We're from this morning's executive session, and I don't believe fellow commissioners have any motions as a result of the session. Is that correct? All right. Is there a motion to adjourn the executive session this morning? Motion by Commissioner Long, second by Commissioner Delco. All in favor say aye.
Aye.
All right. Good morning. We're here today waiting for Margie Castellanos to get our tape recording ready to go.
Because she has to be able to see everybody. She got to have it back to the speakers.
Back to the link.
She will turn around and write her speaking.
All right. Good morning. We're here today on the formal hearing in sworn complaints 312-0487 and 312-0488. The Commission has reviewed the motions filed by each of the parties and will take them under advisement. Specifically, we're carrying those motions. Today we have the opportunity to conduct a formal hearing, and each party has been awarded 4 hours of time to present their case to the Commission. The rules for the time are as follows. Specifically, each side gets a total of 4 hours to use as they'd like. That includes questioning witnesses, cross-examining witnesses, presenting evidence, making opening and closing statements, and arguing evidentiary points throughout the hearing. The following does not count towards the 4 hours. Questioning by commissioners. And once the commissioner's question has been answered, the chair or the commissioner can say that you've answered our question, and then the clock will start again for the next party who starts speaking. We have a couple of timekeepers available with us, and that is only to allow the parties the information of knowing where they are in terms of the time that they have to present their case today. We'll provide time updates at my request, at each break, at the request of either party, at the 2 hour mark, the 1 hour mark, and then once the side has 1 hour remaining, we'll count it down. Our timekeepers this morning are Christina and Marta. Raise your hand, ladies. Okay. And so you can check with them with regard to where we stand. All right. In order to get going this morning, we need to call the roll, so I'd like to ask our Executive Director to call the roll.
Chair Clancy.
Here.
Vice Chair Hobby.
Here.
Commissioner Aiken.
Present.
Commissioner Delco. Commissioner Harrison.
Here.
Commissioner Long.
Here.
Commissioner Ramsey.
Here.
Commissioner Untermeyer. We have a quorum.
All right. At the end of today's hearing, the close of the evidence and the completion of the arguments, the Commission will deliberate, and we'll decide then whether we'll be able to make a decision today or whether we'll need to continue the hearing. We'll also decide whether or not additional relief needs to be awarded to either party or whether the hearing needs to be continued. So, we are ready to proceed with a formal hearing on sworn complaints SC 312-0487 and 0488. Is the respondent present?
Yes, the respondent is present.
All right.
Mr. Chairman, we have a couple of just administrative questions.
Please.
Okay. The first is with regard to the documents. I mean, there are many of the documents that we have stipulated to no objection, but there are some that we do have objections to.
Right.
And how does the chair wish to deal with those objections?
What I'd like to do is, if you have a list of the documents that have been pre-admitted, if you could provide that to me, and then we'll take up the objections as the evidence, if required, is admitted.
We have entered into a stipulation previously. I think and so that numbers are listed in the stipulation.
All right. Can I have a copy of that for our reference?
Yes, sir.
For our understanding, is the chair able to identify which motions it has chosen to carry forward?
All of the pending motions?
Does that include our motion for a more definitive statement?
Yes, sir.
Does it include our motion to exclude the testimony of Mr. President?
Yes, sir.
Okay. We would invoke the rule under Rule 614 of the Texas Rules of Evidence.
Okay. Counsel, you intend to make an opening, right?
I do, yes, sir.
And do you as well, Mr. Nixon?
Yes.
Okay. What I'd like to do is, who is here to testify at today's hearing? Okay. Can I have the witnesses all stand and come forward so I can swear you at one time?
Admonish them not to watch the broadcast.
All right, and we're just going to go left to right. If you would identify your full name, and then I'll swear you all at one time.
Michael Quinn Sullivan.
Mark
Lisheron.
Jesse Hauk.
Jim Keffer.
Robbie Douglas.
Steve Bresnan.
Vicki Truitt.
William Greenhoff.
All right. Ladies and gentlemen, if you raise your right hand, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right. Thank you very much. You all can be seated. At the conclusion of opening, we'll ask you to leave the hearing room as we begin the testimony.
Admonish them not to watch the hearing.
So that we're clear,
Broadcast.
Okay.
Mr. Sullivan is allowed to stay.
Of course.
And then our expert, Mr. Lisheron, would be allowed to stay.
The basis for him being allowed to stay?
He is our expert and needs to be able to digest and understand the other testimony in order to provide this commission his expert testimony.
Counsel, you have a position on Mr. Lisheron remaining?
Well, I think at this point, Mr. Lisheron should be required to wait outside if he's going to be providing an expert opinion in this case. Then we'll need to know what specific evidence he's looked at, and I would assume that he has already looked at some documents, or he's communicated with Mr. Sullivan or other individuals with Empower Texans. And
Do you oppose him attending?
I do.
And Mr. Nixon, do you envision Mr. Lisheron offering fact testimony?
No, he's going to be offering only opinion testimony, and I need him to be able to assist me in the preparation of my defense.
All right. Mr. Lisheron will be able to remain during the hearing.
And so that we're clear, the complainants pursuant to 571-138 are not parties, and the complainants would be required to wait outside as well.
Counsel, your position on the complainants?
Well, they're not a party to the complaints. I have no objection with if they're kept outside.
Counsel, just to make the timing easier for when we start, we'd ask that you address the commission or question witnesses from the podium.
Certainly.
All right. All right, very good. We're prepared to proceed. Staff, you may open.
Yes, sir. Thank you. Mr. Chairman and members of the Commission, for the record, my name is Ian Stusloff. I'm Assistant General Counsel with the Texas Ethics Commission, and I thank you for the opportunity to present this case to you today. I'd like to begin first just by informing the Commission that we do have some visual aids. They are poster boards behind that black. They're currently sealed, and they're a restatement of the law. I would ask the chair if I would be able to open those visual aids and put an aid on display over here in the corner. Thank you. So this chart here is a restatement of the law. It's just a guide for you commissioners regarding what the elements are in this case. And I'd like to begin by saying that this is a case about disclosure. It's about transparency in government, and it's about allowing the public to know who is being paid to exert influence on state officials, who is being paid to influence those public servants who decide the policies of state government and make decisions that affect all of us. This isn't a case about only scorecards. It's not a case about whether any member of the public has the right to petition their government, because certainly under the state and the U.S. Constitution, every citizen does have the right to petition their government. But the issue is that in the state of Texas, there are laws in the government code that require a person to register as a lobbyist with the commission depending on how much they spend or how much they are paid for the purpose of influencing the state legislature. If you receive more than $1,000 in a calendar quarter to lobby, then you have to register. If you lobby the legislature as a part of your regular employment and you are paid more than $1,000 in a calendar quarter by your employer, then you have to register. A person must also register if they're buying things like gifts, awards, meals, transportation, lodging for legislators, and they're spending over $500 in a calendar quarter for those things. That person must also register. Now, in this case, the issue is not about lobby expenditures necessarily. It's about compensation. It's about someone working for a corporation, lobbying the legislature, and being paid to do so. It's not about just a person who feels one day like they want to call their legislator or send them an email and say there's a bill coming up and I urge you to support it or I urge you to oppose it. If they're doing that on their own, that's perfectly fine. They're free to do so. It's only in the case where they're spending certain amounts of money or they're being paid to make those communications that the state law requires them to file a registration with the commission. And what we're talking about, it's a form that identifies who they are, it identifies who their employer is, and it identifies who they're being paid. It doesn't prohibit anyone from lobbying the legislature. These are disclosure requirements. The issue in this case is whether Mr. Sullivan, the respondent, was required to register as a lobbyist based on the compensation that was paid to him by Empower Texans. Now, you will hear from some witnesses regarding the complaints that they filed. That's the reason why we are here today. And they will testify that they had a valid basis for filing those complaints. You will also hear from other witnesses who together provided hundreds of pages of documents to the commission that were received from the offices of state legislators. Those documents will be offered as evidence. You will be able to review them. And one of those witnesses will also be reading certain portions of those documents into the record. It will be clear from those documents that Mr. Sullivan was communicating to legislators or their staff on behalf of his employer in 2010 and 2011, and that the intent behind those communications was clear. They were intended to influence. And again, we're not just talking about scorecards. We're not just talking about a statement that I'm going to grade you on this bill. There are significant statements in the documents that state, we urge you to support this bill. We urge you to oppose this bill. here's a list of our legislative priorities. And by the way, all of these issues, all of these bills, we're going to grade on your scorecard. And then the grades are subsequently provided to the legislators and publicly announced. In those circumstances, when the scorecard is used along with specific exhortations to support or oppose legislation, that is when the scorecards are used to influence, and the documents are going to show that. There are some other documents that or if you look at these records, you will also see that Mr. Sullivan's name and title, and email address, signature, and contact information, and other statements, they are all over these documents. And so it's very clear, and it will be clear from those records that Mr. Sullivan was the source of those documents. Now, lastly, the evidence will show that Empower Texans paid Mr. Sullivan well over $1,000 in each calendar quarter of 2010 and 2011 when these communications were made. Those communications themselves show that Mr. Sullivan sent a large number of them to legislators and staff to influence them, and that it was done as part of his employment. Therefore, he was required to register as a lobbyist. The decision before you today, again, is whether Mr. Sullivan was required to register in 2010 and 2011. In making that determination, you must decide whether, by a preponderance of the evidence, Mr. Sullivan was required to register and failed to do so. Preponderance of the evidence means more likely than not, or 50% plus 1, or 50% plus 01, if you like. Essentially, that it is more likely that Mr. Sullivan was required to register than that he was not in 2010 and 2011. So the questions that you can ask is it more likely than not that Mr. Sullivan communicated directly with legislators or staff with the intent to influence legislation, including the election of the Speaker at the beginning of the 2011 session? Is it more likely than not that those communications were a part of Mr. Sullivan's employment with Empower Texans? And is it more likely than not that Mr. Sullivan was paid more than $1,000 by Empower Texans in a calendar quarter during that time period? Again, the issue is not whether Mr. Sullivan or any other person has the right to contact their legislators. They certainly do. But the Texas legislature has set out relatively benign requirements that people who spend money to lobby the state or who receive payment to lobby the state must publicly register to disclose what they spend on legislators, if anything, and who pays them to lobby. That does not prohibit anyone from petitioning their government, but it only requires transparency so that we all know who is being paid to exert influence over the state's public servants. This is an important interest, and I thank you for allowing me the opportunity to address this commission.
Mr. Nixon.
Mr. Chairman, Commissioners, Council, today is Exoneration Day. Today is the day that Michael Quinn Sullivan is exonerated. The facts and the law are going to set him free from this complaint, either in this tribunal or the next. But today is a day that we are so excited to be able to be here because we publicly get to explain why Mr. Sullivan, nor anyone else who's similarly situated, should be facing these complaints. First, there are 3 reasons why today is Exoneration Day. 1, you're not going to have a single bit of evidence to support the allegations brought in the complaint. This whole fight has been over whether signing a 7,000 signature petition asking legislators to support somebody other than the current speaker for speaker constitutes an act of lobbying. And if you recall, I asked the commission to specifically identify whether signing that petition constituted an act which required Mr. Sullivan and the other 7,000 signatories to pay a fee to the state of Texas of $750 for the privilege of signing that piece of paper. The commission refused that request. I asked the commission to identify the specific act with regard to scorecarding that required Mr. Sullivan to register to lobby. You're going to see Mr. Sullivan's scorecard and others who do not register to lobby. And I want to know what facts there are that support a violation of a specific statute. You're not going to have any. There will be no evidence to support the concept that scorecarding influences legislation for a very key reason. The United States Supreme Court, in the case of Buckley versus Vallejo, considered the term influencing to be unconstitutionally vague. Influencing allows any kind of regulatory body the opportunity for selective prosecution. We're going to consider a complaint against one, but not others, because influencing it's a very vague term. Just a few weeks ago, the Seventh Circuit, in the case of Wisconsin Right to Life versus the Wisconsin Election or Ethics Commission, considered the term influence in the Wisconsin statute. And you know what the Wisconsin Commission did? It acquiesced. It said, you're right. We can't enforce this statute because we agree that influence language in the definition raises the same vagueness and overbreadth concerns that were present in federal law at the time of Buckley. So to begin with, we have a statute that has an unconstitutional term. Influence does not create a bright line. And the interesting thing, any statute which chills speech can and must be invalidated when when you look at the law and it becomes facially invalid, when the law is vague and unclear. And the reason is it's very specific, because the First Amendment requires a heightened degree of regulatory clarity and a close fit between governmental means and its end. And most regulations just don't meet that standard. So, you've got a statute on its face with regard to scorecarding that is unconstitutionally vague. And then finally, Mr. Sullivan, you might hear, but not from any of the witnesses that were sworn in, attends a Wednesday center-right meeting. But you're not going to hear from anybody who was actually there as to what goes on. And so when I asked this commission, because all three of those things are identified in the complaint, what is it specifically that Mr. Sullivan does that requires him to register? This is what I was told. Those were almost my exact words. What specifically did this commission find to constitute lobbying? And I was told, pay the fine and get on down the road. That's what your lawyer said in response. And Mr. Chairman, you said in response, we'll consider it. That's not enough to determine that someone is subject to civil and criminal penalties. So you're not going to have evidence that any conduct constituted any sort of speech that the state of Texas or this commission has the constitutional authority to regulate. Furthermore, you're going to find, and I think it's great that he put this up here, lobby registration requirements, but he didn't put up the exceptions. And on this board that we have here, it says exceptions down at the very bottom. But we have an exception in the Texas statute that says this. The Government Code, Section 305.004(1) says a person who owns, publishes, or is employed by a newspaper, any other published periodical, a radio station, a television station, a wire service, or any other bona fide news medium that in the ordinary course of business disseminates news, letters to the editor, editorial, or other comment. You're exempt from registering. You know what that means, Mr. Aiken? General Electric owns NBC. NBC owns a radio station, a TV station, a newspaper. The Maytag repairman that works for General Electric is exempt from lobbying because he's employed by a person. And Mr. Chairman, we know that a person is who? It's a live entity and a corporate entity. There is an exception. It's not your fault. You didn't draft it. It was written in 1993. Before the internet, Mr. Ramsey. Before Al Gore invented the internet, before I had a computer at home, you had a statute that gave an exemption so broad you could drive a battleship through it. Now let's think about some obvious choices. The Austin American-Statesman, owned by Hearst. Mr. Hobby, your family used to own the Houston Post. My mother used to be a columnist for the Houston Post. The Post had more than just a newspaper. The Austin American-Statesman is owned by Cox. Hearst owns the Chronicle. Belo Corporation owns the Dallas Morning News. And a quick internet look can tell you what all those entities own. Banking interest, real estate interest, assets both here in America and abroad that have nothing to do with media. So, we have a media exception that Mr. Sullivan fits into, but then you're confronted with the very last problem with regard to your media exception. The United States Supreme Court looked at this exact situation in Citizens United, which was a cause of corporate entities being determined as persons in Texas statute. Citizens United prohibited corporations from engaging in political speech so many days before an election. But there was a media exception, because obviously the media has to talk about politics. The Supreme Court considered that problem and held that corporations that don't own media assets are no different than any corporation. Corporations that own no media assets are on equal standing to everybody else. I want to review their words for you right now so that we understand where we are. The media exception, as was written by Justice Kennedy, discloses further difficulties with the law now under consideration. There is no precedent supporting laws that attempt to distinguish between corporations which are deemed to be exempt as media corporations and those which are not. We have consistently rejected the proposition that the institutional press has any constitutional privilege beyond that of other speakers. So here's where they did. the media exception is fine. You want to draw a line in the sand, said these people, because they simply, the federal statute distinguished between people of equal dignity and said we're just going to draw an arbitrary line. And the Supreme Court said the drawing of the line is unconstitutional. You gave an exception to the media. So what happened, Mr. Hobby? Made the rest of the statute unconstitutional. It's okay to give the media an exception. It just invalidates the rest of the Constitution. And why, Mr. Clancy? Because, as the Supreme Court said, we have consistently rejected the proposition that the institutional press has any constitutional privilege beyond that of other speakers. We have a fundamental flaw in the Government Code 305. We have given an exception to the media, and thereby failing to give the exception to everybody else, we've created a constitutional dilemma, meaning that the rest of the statute fails a constitutional challenge. To make the matter worse, Justice Kennedy continued, with the advent of the internet and the decline of print and broadcast media, moreover, the line between media and others who wish to comment on political and social issues becomes far more blurred. So we brought for you today a very well-qualified media expert, someone who has been in journalism all of his life, who has worked for newspapers for the majority of his life, who was involved in a national media. He's a deputy editor, the number 2 man in the national media, Mark Lisharon, award-winning writer, both a critic and scholar of journalism, who is going to tell you what new media looks like today and why bona fide media and why Empower Texans is bona fide media. So here's where we are. One, you don't have any evidence to support any conduct which can be regulated by the state of Texas. Two, Mr. Sullivan indisputably fits into the media exception. And we know that in part. I mean, this commission asked for and tried to subpoena at one point his blog postings, his editorials, and news stories, thereby admitting that the guy disseminates news and writes editorial content. And three, you have a statute which is clearly unconstitutional in the exact same manner of the federal statute which prohibited corporate speech for the exact same reasons. Dead solid on. So here's where we are. It's our exoneration day. And we're very happy to be here. Glad that this day finally has come. But at the end of today, whether through you or through another form, Mr. Sullivan will be exonerated.
Thank you, sir.
We would ask that the rule be invoked.
Yeah. At this time, I'd admonish the witnesses that while this hearing is broadcast for the benefits of members of the public, you not review any broadcast or any information regarding that broadcast until after you're excused from your subpoena and your testimony in today's hearing. So those witnesses who are going to offer testimony today, I'd ask that you leave the hearing room at this time. And I'd ask staff to call their first witness.
We call State Representative James Keffer.
Where do you want me to get?
You're going to have the seat at the end of the dais, our witness chair.
Be very careful of this.
There's a little red button underneath the chair, underneath the table, that will empower your microphone. Under the Government Code, Section 571.130C, each witness has the opportunity to give a brief statement prior to the questioning being made. Is that microphone on from Representative Keffer? All right. Sir, do you wish to give a brief statement?
No, thank you.
All right. Counsel, you may proceed.
Thank you, Mr. Chairman. Representative Keffer, I'm going to, for the record, the exhibit number 2 has already been stipulated to as admissible. And Mr. Representative Keffer, if you could please turn to, in the large book before you,
Okay.
if you could turn to tab number 2, please.
Yes, sir.
Are you there?
Yes, sir.
Do you recognize that document? And please feel free to take a moment to review that.
Yes, I recognize it.
And what is that document?
It is the complaint to the Ethics Commission.
Okay. And just so I want to kind of start from the beginning. For the record, could you please state your full name?
James Lloyd Keffer.
And what is your current occupation? I missed a few introductory questions,
Okay.
so let me just start there, please.
Okay. My governmental or...
Both, personal, professional.
Well, I'm state representative for District 60, and also I'm president of Eva Iron Sales and Iron Foundry in Eastland, Texas,
Okay. And how long have you been state representative?
since 1997.
Okay. And you are a complainant in this case, is that correct?
Yes.
This document before you, is that the complaint that you filed?
Yes.
How did you prepare that complaint? Or what was your involvement with filing
involvement?
that complaint? Yes, sir.
The involvement, this complaint was brought to me, the evidence or the complaint was brought to me, and I was asked to look at it and to see if I felt that what had been collected over a period of time by Steve Bresden, if that was thought, if I thought that it would be something I would want to be involved in to go forward and have a complaint or file this complaint, and I did.
Okay. So somebody else gave you the documents that
Right.
were used as the basis for the complaint?
Right.
Okay. And was that Steve Bresnan?
Yes.
Okay. Did any other person assist you other than Mr. Bresnan in filing that complaint?
Brian Epstein.
Okay.
He's my-
And what was his involvement?
He actually worked with Steve Bresden on some of this information, and he's the one that brought Steve and myself together
Okay.
for a meeting.
But when you filed the complaint, you completed an affidavit. It's on the very last page of that complaint. Is that correct?
Okay, what page?
It's at the very last. If you turn to the very last page, sir, page 74, you'll see it at the bottom.
Yes. Yes, I signed it.
So the bottom half of that page, is that your name?
Yes,
And is that your signature beneath your name?
it is.
Okay. So you completed that affidavit, and that's correct?
That's correct.
And did you file that complaint once it was completed with the commission?
Yes, I did.
Okay. Now that affidavit, it states that and I'm reading from it in the paragraph, it says that the source of my information and belief is the documentation attached. Is that correct?
Yes.
So what was the basis for the allegations that you made in that complaint?
Well, the basis of the allegation, listening to the opening statements, but the basis of the allegation, in my thought, was that influence was being garnered or generated to elected officials or staff, and by mail, by conversation by phone, by whatever, and that there was enough information that had been collected from other offices to show that certainly in what I feel lobbying or trying to influence outcome of policy, not election, but policy, and that the law, as I understand it, is if you're going to do that, that you sign up as a lobbyist. You actually follow the regulations or rules and sign up as a lobbyist, which Mr. Sullivan had not done. So that gave a basis to, if you're going to do this, that you follow the rules and regulations set out by the state.
Okay. So as a state representative, do you encounter many lobbyists at the Capitol?
Yes, I do.
Do some of them contact you in person?
Yes, they do.
Do some of them contact you by telephone?
Yes, they do.
Do some of them contact you by writing?
Yes, they do. Those that can write.
Does that include email?
Yes.
Is it at all unusual for a lobbyist to contact legislators in writing rather than stopping by their office or calling them on the phone?
Is it usual?
Is it unusual?
Is it unusual? No, it's not unusual.
Now, you were a representative at the beginning of the 2011 legislative session, correct?
I was.
And at the beginning of the session, how was the Speaker of the House elected during the legislative session?
By the members of the House.
Okay. Is that done by a vote?
Yes.
That's done on the floor of the House?
The very first vote of each session is the Speaker election.
So that's a decision that's ultimately up to the members of the House to make?
Right.
Okay. I pass the witness.
Mr. Nixon?
Take your time. Good morning, Mr. Keffer. How are you?
Good morning, Mr. Nixon. Just fine. How are you?
Good to see you again.
Likewise.
All right. All right, so let's make sure we understand where we are. You didn't do the research to obtain the documents.
You're right.
That was done by
Steve Bresnan and Brian Epstein.
who is Brian Epstein?
He's a political consultant.
You're a political consultant?
Yes.
Now,
But the majority of the work was done by Steve.
okay. My understanding is that you didn't even write the complaint.
That's right.
Is that true?
That's right.
The handwritten portions of the complaint were all filled in by who?
Steve Bresnan.
And the only thing you signed was the last page.
That's right.
Okay. Now, did you check his work?
We did.
Good. Did you authorize the research to begin with?
No, I did not.
Do you know who did?
No, sir.
They just came to you with a finished complaint?
Pretty much.
Okay. Now, a minute ago you said the words, you thought Mr. Sullivan was exercising influence by generating mail, conversations, and phone calls. Did I hear you correctly?
Sure. Yes, you did.
Can you turn to your complaint? Exhibit 2. Is there an allegation in your complaint that Mr. Sullivan had a conversation or a phone call with a single member of the Texas House of Representatives?
Through it.
Take your time. Like the clock to stop, Mr. Chairman, while the witness reads his complaint.
That's going to be denied.
Well, on page 5, Joe, the evidence supplied below shows that Michael Sullivan sought to influence the legislation on behalf of his employer, Empower Texans, DBA Texans for fiscal responsibility, by communicating directly with members and staff of the Texas legislature during the last quarter of 2010 and during the 2011 sessions of the Texas legislature.
Did you reference a single conversation?
Well, there's
Did
It is?
you reference a single conversation?
No.
Did you reference a single phone call? Did you engage a lawyer to review the complaint to see that it was facially correct?
I do have, yes, I do.
Who?
I object. I think that information would be privileged.
The witness can
What's
testify.
what's the objection?
With an attorney, if he had consulted an attorney.
Okay, that's sustained.
He can testify as to whether or not he did engage a lawyer and who he was. I did not ask for advice.
Ask your question again.
Who was the lawyer that you engaged?
Ross, my mind just went blank. I'm sorry, Ross.
At the time you filed the complaint?
No, at a later date.
All right, let me ask my question again. At the time you filed the
No, I
complaint?
did not.
All right, so what the record is perfectly clear. At the time you filed the complaint, you did not engage a lawyer to review the complaint to see if it was legally or factually correct.
You're right.
Did you consider any of the exceptions that are in the election, in the 305 of the government code?
No, at that time, there was no conversation about being of the press.
Okay. You didn't consider that.
That's come out later.
All right. So we're all clear, and the public knows this, the complaint was filed on information and belief,
Yes.
not on personal knowledge. You didn't swear to it that this is based on your personal knowledge to be true and correct, like you would an affidavit.
Well, it was based on what I know goes on in the legislature.
Well, look, turn to the signature page. Let's talk about that.
The signature page?
To the last page of your complaint. It'll be the last page of Exhibit 2.
Okay. $74.
What's that?
74.
All right. It's signed under, I don't need to look at it because I've read it. Signed under information and belief, right? You had an opportunity to sign it under your own personal knowledge, but you did not.
Right.
You crossed out the section that said personal knowledge.
Right.
And you signed it only on information and belief.
Okay. Yes.
What is information and belief?
That I
A
believe
rumor.
that the information that was brought to me after we looked at it and my knowledge of what goes on in the legislature, I felt that was enough to go forward.
Information and belief is
Information
nothing
and
other
belief.
than a rumor, right?
Information and belief. I don't know. You're the
Hearsay.
attorney.
It's a rumor. All right, now, let's get to the heart of this. Let's look at the first exhibit to your complaint.
Which is,
It's a letter. You see it? Letter dated November 4th, 2010.
I'm sorry, what tab?
It is the first exhibit to your complaint. So it should be under Exhibit 2 still.
Counsel, for the benefit of the commission, would you give us the page number from the exhibit book?
Be page 14 under tab 2.
That's the one that has the label 14 on it?
No, it is fate stamped 00014 under Exhibit 2.
Okay.
November 4th to 2010?
Yes. You see that?
Yes, I do.
You attached that to your complaint, right? And you wanted the commission to utilize that letter in its decision-making. Is that correct?
Yes.
How many signatures are on that letter of November 4th, 2010?
There is 5 signatures.
In one that's electronically signed.
Right.
And that letter says, a change to a more conservative speaker is in order, right?
Right.
Do you consider that to be lobbying you?
I think, yes.
Now, we understand this letter wasn't addressed to you.
No, all the members.
Yes, all the members. In fact, as I go through your complaint, there's not a single piece of paper, email, web page, anything addressed to you.
Counselor, can I interrupt you for a second? We're trying to find this exhibit here on the commission. It appears that it's labeled page 88 as Exhibit 1, 2.
No.
Is that not it?
Clock can stop, I'll show
It's
it.
right here. It is number 14.
Okay,
Tab 2,
14, 0014
Zero, yeah.
in Exhibit 2. Very good. Thank you.
Sure. Okay. Did you do anything to ensure that that was a complete letter?
Complete letter?
Yes.
What does that mean?
Well, let me hand you what's been marked. And Mr. Chairman, I'd offer exhibits 110, 111, and 112 pursuant to our stipulation into evidence now.
Those
No
pre-admitted,
objection.
correct?
Yes, sir.
Okay. They're admitted.
Do you have, let me see do you have the other notebook? No?
It's a smaller one.
Not this. These aren't. You have one for the room, small one for the room.
That includes 110.
Oh, okay. We need 11 and 110. Okay, Mr. Cuffer. Let's look at Exhibit 110. Excuse me, 111. 111. In comparing Exhibit 111 to your Exhibit 1 to your complaint, is the exhibit attached to your complaint a true and correct copy of the letter that was received by members?
It has these other 2 pages with more signatures.
This has 42 more signatures, 3 more pages of people who signed that letter. You would agree with me that the exhibit attached to your complaint is incomplete.
It does not have the other pages.
Based on information and belief, are there any other exhibits attached to your complaint which are incomplete?
Well, I would not know.
Because you didn't ever go back and look. Is that right?
We have the crux of the letter here and not all the signatures that we felt was in the need.
Mr. Keffer, are you asking the commission to assess a fine and hold someone in violation of a statute of the state based upon incomplete research?
I think the research is complete, showing what the crux of the issue is, I feel.
Well, do you consider a letter,
And some of these actually are lobbyists.
do you consider a letter signed by 48 people to be a lobby letter?
Yeah,
You do?
I do.
Okay. Let's go to Exhibit 112. Oh, by the way, did you file a complaint against any other signatories in the letter?
Did not.
Okay. Let's go to Exhibit 112. I note that this letter was not attached to your complaint. Exhibit 112 was not attached to your complaint at all. Have you seen Exhibit 112?
No.
112 is a letter identical in wording to the exhibit you attached, identical to the wording of the complete letter signed by the 48 signatories. But this one's signed electronically by 7,000 citizens of the state of Texas. Do you consider Exhibit 112 to be a lobby letter?
Well, I'm certain that, they are, these letters or any other letters like this are written to influence, yes.
You note that there are probably a dozen members of House District 60. You represent House District 60. There are about a dozen voters on House District 60 of the 7,000 that signed this letter. Did you file a complaint against any of the voters in House District 60?
I'm sure that these are not getting paid to do it. It is their
Well,
right to.
have you done any
to
research?
converse.
Have you ever done research?
Not on every one, no.
No.
They were
Have you
not
done
the-
it-
They were not at the point of the complaint.
Did you do any research as to any other signator on any of the letters that we've talked
I
about?
did not.
So let's get to the heart of this. What is really Exhibit 1 attached to your complaint?
What is?
Yeah,
What is it? What do you mean, the letter?
it's a letter saying we want a new speaker, right?
Right.
Now, you're a chairman in the House, right? Appointed by who?
The speaker.
And your political consultant, it wasn't your idea, but your political consultant has come to you and says, here's a complaint we want you to file.
We want you to look at, yeah, the file, yeah.
And you signed it on a rumor. So, let's get right to it. Mr. Keffer, you filed a complaint that you didn't research, either factually or legally, of which you have no personal knowledge, based on a belief that Sullivan was lobbying other people.
I believe that is true.
Not you, other people.
He knew not to lobby me.
You ever been to the Empower Texans website?
Maybe once or twice.
Pass the witness.
Before you continue, Counselor, any questions by commissioners for this particular witness? Go ahead, Counselor.
Representative Keffer, when you filed the complaint and you only included those first couple of pages from Exhibit 1 in your complaint, what was your reason for just including those particular pages?
Well, because the letter was the letter, and really, the resident signatures where they all have a right to sign, and that's fine. Like you said, we're not here to shut off anybody's right to communicate with their elected officials, but the letter was the crux of the issue, so that's why it was only, that part of it was the only attached to the complaint.
Now, are you required to file a complaint against any person if you think that they may be lobbying? Is there anything that requires you to do that?
Of course not.
Is there anything that requires you to look through Chapter 305 of the Government Code and Chapter 34 of the Ethics Commission's rules to review every exception under the law to see if a respondent meets all of those exceptions?
No.
Now, Mr. Nixon has said that you filed a complaint based on a rumor, but is that an accurate statement that you filed the complaint based on a rumor, or was it based on information and belief?
Well, it's information and belief.
I have no further questions.
Nothing further.
Next witness.
Okay. Mr. Clance,
Yes, Mr. Chairman.
The witness is excused.
Thank you, sir.
thank you all very much.
Thank you, Judge.
Appreciate it. Talk to you, Joe.
I call Ms. Vicki Truitt.
One of the members of the commission staff put their head in the hallway, let Mr. Truitt know it's time.
Is Homer here?
Good morning, ma'am. Take a seat at the end of the day. That's where we're having our witnesses testify from.
I did not prepare an opening statement.
Good morning, Ms. Truitt.
Good morning.
Could you state your name for the record, please?
Vicki Truitt.
And what is your current occupation?
I'm a lobbyist.
Did you once hold a public office?
I did.
And what was that office?
Between the years 1999 and 2012, I was the state representative for the people of the 98th Texas House District.
Okay. And you are one of the complaints in this proceeding, is that correct?
I am.
I have before you in your notebook, there's a large notebook behind tab number 3, and I would offer that exhibit number 3 to be admitted into evidence as per our agreement with the respondent's attorneys.
That would that be 103?
No, ma'am, 3.
Oh, 3
in the
this?
large notebook.
Counsel, all the evidence that's been pre-admitted is already there.
Okay. I just want to, okay, thank you, sir. Do you recognize this document?
I do.
And what is that document?
It's the complaint that, and on the second page, on page 076, that's my handwriting.
So you filed this complaint?
Yes.
Did you prepare that complaint?
Not completely, no, sir.
So how did you compare it, or how did you prepare that complaint?
I read it and signed it and had it prepared to admit, and some of the documents within it were provided either by me personally or by my legislative office.
So did you personally obtain any of those documents that were included in the exhibit from your office, or were they given to you by somebody else?
There was an open records request through which some of them were submitted, and at least one of the documents I submitted on my own. That it was something that was mailed out in the district.
Okay. So is there another person who assisted you with filing that complaint?
Yes.
And who was that?
Well, if I could back up to the genesis of the complaint, I was really shocked to learn that Mr. Sullivan was not a registered lobbyist based on my experience in the Texas legislature, and was told by my campaign consultant that some information was being put together to prove that there had been lobbying, and would I be interested in being a party to a complaint. And I agreed that I would. As I said, I was shocked to learn that he wasn't registered.
If you could please turn to the very last page behind tab number 3. That's marked at the bottom with a somewhat fuzzy 148. Can you turn to that page, please?
Yes, sir.
What is at the bottom of that page?
Notary and my affidavit.
So you signed that affidavit?
That is my signature, yes.
Okay. And you stated in that affidavit that the source of your information and belief was the documentation attached?
Yes, sir.
Okay. So I'm going to show you an exhibit number 39. And these documents are located, commissioners, in your notebook behind tab number 39. I have the originals here.
We have objected to those exhibits. That we've not agreed that those are to be admitted. So before we show the witness or discuss them, I'd like to re-urge our objection based upon both relevance and hearsay.
Well, I'd like at least an opportunity to ask Ms. Truitt if she knows what the documents are, if she recognizes them.
Go through the approval.
Ms. Truitt, do you recognize those documents?
I do.
What are they?
The top document is a letter dated January 24th, 2012, from William R. Greenhaw to my legislative office, an open records request.
Does that appear to be your the letterhead from
That is
from
the
your
letterhead
office?
from my legislative office, and that is my original signature.
Okay. Was it your office's normal practice to?
It was. I'm sorry. This was not from Greenhaw. It was to Greenhaw in response to his open records request. I apologize.
Okay, it was from your office
Correct.
responding to a letter from Mr. Greenhaw.
Yes, sir.
Was it your office's normal practice to produce this kind of a letter when responding to an open records request?
Yes, sir.
Was it your normal practice to include all of the documentation responsive to an open records request?
Yes, sir.
When they were sent back to the requester?
Yes, sir.
Okay. Can you turn to the next page, please, number 733?
Mm-hmm.
Do you recognize that document?
That is the letter from Mr. Greenhaw, with the open records request from Mr. Greenhaw.
And the notation at the upper right corner of that page, what does that say?
That was the date it was received in my legislative office, and I believe that's the handwriting of my former chief of staff.
Okay, former chief of staff.
The date received, yes, sir.
At the time. And who was your chief of staff at the time?
Tara Taylor.
Okay. So is she the person who would have prepared these documents?
Yes, sir.
And is she the person who would have compiled them and sent them to the requester?
Correct.
So the additional documents that are included with this exhibit, do you recognize those?
Yes, sir.
Mr. Chairman, I would reurge the objection. I think that the witness has now helped us.
I'm sorry?
I think the witness has now absolutely stated that her chief of staff is the custodian of records. They were compiled and kept by her. We do not have a business records affidavit. These aren't government records. This is these documents are absolutely all hearsay.
What?
Just so everyone understands, you guys can make as many objections and speaking objections as you wish, but the time is going to run for the period of those objections.
I understand.
All right. So we're going to admit Exhibit 39, and the commission will afford it a weight that is.
So my question again, Ms. Truitt, do you recognize what these additional documents are?
I do. One is a letter dated to me, dated June 29th, 2011, to me as a state representative, addressed to my state office here at the Capitol.
Is that page number 734 at the
Page
bottom?
number 734. It's
Okay.
signed by Michael Quinn Sullivan. So correspondence to me.
Okay. And what is that correspondence? Can you generally state what that correspondence is, what it's stating?
It advises that the organization Texans for Fiscal Responsibility will be preparing a scorecard, or prepared a scorecard, and based on my votes, my rating for the 2011 Fiscal Responsibility Index for the 82nd Legislative Session was a C.
Okay. And do you recall receiving that document?
I do.
Do you believe that that document was sent to make any sort of impression on you?
Yes, sir.
Okay. Can you please turn to page number 737?
Yes, sir.
And do you recognize that document?
I do.
And what is that document?
It is a letter dated May 6, 2011, from Michael Quinn Sullivan as president of Texans for Fiscal Responsibility, thanking me for my service and to inform me of the draft of their 2011 Fiscal Responsibility Index that they wouldn't be releasing until after the legislative session.
Okay. And can you refer to, can you turn to page 738?
Yes, sir.
And do you recognize that document?
I do.
What is that document?
It was the draft for my rating of with the Fiscal Responsibility Index.
Okay. And what is do you know what this list of items underneath the column, the heading vote?
Those are votes upon which they based their scoring.
Okay, and there are two columns there to the right of that, is that right?
Yes, sir.
And one column says our position, the other says your position. Okay.
Correct.
Now, can you turn to page 739?
Mm-hmm.
Do you recognize that document?
I do.
What is that document?
That is a document that was not submitted through the open records request. It was a document that I offered up. It was a letter or a memo, a legislative memorandum to the taxpayers of House District 98 from Michael Quinn Sullivan. The letterhead says Tim Dunn and Michael Quinn Sullivan, telling the taxpayers of House District 98, which is the district I represented, that I was not a good representative.
Okay. So you provided this document
by their standards. I'm sorry.
So you provided this document for purposes of the complaint.
I did.
Is that right? Okay. Now, can you turn to page 741 and 742?
Yes, sir.
Do you recognize those documents?
Yes, sir.
And what is that?
It's a letter dated December 2010 from Texans for Fiscal Responsibility, signed by Michael Quinn Sullivan. The letterhead says Tim Dunn and Michael Quinn Sullivan, thanking me for my service, sharing he wanted to share their organization's priorities and interests, and sharing that they will be scoring me on the Fiscal Responsibility Index based on how I voted according to their desires.
Okay.
And discouraged me from voting against the Speaker of the House, and indicating that would be a substantial piece of their scoring component.
And so at the very first paragraph of that letter on page 741, can you read that first full paragraph?
Yes, sir. The first, beyond the thank you for your service.
Yes, ma'am.
As you know, Empower Texans / Texans for Fiscal Responsibility is a nonprofit, nonpartisan organization through which tens of thousands of voters from around the state work with and through to advance free market solutions, transparency, responsible government, and low taxes for the empowerment of all Texans.
But this document was addressed and sent to your office, is that correct?
To my legislative office here at the Capitol.
And so the very next sentence, can you read, that begins with the word with, can you read that sentence, please?
With the start of the 82nd session of the Texas Legislature, I wanted to share with you our organization's priorities and interests.
And there's a list of bullet points there, is that correct?
Yes, sir.
What's the first bullet point?
Balance the budget without increasing taxes or creating new revenue sources.
And what's the second bullet point?
Oppose the creation of new taxes, granting of additional taxing authority, or creating any new taxing entities.
And what's the third bullet point?
Strengthen the constitutional expenditure limit, such as by requiring that the legislature choose the lower of the change in the sum of population plus inflation or the current measure.
Okay, so there's a lengthy list of certain policies. Is that correct?
Yes. Mm-hmm.
And
policies and a reference to a particular bill.
Okay. And the very last sentence that says, as we have done, can you read that paragraph?
As we have done in the past, scores on the Fiscal Responsibility Index will be based on the votes related to these issues. We will calculate individual member scores only on the votes actually taken, including any clarifying statements in the journal. Sponsoring, co-sponsoring targeted legislation is likewise included in the scoring.
Can you restate that the full sentence, please? Sponsoring and co-sponsoring.
Sponsoring and co-sponsoring targeted legislation is likewise included in the scoring.
And can you read the next paragraph, please?
We will make every attempt during the legislative session to notify your office of the specific votes and legislation we will be scoring. Those will also be noted on our website.
Okay. And the sentence in bold, can you also read that?
Given the important role of the Speaker of the House in determining committee assignments and chairmanships, and thereby affecting the flow of legislation, the vote on the speakership may be included in the index.
Okay. And that page has the signature and name of Michael Quinn Sullivan?
Correct.
So this document, it didn't just tell you that they were going to issue a scorecard, is that right?
Correct.
In fact, doesn't it include a list of what it refers to as priorities and interests?
Yes, sir.
Objection leading. I've been letting the council lead, but I mean, we need to elicit testimony from the witness and not counsel at this time.
Sustained.
So, Ms. Truitt, you were in the legislature in 2010 and 2011, is that
Yes,
correct? Sir. Did you ever sign up to receive any correspondence from Mr. Sullivan or Empower Texans?
No, sir.
So you never asked them to send anything to you?
No, sir.
Never asked them to send any notices of this sort to you?
No, sir.
Now, you're currently registered as a lobbyist?
I am.
When you're contacting a legislator on behalf of a client, do you contact them in person?
Oftentimes, sometimes by email.
Sometimes in writing, by mail?
In writing, in email, in person, on the phone.
But it's not uncommon to send out multiple letters to various legislators on behalf of a client. Is that correct?
Not.
Okay. Is it unusual for a lobbyist to send multiple letters or multiple copies of letters to legislators on behalf of a client?
No, sir.
Objection.
Sustained. Let the witness testify, counsel.
Okay. I have nothing further. I pass the witness.
I've especially
There's no question before the witness at this time.
That's correct. Thank you.
Ms. Truitt, have you ever been to the Empower Texans website?
I have.
Did I hear you correctly in answer to questions say that you saw the questions that were going to be asked of you ahead of your testimony today?
That I saw the questions. I'm sorry, would you say it again?
Yeah, I'm not sure that I heard it correct, but I always want to make sure I did, and I may not have. Did you see questions that Mr. Strusloff was going to ask you?
No.
Okay. All right. I just want to, I didn't think I heard that right, but I just wanted to make sure. Okay, so in looking at your exhibits, you got a letter in May saying you're going to get a grade, and this is what we think your grade is going to be, right?
Yes.
Did it tell you how to vote on any piece of legislation?
The pieces that came to our desks and via email to our offices did.
I didn't ask that question. I asked you if the letter that is attached to the exhibit that you talked with counsel about in May.
I believe it did.
All right, well, let's turn to it. That would be 737. Can you identify for me the pending piece of legislation before the Texas House that 737 suggested that you vote for or against?
Well, the votes were on 738.
No, I didn't ask for votes that you already cast. 738 contains votes you've already cast, right?
Correct.
I'm talking about the current pending piece of
Well,
legislation.
that was the end of session. This is after the
Oh, so when we get down to influencing legislation, this was after it had an opportunity to influence any legislation.
there were contacts throughout the legislative session prior to every vote being taken. We would get communications directing us how to vote.
I object to the non-responsiveness of the answer and ask that the answer be struck and that the witness be instructed to answer the question that's been asked. Ms. Truitt, did you not understand my question?
I guess not.
Okay. I'm asking you, with regard to the exhibit that the Ethics Commission has wanted to put in this big, thick notebook, what is the pending piece of legislation that the letter of May 6, 2011 was designed to influence?
That particular letter was regarding votes that had already been taken.
Well, my point is that there's no pending piece of legislation that it asked you to vote for or against, right?
There were many occasions when I was contacted before the vote.
This letter doesn't say vote for or against a pending piece of legislation, does it?
It says, while the session is not complete and there will be many votes ahead, I wanted you to both be aware of what we are currently scoring and where that places your rating. And the message to me was that, okay, here we are. You've got a little bit of time left. You'd better be doing what we tell you to do.
Or what happens?
Or I get worse than a C, I guess.
So what is the name of the bill that was pending that they told you how to vote on?
It is not referenced in this particular letter.
Oh, okay. It's not referenced. Okay. And so let's go to 734, the first letter you discussed. That's dated what?
It thanked me for my service.
What's the date?
June the 29th.
Was the legislature in session at that time?
I don't believe so.
No, it's after session, right? So there's nothing pending before the legislature. And of course, they gave you a C, right? You didn't like that. Now, the last thing that you dug out and attached was a memo to your constituents, right?
Correct?
Okay, so is the memo to your constituents communication to you to influence legislation?
No.
Okay. So that's what's attached to Exhibit 39. I note, too, and if you go look at your complaint, and I think it's Exhibit 3, there's not a single piece of paper attached to your complaint addressed to you, is there?
I have to go back through and look. There, yes, I believe there absolutely there were some things from my office. Yes.
Okay. Well, we're going to have an opportunity to go through Exhibit 3. In just a sec when we get to it, so we can clarify that. Now, one of the things we know is that you have a relationship with a Mr. Epstein, don't you?
No longer.
But you did.
I did.
And at the time you filed the complaint, you did.
I did.
And it was Mr. Epstein. What is that relationship?
He was my political consultant.
Did he advise you to file this complaint?
He did not advise me.
Did he recommend it to you?
He asked me if I would be interested.
Yes. And what did you tell your political consultant?
I was frankly shocked that Mr. Sullivan was not registered to lobby, given the extent of communication that was taking place with members of the legislature, and that I would be interested in being a party to that.
Okay, so we saw the extent that is attached in Exhibit 39, which relates to you. But Mr. Epstein was doing something else for you at that time, right? He was advising you in a
political consultant.
Right, you were in a race, were you not?
I object. Is Mr. Nixon testifying, or is he asking questions of Ms. Truitt?
I get the lead.
Your objection is what?
I retracted.
You had a political race going on at the time you filed the complaint, did you not?
I did.
Yeah, and then you turned right around and made public the fact that you filed a complaint.
I did not.
You did not? Turn to, in a smaller notebook, Exhibit 110. Commissioners, 110 is a mail piece sent out by Ms. Truitt. You see Exhibit 10?
I do.
Okay, it's already been admitted into evidence. If you could turn to the page that looks like this.
Got it.
This page.
So that did make reference to the ethics complaint.
Oh,
And
okay.
it was my flyer.
Will you read aloud the sentence, the first sentence under the paragraph, pulling the curtain back on the victim's opponent, on Vicky's opponent?
Formal ethics complaints have been filed against a special interest PAC, Empower Texans, from Midland, Texas, and their special interest lobbyist for funding the false attacks against our state representative, Vicky Truitt.
Okay, the special interest lobbyist is who?
That would have been Mr.
And the ethics complaints were filed by who?
I, myself, and Representative Keffer.
Okay, so when you said you didn't turn around and make them public, you did.
Well, via the campaign.
Sure. Okay, and here's what you said. Formal complaints have been filed against Empower Texans and Michael Sullivan for funding the false attack ads, or false attacks against our state representative. But the complaint alleges that Mr. Sullivan is an unregistered lobbyist. The complaint doesn't allege that he's funding false attack ads.
Mr. Sullivan issued directives to members of the Texas legislature received by me mostly through unsolicited emails and written material addressed and provided to House members in the chamber prior to key votes.
Ms.
He
Truitt,
directly contacted myself and other members of the legislature and recommended how we should vote on specific legislation.
Objection, non-responsive. Ms. Truitt,
Sir.
did you allege in your complaint that Mr. Sullivan was funding false attacks against you?
I don't recall. I'd have to read the
He did.
complaint.
Your complaint doesn't allege that against him, does it?
What does that have to do with anything?
Well, your statement saying that ethics complaints were filed against Mr. Sullivan for funding false attacks ads is itself false, right?
I think that's a play on words.
They're your words. Now, as a candidate, you approve every mail piece that goes out, right?
I looked at them.
You approve these words?
I don't recall.
You proud of this mail piece? You glad you sent it?
I don't have a problem with it.
All right, good. Don't have a problem with it. Okay, so let's take a look at Ms. Truitt, we've had an opportunity to go back and look at Exhibit 3 in detail. There's not a single document from your office attached to your own complaint. And I would ask that the Ethics Commission take notice of the fact of what is and is not in her complaint. Now, Ms. Truitt, I'm going to hand you, a resolution adopted by the Texas Ethics Commission. This is issued December 3rd, 2013. Would you like to read it?
I object. I don't see how this is relevant.
This is your own document, and I'm laying the predicate for a question.
How is a commission action in 2013 relevant to 2011?
Well, if we go over the resolution, it'll be patently obvious. I get 4 hours. I can use it any way I want.
The objection is sustained, but you can continue to ask your questions.
All right. So let's go over this resolution then. I won't have you read it. It says the Ethics Commission unanimously condemns the use of misleading campaign communications regarding the activities of the Commission. Do you see that? You see where it says the use of statements. A sworn complaint has been filed against candidate A.
I'm sorry, I don't know where this is going. Mr. Nixon's
He
just
does not
reading
know
a
where this
statement
is
into the
going, but
record.
I do.
He's just reading a statement into the record, and
Counsel, what's your objection?
well, the objection is I don't see why he's reading the statement into the record, and it's not relevant.
I'm asking questions that are extraordinarily relevant to this.
I mean, he's reading a
The
statement.
relevance objection is sustained. You may continue your cross-examination.
All right. Sure. Thank you. Do you see where the Ethics Commission has condemned the use of the statements, a sworn complaint has been filed against candidate A, where the Texas Ethics Commission is investigating a complaint against candidate A? They condemned it after you sent out this mail piece. So, Ms. Truitt, as we stand here today, the only person whose actions have been condemned by the Ethics Commission are yours. Is that right? In this room, the only persons whose words have been condemned by the Ethics Commission by resolution are yours.
I object. The commission has not specifically addressed this particular flyer. They haven't made a statement regarding her flyer.
What's the objection to that question?
Well, the objection is he's making an inference that the commission has objected to
But he's
statements that made
cross-examining
issues
this
made in the
witness. I mean, he could make all sorts of false statements. We're not going to rule on the truth or falsity of his cross-examination. What's your objection to his question?
flyer. Well, that was my objection, sir.
That it was a false statement?
Well, that he's making false statements and inferring that the commission has condemned her
Overruled.
statement.
Now, let's just do a last few things. Like Mr. Keffer, your complaint is filed under information and belief, right?
Yes, sir.
Rumor.
No, sir.
Okay. You had the option to file under personal knowledge, but you didn't.
I did not.
Okay. With regard to Exhibit 39, you didn't attach any of those documents to your complaint, did you?
Exhibit 39. In the big book?
Yes, in the big book.
Exhibit 39, yes. It came from the top sheet. Came from my office. The 732 came from my office. 733 came from my office. 734 came from my office. 735, 736.
I maybe didn't answer the question. All of Exhibit 39 came from your office, right?
Correct.
But none of Exhibit 39 is attached to your complaint, correct?
I would have to go back and look.
We've looked. It isn't. Why wasn't the documents sent to your own
I
office
don't.
attached?
I would have to talk to my counselor about that. I'm hesitant to take your word for it.
Speaking of that, did you hire a lawyer to review your complaint when you filed it?
No.
Did you look at the lobby statute when you filed it?
I may have read part of it. It's been a good while back.
Did you read any of the exceptions?
Not that I recall.
Did you read any Supreme Court case law?
No, sir.
Do you know whether the documents attached to your complaint, which are identical to Mr. Keffer's, are complete?
I'm not certain.
Okay. House of Witness.
Council, we're going to take a 10-minute recess for our morning break, and we'll be back in 10 minutes. Session on formal hearing. Counsel for the respondent has completed his questioning on cross, and I need to ask my fellow commissioners if they have any questions. Mr. Nixon, do you have something?
Couple
interim?
of quick administrative issues, real quick.
Sure.
First, we're not certain if the witnesses that you put under the rule understand that they're not to watch the proceedings on the internet.
That's what I said.
Okay, just want to make it, because there was some information during the break that somebody might have, and I just want to make sure that didn't happen.
Those were my instructions.
Okay, secondly, I need to ensure that the witness had not been reading in their testimony from any kind of prepared statement or any kind of notes. Did you have any statements or notes that you were reading from?
You can ask that on recross.
Okay. And finally, and while this is, I understand how committee issues work, howsoever, this hearing is very, very important to our client. And I note that at a couple of times that commissioners have had to leave or excuse themselves. We don't mind taking a break at any time, but we would request, particularly during cross-examination, that the commissioners stay and hear the entirety of the evidence.
I'll just note that the microphones work back there, so you can't get away from it. You're hearing every word, even if you're back there for a second.
Well, as a lawyer, you know, Mr. Hobby, that jurors need to see witnesses, their expressions, and take into the entirety of the circumstances in their deliberation.
Counsel, your objections noted. We'll take more frequent breaks to accommodate commissioners. And staff and counsel, I'd ask that you, to the extent that you're going to address commissioners, please refer to them as commissioner. That'd be helpful and appropriate for this forum.
Yes, sir.
All right. I'm going to ask commissioners if they have any questions for Representative Truitt. I have a couple. Would you turn to Exhibit 39? Specifically, I want to turn to what's been page 734, the letter dated June 29th, 2011. Okay. I understand that the June 29th letter is a scorecard on votes that have been completed. Is that correct?
Yes, sir.
So every item that's listed with regard to this scorecard is a matter that is no longer pending. Is that right?
Yes, sir.
Okay. So to the extent that your complaint addresses influence, it doesn't pertain to a letter dated June 29th, 2011. Is that right? All right. Now, I want to turn to the whole issue of scorecards. A scorecard is a very common device for interest groups to grade legislators after a session.
Absolutely nothing wrong with
Okay. Who are you aware of that has scorecards that you've been scored on?
it. I think maybe Texas Right to Life.
Or turn the power on?
Okay, now?
We can't hear you.
In response to your question, I think that Texas Right to Life may have a scorecard.
Okay.
I think there are other organizations. I personally never paid much attention to scorecards.
That's not my question. My question is, who has them?
There are other organizations. I'm sorry, I can't list all of them. I have to go look them up.
So there's only two that you're aware of today?
Only two that come to mind. I'm certain there are others.
All right. Now, at the beginning of a session, are you contacted by many folks about what their priorities are for the session?
Yes.
Okay. What form do those communications take?
Personal visits, phone calls, emails, letters.
Okay. Do you believe that an organization, or do you feel like an organization that has a particular interest making a general statement about what their priorities are for the legislation is a comment on a pending matter?
No, I think it would have to, it would specifically concern the bill.
Okay, so it doesn't surprise you that Empower Texans is in favor of lower taxes, for example?
Not at all.
Okay. It doesn't surprise you that Texans for Lawsuit Reform are in favor of tort reform measures?
No, sir.
All right. And that would not be an attempt to influence you on a pending matter before the legislature?
The pending matter to me is specific legislation or an action of the legislature. I mean, I count speaker election as part of
All right.
that.
When does the speaker election actually begin?
On the very first day of session. Oh, when does the election begin?
No. When does that become a pending matter before the House?
As soon as the legislature's gavelled in, I presume.
Okay. So is it your testimony that a communication regarding the speaker election before the session is not a pending matter?
No, that would be a pending matter.
Okay. Why is it a pending matter?
Well, there's going to be a speaker.
And so what is the mechanism for the choice of the speaker?
The speaker is determined by a vote of the 150 members of the Texas House.
Okay. And how is that done in practice?
One of the first orders of business when the legislature is sworn in is to deal with its housekeeping rules and elect a speaker, a presiding officer, and the presiding officer is elected from among the body of the 150.
So pledge cards have nothing to do with it?
I guess there's a history of pledge cards, but they're non-binding.
My question is, in Exhibit 39, there's a document from what is it, November? The one with the oh, it's not 39. The one with the signed by numerous people and attaching a petition. You remember that?
I do remember such a document.
Okay. And it asks that a change to a more conservative speaker is in order.
I remember that.
Okay. Is it your testimony that that was a communication regarding a pending matter or not?
It was.
Okay. How could it be a pending matter if it was sent before the session opened?
It was directed to members-elect of the next legislature that would be taking up that matter.
Okay. So it's your testimony that even though the session had not opened, that pending before the House was the speaker election issue?
Well, I don't think lobbying is confined only to the period of the legislative session.
Okay. One of the things that Commission staff briefed us on was that the purpose of the communication is to influence any matter pending in either the House of the legislature. Okay. Is it your testimony that the speaker race is a matter that's pending prior to the beginning of the session?
Yes, sir.
Now, I want to talk to, I want to address the letter in Exhibit 39 dated December 20th, 2010. It's pages 741 and 742.
Yes, sir.
Okay. Are these bullet lists general statements of the interests that are supported by this group, or are those specific attempts to influence pending activity?
Those are more general bullet points.
Okay.
But I'm certain that there are other documents that were submitted that referenced specific legislation and directed members of the legislature how to vote.
What documents are you referring to?
There was something related to House Bill 20. I had three bills during the 82nd legislative session, and there was communication sent to my office and other legislative offices telling members to vote against those specific pieces of legislation. And I'd have to go back and look at the bill numbers. In fact, it may be on their scorecard business. 2592. Was it behind 37 or 39 where that list on their scorecard was?
Well, let's go to 737 in Exhibit 39, and let me ask you some specific questions
Okay.
about it.
All right.
May 6, 2011 is a letter that addresses a draft rating. Do you see that?
We're on 739?
Page 737, the May 6, 2011 letter.
Yes, sir.
And attached to that letter is a listing of votes.
Yes, sir.
But those votes have already been cast, right?
Correct.
Okay. So this draft report of May 6, 2011 is for votes that have already been cast.
Yes, sir.
Just like the June final report is for votes that have already been cast.
I'm sorry. Say that again, please.
Just like the first letter we looked at in June, the June 29th, 2011 on page 734 were for votes that were already cast.
Right, but it says, if you'll notice down toward the bottom of the letter, it says, again, others will be added to these in the final weeks of session.
Right? But they can add anything they want to their scorecard, can't they?
Yes, but along with the scorecards, there were directives issued to the members of the legislature to vote a certain way on each of those pieces of legislation.
How were those directives communicated?
Via email and communication, written communication that was delivered to the desks of the members on the House floor.
Okay. So the email was sent from who?
From Empower Texans Michael Quinn Sullivan to each member of the Texas House.
For every bill that ever came on a scorecard?
I don't know that it was for all of them, but for certainly selected bills, they issued written communication. Yes, sir.
Okay. Now, this reply in Exhibit 39, this letter to Mr. Greenhall, asks for all correspondence received from Michael Quinn Sullivan, including electronic mail. Why are those electronic mails not included in Exhibit 39?
Likely because they had been, I think that there is a House policy, administration policy, that periodically they make room for more data, and that.
Don't tell me the Texas House is as bad as the IRS. Please don't tell me that.
Gosh, I hope not. I hope not. But I do think that periodically they move, and frankly, some of those things I wadded up and threw in the trash can. So I may not have kept, a hard copy of it, and if that's the case, I couldn't provide something that I'd thrown away.
Do you have to interrupt me?
I just wanted to let you know that one of the documents that we stipulated to was the House policy on elimination of emails after 30 days. That was the House's own document retention policy is to eliminate emails after 30 days.
Thank you. So it is as bad as the IRS. All right. So it's your testimony.
I didn't vote to do that.
It's your testimony that, but the emails would come to you regarding scorecard votes
Yes, sir.
in advance of those votes being made.
Yes, sir.
Now, did they tell you which way to vote on a scorecard?
Yes, sir.
What did they say?
Not on the scorecard. They told us that this was their position on that bill, that we were to vote for or against it, and that it would be graded on the scorecard.
Okay. What is the significance of a draft score before the last 3 weeks of the session?
I think a warning,
What do you mean?
clean up your act or else,
Or else what?
or we'll go after you in your district.
Okay. And it's your testimony that those communications came primarily by email?
Yes, sir.
Have you ever-
And some passed out on the floor of the House. That there's a process, and I don't know that it is still the procedure currently in the House, but at the time, a document could be submitted via the sergeant's office, approved by House administration, and then distributed to members' desks on the floor.
And what would that document say?
It would identify, and we didn't get those just from this organization, but I remember seeing stuff come through that would be, okay, this bill is coming up, and we want you to vote this way. So-and-so is going to be offering an amendment, and you need to vote this way on it, or we oppose this bill, or we're in favor of this bill, and this is going to be on our scorecard, and so you need to vote the way we want you to vote.
Mr. Chairman, I don't want to interrupt, but I do have to assert a hearsay objection to that testimony. The best evidence, of course, is the emails themselves. And her recollection of I don't have the ability to cross-examine her recollection because she, of course, doesn't have those emails. So I would ask that testimony be disregarded.
I believe that there is.
Let me ask just a question. I realize you two former members would be able to talk for a long time. But I have a question about this thing that is handed out on the House floor. Is it your testimony that the Sergeant at Arms hands out interest group communications on the floor of the House?
Yes, sir. They did. I don't think they do anymore.
They did in the 2011 session?
Yes, sir.
Did they keep a record of those?
I am not certain.
And so for matters that are pending on the calendar for that day, there's a list of where the interest groups came?
2000. They did it through 2000. I know for certain that, they did it in 2011 too, because that's when my 3 bills were up, and I remember seeing something on the floor related from this organization saying vote against that bill.
But are there from other organizations as well?
Yes, sir.
All right. Any other commissioners have questions for this witness?
Mr. Chairman,
Commissioner Ramsey, if you'd use your microphone so we can have the public see it. The button's underneath the table.
I would like to ask the chair to give me an explanation of what is pending legislation and what would in pending legislation be important in this procedure.
Fortunately, today we're triers of fact, and I would hope that council will address that in their closing arguments.
All right, so one more question. Can pending mean, if you're in the legislature and you've been there 2 or 3 sessions, or even the first session, doesn't matter when, but you are aware of certain items that are going to happen that session in the legislature, would those be in the pending classification in your opinion, Mr. Chairman?
I hope that council will address that in their closing arguments.
Thank you, sir.
Mr. Chairman.
Any further questions by commissioners?
Mr. Chairman, may I just clarify something on the papers being handed out?
Exhibit 39 or something else?
The ones that we referenced, you asked me about the material that was handed out on the House floor.
Yeah.
It did, I believe it did, I was just thinking about it, I believe it did have to, it was done at the request of a House member. So an organization would bring something to a House member and ask them if they could have it distributed, and then that person would take it to, would go through the approval process. So it came from an organization via a sitting member.
So it would say Representative Houston
It would-
supports this bill, or would it say
No,
the interest group supports this bill?
It would say the interest group supports the bill, but there would be a signature at the top saying approved for distribution and a signature of a House member.
I see. All right. Thank you. Council, redirect.
Ms. Truitt, are you aware of what the definition of legislation is under the lobby law?
Anything pending?
Can you see the board up here?
No,
Can you see the
sir.
writing? Okay. I mean, since this issue is under discussion, Mr. Chairman, I'd like to ask if you could take official notice of the definition of legislation that's posted on that board.
I think you guys are going to do a great job in closing of explaining how the law applies to these facts, and what we're trying to do is get all the facts on the table.
Okay.
All right?
I have no further questions.
So did you ask her any questions?
Well, I mean, I asked her if she was aware of the definition of legislation. That's all I just wanted to get. I wanted to ask if she was aware of that.
All right. Council?
Ms. Truitt, have you ever sponsored a flyer being distributed on the floor of the House?
Yes, sir.
All right, and you write on it, okay for distribution, sign your initials and the date, and then give it to the sergeant at arms, right?
Yes, sir.
And that's pursuant to the House rules.
It was at the time. I
Right.
don't know if that's still the case.
Okay. And then the sergeant at arms distributes it.
After approval from House administration, I
Right.
believe.
So House administration has to approve it.
I believe so.
And one of the things that's routinely circulated on the floor is a flyer each day from the Texas Conservative Coalition. Is that right?
Correct.
Okay. And sometimes they compile information from positions of various organizations, right?
Yes, sir.
And so they say, here's our list for today of various bills. Texas Public Policy Foundation takes a position, Texas Trial Lawyers take a position, the Realtors take a position, or some other, or the Austin American Statesman takes a position. But the Texas Conservative Coalition compiles those and submits those. Is that right?
They did have a list.
Okay. Are you thinking that your bills were opposed by the compilation of a distribution that was done by the Texas Conservative Coalition and then sponsored by a member, and not specifically done by Empower Texans?
I seem to remember a communication specifically from Empower Texans opposing one or more of those three bills.
You don't have a copy of it, though?
I don't. Well, there may be something in the documents.
I've been informed that Empower Texas has never once in the history of its existence has asked for a piece of their paper to be submitted to the House floor. It's gone through, if their position has been done by a different organization and sponsored by a member. Do you have any evidence to support something opposite that position?
Not in front of me at this time.
Okay. Now, let's talk about the Speaker's election. Really clarify it, something I know something about as well as you. The first order of business in the Texas House is to do what?
As I recall, the Secretary of State convenes the legislature and then a speaker is nominated. Nominations are open for speaker. There are nominations, seconding speeches, and I think the housekeeping comes after that.
Doesn't the first, everybody gets sworn in,
Yes, sir.
and then the next thing that happens is they adopt rules.
Is it the rules first?
Right.
I
You
couldn't
can't
quite
elect a
remember.
speaker unless you have rules
That's true. That's true.
to have a speaker's race. Okay. So first thing you do is adopt rules, and then you have a speaker's race. Right. You don't have
Well,
a
the
race.
speaker's race goes on a long time before that.
But you don't really have
It's
a race.
usually over by that time.
Right. You don't have a race until you have a nomination. Right?
I would disagree with that.
Well, you don't. I mean, you and I have both been in the chamber when we only had one choice.
So I liken this to the time when my previous opponent hadn't filed for election yet, but I was asked to appear at a Tea Party meeting to debate my opponent who hadn't filed for office yet. It's the same. The race starts way before.
You don't have. You officially don't have an opponent legally. Legally, you don't have an opponent until that person files. Right?
I appeared anyway, but out of courtesy.
Sure, out of courtesy, but legally, you didn't have an opponent, did you?
I did not.
Legally, there's
But,
not a.
well,
Miss Truitt.
But in the speaker's case, those people file well in advance of the election.
They file a notice that they may be running.
They file with the Ethics Commission, I believe,
Right.
that they're a nominee or that they're going to run for speaker.
But there isn't a real race until they're nominated, right?
I would disagree with that.
There's a difference between sharp elbows and politics in the back hallways of the legislature and what happens on the House floor. But on the House floor, there's not a real race until there's a nomination.
If someone tells me that they file for speaker, I think they're running for speaker.
How many? I mean, you've been around when people said they're running for speaker who have never really filed and nobody nominated them, right?
But I.
No. Answer my question, right?
That is correct.
Okay. That's all that we need to get to. And the House rules will speak for themselves. Okay, now, a couple questions earlier. Were you looking at some notes when you were answering my questions earlier?
Without direction or advice of anyone, I jotted a few notes down for myself.
Can I have those, please?
Certainly.
Now.
Well, they're on my iPad.
So you were testifying from your iPad?
Yes. They were my notes.
Is your iPad connected to the internet?
It is.
Were you watching the proceedings out in the hallway?
I was not.
Did anybody help you put those notes together?
No, sir.
Well, your testimony is that in answer to my question, you were looking at prepared notes.
That I myself prepared without direction or advice from anyone else.
Mr. Chairman, I ask that this witness testimony be struck.
Well, and I would say that I don't believe her testimony should be struck. We don't know what specifically she was referring to, but she was testifying for the vast majority of these proceedings without referring to any notes or prepared writings to our knowledge.
I'd be happy to provide the notes if I need to. It's like one page.
Ms. Truitt, did you testify from notes?
Not. I testified maybe 2 sentences from notes.
Okay, so you referred to them to help provide testimony to the commission today.
Only during one time.
And what time was that?
When Mr. Nixon was first interviewing me.
Okay, and so those notes are in what type of application on your iPad?
It's in iAnnotate.
And can you email a copy of iAnnotate to counsel for both sides?
Yes, sir.
All right. And I'd ask you to do that as soon as this testimony is over, and we will prevent the witness from being excused in case we need to recall her to address that item.
Okay, thank you.
Is there any further redirect?
Yes.
Okay.
Ms. Truitt, could you refer to the documents behind tab number 75? And at this point, I would like to offer, as an exhibit, certified copies of documents 75 and 76. And for the record, Mr. Nixon and I, we did stipulate to certain facts, as indicated at the front of the stipulations, that from May of 27, 2009, through the date of the election of the Texas Speaker of the House, on January 11, 2011, that Joe Strauss III was a candidate for Speaker of the House, as well as under section or paragraph 3, that from November 12, 2010, through the date of the election of the Texas Speaker of the House on January 11, 2011, Warren K. Ken Paxton Jr. was a candidate for Texas Speaker of the House.
What about Exhibit 75 and 76?
Those are certified copies of speaker declaration forms that have been filed with the commission. I would just like those on the record to indicate that those particular individuals were candidates for speaker.
Are you offering
during a certain
these, or are
time
you
period.
questioning the witness about
Well, I would like to offer them at this point.
Counsel?
Relevance.
Okay. They're admitted.
The commission should take note that Mr. Paxton was not nominated, nor did he run on the day that the House was sworn in. There was not an actual election. He was not a candidate in an election before the Texas House.
Is that an objection, counsel?
No, that is a request for you to take note of that fact.
Is that a stipulated fact, counsel?
That is not.
Okay. Please continue your question.
Thank you. Ms. Truitt, during the 2011 legislative session, did members of the House, I mean, is it your understanding as a legislator that members of the House have discussions amongst themselves about who they're going to support as Speaker?
Yes, sir.
And how long do those deliberations last leading up to the session?
Months.
In your recollection, do candidates for Speaker, do they make attempts to seek support from other members during that time?
Absolutely, yes, sir.
And is that done through
All
the...
soliciting hearsay. They're both leading and soliciting hearsay. What other people may have talked about at some point where she wasn't present, it's not knowledge of facts.
Sustained. Continue.
There were many occasions when
It's not a question present.
Ma'am, I'm sorry. Please wait for the question.
Yes, sir.
You can continue.
Sure. In your recollection, is it, I mean, how do candidates for Speaker obtain support from other House members?
mostly by contacting them directly, either in person or on the phone, and soliciting their support. Prior, and oftentimes in the past, a speaker candidate would try to garner enough signatures from members to show that they had enough votes to win the race, and could then show those to other members, and hopefully discouraging another candidate to withdraw. So there's a lot of work that's done ahead of time to seek the votes, seek the commitments of members of the next legislature.
Our candidates for the Speaker of the House, are they free, or are members of the House, are they free to decide for months or any period of time leading up to the day of the election of the Speaker who they're going to support?
Yes, sir.
And they can freely discuss that with other members?
Yes, sir.
And they can be contacted by individuals outside the House to
Yes,
ask
sir.
them who to support?
Yes, sir.
Okay. I have no further questions.
Did Ken Paxton, was he nominated?
He was a candidate.
No.
He filed papers.
Did you not understand my question? Was he nominated from the floor of the House?
I believe he decided to withdraw on that day.
So he did not. He was not nominated.
He worked ahead of the legislative session.
I'm having a hard time getting a yes or no. Was he nominated?
Excuse me. Give Mr. Nixon back 2 minutes, okay? He's asked a very straightforward question. Please answer his question.
He filed papers. He campaigned. He withdrew on the day.
Ma'am, let me ask the question. Was he nominated in the Texas House for Speaker in 2011?
I don't believe so. I don't think it got to that. I think he withdrew before the nomination.
Thank you. Now we're back on.
One last question. Thank you, Mr. Chairman. If Michael Quinn Sullivan had been registered as a lobbyist, would you have any objection to his letter?
No, sir.
So I guess it's your testimony in front of this commission that registered lobbyists have an opportunity to influence legislators in a speaker's race, but regular people do not?
Not at all.
Thank you.
All right. Ma'am, if you would get the email addresses from these two lawyers, send them your I-annotate document, and then if you would remain subject to recall, unfortunately you won't be able to remain in the proceedings inside the hearing room.
Okay. Can I get the cards?
If you just give her a slip of paper or a card.
We've given her counsel our email.
Okay, very good. Counsel, who's your next witness?
I call Steve Bresnan.
Okay. What time do you intend to break? 12:30? 12:40 minutes. I'd like to get to us at 12. I'd like to get to us. 3 hours between 12 and 1.
No, 12:30. Got to,
Where am I sitting? Over here on that? There it is. Let me try this out.
All right. Mr. Bresnan, Government Code 571-130C gives each witness the opportunity to make a brief statement, if that is their preference. Do you wish to do so?
Can I reserve it for a later time, or shall I make it now?
You have to make it now or not make it.
Mr. Chairman, before we get started,
Yes.
I would re-urge our motion to exclude Mr. Bresna's testimony. We asked the commission for his deposition. The commission, even though they had voted to subpoena Mr. Bresnan and knew that he would testify, counsel for the commission opposed our taking his deposition, and the commission voted that we could not take his deposition. So, if the commission's position is that there was not good cause sufficient to depose a witness that they knew they were going to testify, there is not good cause to have any testimony from that witness. And I would urge that because of the commission's decision to not allow us discovery of this witness that was requested, I think back on February 12th, that at this time, the witness should not be allowed to testify.
And we're still going to carry that motion, but we'd like to hear from the witness today.
All right, I would ask that the witness be instructed that we don't have a truant issue with regard to any notes or any information off of iPhones or iPads, and that all of that be turned off at this time.
That's not a problem. Mr. President, the question has been that we would like to hear your oral testimony today and the answers to the questions. And if you need to refer to documents for the purpose of refreshing your recollection or something else, that counsel be available to see them.
Sure.
So,
Okay,
do
I
you
understand.
need documents to make your opening statement?
Just very briefly.
Do you need documents to make your opening statement?
One document.
Which
It's-
document is that?
It's from United States versus Harris, 1954 case upholding lobby statutes.
What's the citation of that case?
Hold on just a minute, and I'll give it to you. .347 U.S. 612, 74 Supreme Court 808, 98 Lawyers Edition 989, United States versus Harris with 2 S's, et al. Argued October 19, 1953, decided June 7, 1954.
Mr. Nixon?
Mr. Chairman,
Uh-huh.
Mr. Bresnan is going to provide us expert testimony. I would urge the commission to not consider it and not allow him to do so. He is designated as a witness with knowledge of relevant facts. So we ought to hear what his facts are, not what his opinion is on law or any other matter for that, because he's not designated as an expert.
The rules of evidence apply to this hearing, but the government code also gives him the opportunity to make an opening statement, and so I'm going to give him that opportunity. But the rules of evidence do apply.
So I may make a motion to disregard his opening statement if it includes expert testimony.
You may, or you may object to portions of it that are objectionable.
Would you, the chair, wish that I make my objection at the time or wait to the conclusion of the statement? I do not mind waiting to the conclusion of the statement.
Okay, that'd probably make it go faster.
Okay, thank you.
And I'll be brief, Mr. Chairman.
Yes, sir.
The rule of law is a fundamental principle in Western civilization and is a conservative principle. It's the bedrock of conservative principles. Here's what the Chief Justice of the United States Supreme Court had to say about lobby laws and an attack against those lobby laws under the First Amendment. And I'll read it briefly, and that'll be all I'll have to say, Mr. Chairman, other than my testimony, of course. To summarize, therefore, there are 3 prerequisites to coverage under the federal law. A person must have solicited, collected, or received contributions, which is analogous to compensation under our statutes. One of the main purposes of such a person must have been to influence the passage or defeat of legislation by Congress. 3, the intended method of accomplishing this purpose must have been through direct communication with members of Congress. The court goes on to discuss some of the specifics of the specific federal statutes and says, thus construed, these federal statutes do not violate the freedoms guaranteed by the First Amendment, freedom to speak, publish, and petition the government. Present-day legislative complexities are such that individual members of Congress cannot be expected to explore the myriad pressures to which they are regularly subjected. Yet full realization of the American ideal of government by elected representatives depends to no small extent on their ability to properly evaluate such pressures. Otherwise, the voice of the people may all too easily be drowned out by the voice of special interest groups seeking favored treatment while masquerading as proponents of the public will. This is the evil which the Lobbying Act was designed to prevent. Thanks for the opportunity to make a statement.
Mr. Chairman, I ask that the opening statement of Mr. President be completely disregarded as expert testimony and not as a statement of any fact relevant to this case. It's a legal argument that reserved specifically to counsel for the state and the department.
Well, he's not providing legal advice. He's just citing applicable case law.
My point.
Statements made by the U.S. Supreme Court. He's not providing his own testimony.
It appears as if Mr. Stutzloff agrees with me.
The chair's going to let the witness say what he wants to say, and if he wants to quote Supreme Court justices, he can do that. But as the commission knows, this witness does not decide what the law is that applies to this session. So you may begin your question.
For the record, could you please state your name?
My name is Steve Bresnan.
And what is your current occupation?
I'm an attorney and lobbyist.
Are you a registered lobbyist?
I am.
And how long have you been a registered lobbyist?
Since 1996.
How long have you been a practicing attorney?
I was licensed to practice law in 1988.
Okay. Before you is a large notebook. I would like you to turn to tab number 2 that has already been admitted into evidence. Do you recognize that document?
Hold on just a minute.
All right. Please take your time reviewing
Quite
that.
a load here. Yes, sir, I recognize that document.
And what is that document?
That is a complaint filed by Representative Jim Keffer against Mike Sullivan. It is dated April 3rd, 2012, and is the subject matter of this hearing, as I understand it.
Okay. Did you prepare this complaint?
I did.
And is that your handwriting on any of these pages?
It is.
Okay. Can you please turn to tab number 3?
Okay.
Do you recognize those documents behind tab number 3?
I do.
What are those documents?
This is a sworn complaint filed by then Representative Vicki Truitt against Mike Sullivan, and dated April 3rd, 2012.
Okay, and again, is that your handwriting?
Yes, it is.
Okay. So did you prepare these complaints?
I did.
Are you familiar with the documents that are included with these complaints?
I am.
The documents labeled exhibits?
Yes, sir.
And what are those documents?
Well, there's a variety of documents. Some of them are corporate. Well, let me hold on. Just let me look at this particular complaint.
Mr. Chairman, the documents speak for themselves.
The complaint?
Yes. The documents all speak for themselves. Witness doesn't need to testify what they are.
Well, I'm asking him to explain these individual letters and other exhibits that were included. I'm building a foundation
Are
to
they
admit.
admitted?
Well, these complaints themselves, yes, but I do have additional documents that I'm going to ask him about.
Okay, let's move along.
Okay.
Generally speaking, the documents, and
There's no question at this time, Mr. Chairman.
That's correct.
So how did you prepare these particular complaints?
performed search over a number of months period of time and obtained information from various sources, including members of the Texas legislature, and then went back and analyzed the law and concluded that there had been violations of the Lobby Act, and so I wrote up a statement about the violations in following the portions of the Lobby Registration Act and the Chapter 571 of the Government Code, which speak to the complaint process here. Wrote the complaints and assembled the evidence supporting each one.
And where did you obtain the evidence that you included with the complaints?
This particular, most of this, I'm looking at page 85 of the Truett complaint.
Okay.
Those things from item Exhibit 14 and up were things that I obtained via an open records request that was made on my behalf to members of the Texas legislature. Exhibit 14 are documents, the tax returns for the organization Empower Texans that I obtained from the Foundation Center online, which is a common source of those documents. The Exhibit 15 is a letter from the Ethics Commission to me at my request. I wrote the commission and asked if Mr. Sullivan had been registered to lobby in 2010 or 2011, and got a reply from the Ethics Commission that
Counsel,
he is
these
not.
documents are admitted by agreement.
Yes.
Okay, so let's talk about what's relevant about these documents.
Yes, sir.
We don't need to authenticate them anymore.
Okay, I'm getting there. So I'm going to hand you some exhibits. And in the interest of time, I would like to hand these to Mr. Bresnan as a group. I mean, we could go them individually one by one, but for purposes of, in the interest of time, I'd like to ask him to review these exhibits.
What are you trying to hand him?
These are documents.
What exhibits?
These are exhibits from numbers 13. Starting on number 13 to 67.
They're sequential.
Yes, sir.
Okay. So for logistics purposes, he may have the stack.
Okay.
Are these the original documents?
I don't know.
I don't.
Counsel? Well,
I've never seen it before.
they are
The originals you've never seen.
I've never seen the originals, and until Thursday of last week was the first time I saw what I think may be copies of them. And of course, I have objections to them.
Sure.
I don't know when you want my objections.
I want your objections when they're offered.
Now, copies of all of these documents are included in the notebooks that you have before you. They are in your joint exhibit notebook. 13 through 67. Now, Mr. Bresnan, I would like you to look through. We'll begin with exhibit number 13. That should have been at the very top of the stack. Do you see that?
Yes, sir.
Do you recognize those documents?
I do.
And what are they?
The exhibit number 13 is a response to the open records request submitted on my behalf, and this is from the Office of Representative Rodney Anderson, and it conveys a number of email communications styled to Mark Dalton, who was a staff person in Representative Anderson's office at the time. And these appear to be the documents that were responsive to my request.
Mr. Chairman, I would object this witness testifying any further with regard to these documents. These are addressed to Mr. William Greenhall, not Mr. Clancy. Not Mr. Bresnan. Mr. Greenhall received all these documents he was the one that did the open record request, and he was the one who received all these documents. This witness this time, there's no predicate for this witness to be testifying for any of these documents. And I know, and I think the commission should know, that the witness was very careful in not stating that the letter was addressed to Mr. Greenhall. He's testified that this is documents that he personally requested or done at his request. The document itself contradicts that testimony. I would object to any further discussion from this witness with regard to these documents.
So is your request that we bring Mr. Greenhall in here to deal with these documents?
Yes.
Counsel, any objection to that?
Well, he is one of our witnesses, and I do intend to call him after Mr. Bresnan.
You have a problem with us getting these documents admitted, so then we can talk to Mr. Bresnan about them?
I do not.
Does that work?
Let's proceed that way.
Okay. Mr. Bresnan, you're not excused, but if you would step down.
Yes, sir.
We're going to call Mr. Greenhall and see whether or not Exhibits 13 through 69 are going to be part of the record of this case.
Shall I leave the pile here?
I will take those. Mr. Greenhoff, if you could please take a seat.
Counsel, we're going to wait for just a minute till we're all present. Just for members of the public, we'll take a break around 12:30 at the time when, hopefully, when a witness is completed so we can let them be excused for the day. And then we'll break for an hour lunch.
Good morning, Mr. Greenhall.
Not yet, Counsel.
Oh, I'm sorry. I'm sorry. Trey, are you trying to project something? Okay, because we need to turn the projector on.
Mr. Greenhall, the government code gives each witness the opportunity to make a brief statement to the commission before they testify. Would you care to make a statement today? All right. Thank you, sir. Counsel, proceed.
For the record, could you please state your name?
My name's William Randall Greenhall.
And are you currently employed?
No,
Are you retired?
I am retired.
Okay. And how long have you been retired?
Been retired for 10 years.
And what did you do when before retiring? What was your occupation?
For the federal government.
Okay. Are you familiar with the complaints that are at issue in this hearing?
Somewhat familiar, yes.
Okay. How are you familiar with the complaints?
Well, in that Mr. Bresnan asked me if I would help him to file a Freedom of Information request, and that he would make up the request. And I read over it, and then we sent them out, and then as they came in, okay.
Okay, that's fine. I'll just ask. I'll ask you more questions about that. So, are you a friend of Mr. Bresnan?
Yes, for about 30 years.
And you said that you worked with him to submit open records requests. Is that right?
Yes.
Is that something that he asked you to do?
Yes.
And he asked you. I mean, did he ask you to prepare a document, or I mean, what specifically did you do for Mr. Bresnan?
He prepared it, and then I signed it, and then that's what he sent out.
He prepared a letter.
He prepared a form letter.
And did he give that letter to you?
He showed it to me, and then he sent it out.
Okay. Did you put your signature on it personally?
Yes.
So, I mean, did you actually sign the documents, or?
I signed one document, and then we used my signature as a stamp, basically, from there on.
You mean you signed what, a piece of paper, or was it a file?
I signed a piece of paper, and then we scanned it.
Okay, and then you gave that to Mr. Bresnan?
Yes.
And was your understanding that he was going to use that signature in a letter?
Yes.
And what would he do with that letter?
That he was going to send it out for Freedom of Information request, and they would come back to me. And so as they came in, I saved them and gave them to him.
So did you personally mail out those requests?
No, I did not.
Okay. You believe Mr. Bresnan did?
Yes.
Did you receive any documents from legislators' offices?
Yes, quite a few.
Quite a few. Do you know how many?
I didn't count them. They would come in stacks of like 8 or 10 a day.
And at what time did this letter, did the open records request letter go out?
At what time? Whichever the first one was, I think it was in January of 2012, I believe.
Okay. So so you started receiving documents from legislators' offices?
Yes.
And how did you know they were from legislators' offices?
They all had their names on the outside of the envelopes.
So you were receiving envelopes in the mail?
Yes.
And this was at what time? In what time frame?
I believe it was in January of 2012.
Okay.
Didn't.
But do you recall generally how many individual envelopes you had received?
Total probably 35, 40.
Okay. And what did you do with with those envelopes after you received them?
I saved them, and when I'd call Mr. Bresnan every so often, and he would come over and pick them up.
He came to your house, to your home?
Yes.
So you called him and told him that you had documents?
Told him I had some more documents.
Okay.
Yes.
And you gave those documents to Mr. Bresnan?
Yes.
Did you open the envelopes that you received?
No.
Did you modify them in any way?
No. I put them in a sack.
And gave those to Mr. Bresnan? And do you know what he did with those documents after that point?
No, not really.
Okay. Did you receive documents in any other way other than by mail?
There were probably 5 or 6 that responded by email, and I printed those out to PDF format and put them on a disk and gave those to Mr. Bresnan.
Okay. And how did you save them to the disk? They were in a PDF format?
Well, they were emails, and I have Acrobat on my computer, so I just saved them in a PDF format.
Did you modify them in any way other than just saving them as a PDF?
Nope.
You didn't edit them in any way?
No.
And do you know about what time you gave Mr. Bresnan that CD?
Probably within 8 to 10 days after the first letter started coming in. And I don't believe there were too many of them that came in by email. And when they all seemed to come in a group within a 2 or 3 day time period. So I wrote them off and gave them with the other letters that weren't opened as a CD.
Okay. So I would like to give Mr. Greenhaw exhibit number 11. Mr. Greenhaw, there are 2 pages in that exhibit. Do you recognize the first page that's numbered 267 at the bottom?
Yes, that's what Steve had shown me to begin with.
What do you mean that he showed you to begin with?
That
Can you explain?
when we first talked about doing a Freedom of Information Act request, that he said this is what it would look like.
Okay. And so you didn't write this letter?
No.
Okay, and is that your name and your address at the bottom?
Yes.
Now, was this a form letter? What sort of a letter was this?
Well,
I mean,
when he showed it to me, this is what it looked like, just printed out.
Okay.
I'm assuming it's a form letter.
Okay. Can you look at the next page?
Yes.
And do you recognize this document?
Yes, this is one that would have my signature affixed on it.
Okay, so is that your signature at the bottom?
Yes.
And is that your full name and address?
Yes.
Is that your email address as well?
It is.
Were you were residing at that address at the time that the documents were being sent to you? And
Yes.
so is that where they were mailed?
Yes.
And that email address, southaustin.randy@gmail.com, is that the email address to which the responses by email were
Yes.
also being sent?
Yes.
Okay. I pass the witness.
Let's look at, I think it's 268, date stamp 268. Mr. Greenhaw, on the second page of Exhibit 11.
Oh, okay. Okay.
See another one? Now, it's addressed to the Honorable Charles Perry. Did you make that address?
No.
You didn't, so you didn't do this letter?
No, in the sense that what was written, no, I did not.
Okay. Do you know to whom you sent any letter?
No.
In fact, you didn't keep a list of who you sent them to or who you got back from?
No.
And you didn't open any of them?
I did not open anything.
Do you remember doing an affidavit for this, in this file?
An affidavit.
An affidavit.
I've done several. One was stating I wasn't going to be in town.
Well, there's one is you were like in California.
Yes, I have a house in California.
Okay. And you said in your affidavit, I'm going to read it to you, I want to make sure, that, if I read this correctly, upon receipt of the responses, I notified Mr. Bresnan, to whom I personally delivered each response. Is that true?
Yes.
All but a few of the responses came to me via the U.S. Postal Service.
Correct.
I did not personally open any of the envelopes conveying those responses, but delivered them unopened to Mr. Bresnan,
Correct.
who personally took custody of the responses directly from me.
Correct.
Okay. So you are unable to testify today as to what was in any envelope.
I did not open the envelope.
Right. Without opening the envelopes, you do not know whether any of the exhibits attached to that are purported to be responses are actually true and correct, do you?
Whatever was in the envelope, Mr. Bresnan has.
But you can't tell us.
Of what was inside the envelopes? No.
No. You don't know whether any of these exhibits are accurate, do you?
I can't speak to that.
Okay. You still have your computer?
Yes.
You ever done any open records requests before?
No.
Thank you.
So again, Mr. Greenhall, you don't know specifically what was in the envelopes that you received from the legislators' offices, correct?
No. There were some of them that were very large packages, others that were obviously like just 1 or 2 pages.
But you gave them to Mr. Greenhall exactly as you had received, to Mr. Bresnan exactly as you had received them in the mail?
Yes.
Is that correct? Okay. I have no further questions.
Counsel? Any more questions for this witness?
No.
Okay. May the witness be excused?
Yes.
Yes, Mr. Chairman.
Any questions by commissioners? All right. Thank you, sir. Mr. Greenhall, you're excused. You're welcome to remain in the hearing room or to leave.
I'm going to go home.
So I'd like to recall Mr. Bresnan.
Yes, sir. Sir, you're still under oath?
Yes, sir.
So I would like to give you, Mr. Bresnan, exhibit number 11. Mr. Bresnan, do you recognize the those 2 pages that I've handed you?
I do.
And what are those pages?
The first page, excuse me, the first page is a draft of the letter that Mr. Greenhall submitted at my request, that by which the public records were obtained from legislators' offices. And the second one, that was the format, and the second one is a completed copy to the office of Representative Charles Perry requesting the records.
So the document that has the page number 267 at the bottom, is that the open records request letter that was sent to legislators' offices?
Yes, that's the text of it.
That's the text of it?
Yes, sir.
So did you use that as a basis to prepare the other letters that were sent to legislators?
All the letters were identical, except for the addressee.
Did those letters include Mr. Greenhall's signature?
They did?
Is that the same signature that's included on page 268?
Yes, sir.
Did it also include his return address and email address?
Yes.
Is that his return address and email address at the bottom of that
Yes,
document on page 268?
Yes, it is.
So this was just one example of an open records letter that was sent to a legislator's office.
That's
is that
correct.
right? And was that Charles Perry
Yes.
on that particular letter? Did you personally send these open records request letters to legislators' offices?
I did.
It wasn't Mr. Greenhall who sent it?
I printed them out and put them in the envelopes and put stamps on them.
Okay, so you personally mailed them,
I did.
but they had Mr. Greenhall's contact information on them.
That is correct.
Okay, and why did they have Mr. Greenhall's contact information instead of yours?
He agreed to submit the open records request on my behalf and to receive the answers at his address.
But you requested him to...
I did.
You asked him if his name and address could be included on the letters?
Yes, sir.
And what was the purpose for doing that? Why did you ask him for that?
That was to make the request from him and not from me.
Okay.
Is that what you're...
Yes, I mean, is there a specific reason why you wanted the request to come from Mr. Greenhaw and not from you?
Yes. At that point in time, I did not want members of the legislature to know that I was creating work for them and inquiring about these matters.
Okay. So it's your testimony, though, today that this is a sample letter, this is a representation of all of the open records request letters that you personally sent to legislators' offices.
That is request. That is correct.
Okay. I would like to offer you Exhibit 12. Mr. Resin, do you recognize this document?
I'm not sure that I do.
Okay.
I think, yeah, maybe I do. I think maybe this, I can't remember if I created this or, but it appears to be a listing of the people who responded to the open records request and inventory that was made. After I received all these things back, I laid them out and organized them, and Mr. Greenhaw and I went through them. He assisted me to organize the records. So this may have been the inventory that we put together as a result of that. This has been going on for a long time. So.
Okay. So how many legislators' offices? To how many offices did you send an open records request letter?
I believe it was 95 at the time.
Okay. And
so there would have been there were some who did not respond.
Okay. And do you recall which 95 offices you sent them to?
Yes, sir. It would have been all the Republican members of the Texas House of Representatives.
Okay. And did you send any to the Senate?
No, sir.
Did you send any to any Democratic officers?
No.
But not all of the offices responded?
No, sir.
Did you ever follow up to ask them?
No, sir.
About responding?
No, sir.
Okay. Now, how did the documents produced by legislative offices, how did they come into your possession?
Mr. Greenhaw would call me when a number of envelopes had showed up at his house, and I would go to his house and pick them all up.
And when did that happen? At what time? I mean,
well,
what dates? What period of time did that?
Several times, and I can't tell you specific dates, but members would respond periodically. I suspect if we look, there'll be different dates on the reply letters here. They would respond periodically. They'd stack up in Mr. Greenhaw's mailbox, and he would call and say, "Hey, I've got some," and I would go by and pick them up. So I probably made 3 or 4 trips over to his home and pick those up. And
in what format were those? Did Mr. Greenhaw give them to you? I mean, how?
The envelopes were unopened, closed, sealed, just as he got them.
Okay, they were in envelopes. What did the envelopes appear? How did they appear? Did they have any return addresses on them?
Sure, they appeared to have come from members of the House of Representatives with return addresses and.
They were addressed to Mr. Greenhaw?
Yes.
Do you have those envelopes?
I've looked for those envelopes and I cannot find them.
Okay.
I thought they were. I thought they were in that box that I gave y'all, but apparently not. So I don't know where they are. I've moved my office 3 times since this started, so apparently I don't have the envelopes.
Okay. But when you received envelopes from Mr. Greenhaw, they were unopened?
Yes, sir.
Okay, and they did not appear altered in any way?
No, sir. There were a few responses that came by email, and those he printed out and gave me, but there were maybe, I don't know, I want to say 2 or 3 maybe.
Okay, and how did Mr. Greenhaw give those email documents to you?
Well, at first he gave them to me printed out, and then I think at a subsequent time he put them on a CD.
Okay. And what did you do with those documents after Mr. Greenhaw gave them to you?
Well, I
just in general. I mean, what?
Took the envelopes home, opened the envelopes, clipped each package together with a binder clip, and then proceeded to go through them and see what they were about.
And so did you use any of those documents as a basis to file complaints?
Oh, sure. Yeah, after the responses stopped coming, then by that point I had gone through and clipped them and analyzed the documents, and I saw a number of instances of what I concluded were direct communication to influence legislation, and copied those portions of those documents and used some of them to put with the complaint that I ultimately wrote after doing that research.
Did you include all of the documents with the complaints?
All of the documents that came from the requests?
Yes.
No.
You only included some of them?
That's correct.
And why did you only include some and not all?
I didn't include things that weren't relevant to the complaint.
But after the complaints were filed, what did you do with the documents that you received from the legislators' offices?
Well, I boxed them up and set them aside. That would have been, I guess, late April or early May of 2012. Boxed them up and set them over in the corner and waited for y'all to do your work. Sometime subsequent to that, and you'll have to help me with my memory, I went back through the documents and determined that a number of other items in those documents were also evidence of violation of the Library Registration Act, and I supplied the commission with an affidavit that itemized those additional documents. There were 58 of them that relate to this complaint, and I itemized those, where the documents had come from, and provided them to the commission.
Okay. And I would like to hand you, again, the exhibits 13 through 67. So, Mr. Breslin, do you recognize these documents that I've handed you?
I do.
Okay. And if you need additional time, feel free to.
No, that's
look through
okay.
them.
I'm pretty familiar with this pile.
Okay. So what are those documents?
Well, these appear to be the responses to the January 10th open records request, January 10th, 2012 open records request that went to members of the House. Excuse me?
So you personally gave those documents to staff at the Ethics Commission?
I did.
And at the time that you gave them...
Wait just a minute. After the complaints were filed, as part of your investigation, I supplied all of these documents to the commission.
After the complaints were filed, do you recall what time that was?
Ooh, I think I gave you the whole box of them earlier this year.
Okay. And at the time that you gave us the documents, did you modify any of those documents before you gave them to commission staff?
There's a few of them that I had highlighted, some with a yellow highlighter, but otherwise they're unaltered.
So you didn't change them in any way?
What you have is exactly what I got from the members of the House, with the exception of there's a few places where I highlighted them to, like, that's a violation, or this is electioneering, or in the case of the subsequent or the other complaint. But that's the only change I made in any of these documents.
Okay. And I would like to. Is there a CD included with the
Yes, sir.
documents that I gave you? Is that?
Yeah, I think so.
Can you look at that?
Yes.
That's Exhibit 42.
Oh, yeah, and I just got this out of order, so sorry about that.
That's fine. Do you recognize that CD?
This appears to be the CD that Mr. Greenhall gave me.
Okay. Do you know, and have you reviewed that CD?
Well, I did at the time. I couldn't tell you which ones are on there right now, but I did, at the time.
Okay. But you gave that CD to commission staff?
Yes, sir.
As well?
At the same time I gave you all the rest of this.
And did you alter any of the files or any of the information that are on
No,
that
sir.
CD? Okay. I would like at this time to offer the exhibits 11 through 67 as evidence.
Counsel,
I have no objection to Exhibit 11.
Exhibit 11 will be admitted.
I object to 12 through 67.
What's the basis of your objection?
Under Rule 901 and 902 of the Texas Rules of Evidence, these are not authenticated as business records. They are not, and they don't fit any other exception under Rule 804 for hearsay sections, either 803 or 804. Plus, we got a massive chain of custody problem.
All right. I think we're at a good stopping point. We're going to recess for lunch, and we'll return in 60 minutes.
To any testimony be involved in this trial, we now find that Mr. Bresnan tweeting outside. He has been tweeting with people who are in the room regarding the testimony that was delivered. Mr. Bresnan says Emily writes.
Counsel, let me just what I'd like you to do is reserve that for cross, and we'll take that up at that time.
Oh, Mr. Chairman, this is a violation of your rule. This is not a matter of cross. This witness has now.
Well, let me ask this question: is he violating at this moment?
Is he violating the rule at this moment?
Yeah.
What were his tweets during lunch?
At this moment.
At this moment, he is sitting quietly in the witness stand.
All right, Mr. Bresnan, don't tweet right now.
No.
Okay. So what I'd like to do is I'd like you to address that during your cross-examination, and then we'll entertain motions at that time.
The chair needs to be advised of a violation of the chair's rule by a member of the State Bar. And the chair, the respondent at this point moves to strike Mr. Bresnan's, the entirety of his testimony for his violation of the rule. And the respondent requests that the chair advise the State Bar of this witness's violation, knowing violation of the rule of evidence and the order that the chair imposed on each of the witnesses. This is a very, very serious matter, not to be delegated to cross-examination.
It's not that it's delegated, it's just that I would like a little more exploration of the facts surrounding your motion, and I think those are going to be best taken up in cross-examination. For the moment, your motion will be carried. I will not rule on it. All right. All right, so if I understand where we left off, there was an offer of Exhibits 12 through 67. Is that correct?
Yes, Mr. Chairman, that's correct.
Okay. Exhibit 12 is denied. Okay. Exhibit 13 through 67. Are going to be admitted, but with this caveat. Okay. The Commission is only going to consider those pages that are subject to an exclusion or exception under the rules. Specifically, there are some things in these exhibits that are objectionable and concerning to the Commission. But in light of the number of pages that are in these exhibits, they're going to be admitted, but the Commission is only going to consider those pages that are subject to an exclusion or an exception under the hearsay rule. So, Counsel, you may proceed.
Okay. And will I know which specific pages would be admitted, or is that something that would be determined at a later time? Part of
the difficulty is you've submitted a collection of exhibits under each exhibit number, some of which have appropriate exemptions or exclusions, and others that do not. And so I am not going to spend your time or Mr. Nixon's time going through each page of that. So okay. You may continue to question this witness.
Okay. Thank you, Mr. Chairman.
Oh, one last, just a housekeeping matter. At the end of our break, the remaining time for the staff is 2 hours and 41 minutes, and for the respondents, it's 2 hours and 58 minutes.
I would like to inform you, Mr. Chairman, and members of the Commission, we have received the document from Ms. Truitt as requested. Would it be appropriate to distribute that at this time, or shall we wait until after Mr. Bresnan's testimony is concluded?
Are you talking about her notes?
Yes.
Counsel, we're operating under the rules of evidence.
Okay.
And so if those documents are going to be offered, they need to be offered in the proper way. So we're not just going to hand them out.
All right.
All right.
Now, I need to use the projector. May I connect this?
Mr. Chairman,
Commissioner Ramsey?
your declaration on no cell phones or iPads, is that for everybody or just people that are going to be testifying?
What I was referring to was those testifying witnesses in terms of what they were going to refer to. So to the extent that they were going to use notes or electronic devices to refresh their testimony, that counsel would have the opportunity to know what they were referring to before they were questioning that witness.
Thank you, sir.
What I would like to do at this time is project the exhibits that have already been admitted into the evidence and ask Mr. Bresnan if he can read certain portions of those documents into the record, if that's permissible at this time.
Documents speak for themselves, Mr. Chairman.
Yeah, they do. I'd like you to ask questions about documents if you need to, but I certainly don't want to spend the Commission's time reading something that we already have.
Okay.
Counsel, you have questions about the documents, right?
I do. And
You just don't need to tell them to read it.
Okay. Okay.
I'm not trying to interrupt your flow. I don't want to read it because we've got the pages in front of us and we can read it ourselves if you need us to do that.
I understand. Yes, sir. I'm having a technical difficulty. It's not responding.
The computer?
The computer, it says it's not responding. Okay. Well, I'll proceed with our notebook instead of the projector.
I've never seen one work in a truck.
There it goes. It's just so big.
Okay.
Let's see if this will move that maybe.
This will work here.
Thanks. Thank you. Just a minute. Got a loose cable. Okay. Mr. Bresnan, can you read? I mean, is that exhibit legible?
I can read
to you?
that.
Okay.
It's a driver's license test. I'm in trouble if it is.
That's all right. So can you read the page number at the bottom of this
Yes, sir.
exhibit?
May I flip to it and refer to the document in the notebook?
Yes, I will find that here.
Counsel, the witness may be able to read it, but There's no way any of us can.
Okay.
So tell us
This-
what the document number is.
This is behind tab number 45, starting at page 858. So, Mr. President, did you include this document in the packet of documents that you gave to the commission?
I did.
Okay. And why did you include this particular document in with the documents that you gave to the commission?
Because it addresses a matter within the definition of legislation in Chapter 305 of the Government Code and urges a vote on that legislation.
Okay, and
Excuse me, I object to the responsiveness of the answer as including a legal opinion and not just facts.
Sustain?
does this particular document address the election of the vote of Speaker of the House?
Yes, it does.
Document speaks for itself.
I'll allow it. Overruled.
And can you refer to paragraph 3 on that letter? What is the first sentence on that letter?
A change to a more conservative speaker is in order.
Okay. Can you read the very last sentence on that document?
We look forward to working with this reinvigorated conservative majority throughout the coming legislative session.
Okay. So was it because of those particular statements that you included that document with, you provided that document to the commission?
Yes.
Are you aware whether there were multiple communications of the same sort sent to legislative offices?
I believe there were. I believe there were.
And on what do you base that belief?
Well, I believe, if I recall correctly, this letter or a version of it appeared in multiple responses that came back from members of the legislature in response to the open records request.
Okay. Can you turn to tab 19 in your notebook, please? Page 464.
Okay.
Do you recognize that document?
I do.
And what is that document?
That is a letter to the Honorable Tom Craddock on Texans for Fiscal Responsibility letterhead dated December 20th, 2010, signed by Mike Sullivan, and addresses a number of issues that would be considered by the House of Representatives in the 82nd session.
And did you include this particular document in with the documents that you gave to the commission?
Yes, I did.
Okay. Now, you also provided a number of other letters and memoranda to the commission, correct?
Yes.
And you also included a number of emails to the members of to the commission?
Yes.
If you pardon me for one moment, I'm getting a stutter on this laptop here. Could you turn to tab 33, please?
Okay.
And could you specifically turn to page 653?
Counsel, for the court reporter's benefit, would you refer to that as Exhibit 33?
Yes, Mr. Chairman, Exhibit 33.
Okay. I mean, we understand where it's located, but she needs to know that's the exhibit that we just talked about.
I understand, for the record.
What page?
Page 653.
Okay,
Do you recognize this document, Mr. Bresnan?
I do.
And what is that document?
That is an email from Mike Sullivan to Matthew Miller, who was an aide for Representative Rob Orr during the relevant time period, stating an opinion, asking them to vote for Senate Bill 655, as carried by Mr. Keffer, and I don't know who the Senate sponsor was on that.
The objection document speaks for itself. What it says is, we still have an evidentiary issue with regard to, is that truly a document out of their file? We're not sure, but the main deal is this witness doesn't need to be testifying about his interpretation of what he thinks the document says.
Very well. Move along.
Okay. So, Mr. Bresnan, you provided a number of emails to the commission, is that correct?
Yes, sir.
And you believe that a number of those emails were submitted to the offices of legislators, including legislative members of the legislators, members of the legislature and their staff?
Yes, sir.
His belief is irrelevant. What he knows.
I'm getting there.
No, we have a different opinion on that, but still, the question, this witness should not answer that question as asked.
As to the relevance objection, it's sustained.
Okay. I would like to show you, Mr. Bresnan, exhibit number 10. Do you recognize that document, Mr. Bresnan?
Yes, I do.
And what is that document?
This is a report by the House Research Organization of Legislative Staff for the 82nd Legislature dated March 8th, 2011. It lists all the offices and the committee offices and the staff and contact information for members of the legislature.
Where did you obtain this document?
I printed off online from the House Research Organization website.
Okay. And what is the House Research Organization?
House Research Organization is governed by a number of members of the House. It's paid for, I believe, by subscriptions from the House members, and they produce issue things, informational items like this for the House. It's a bipartisan governance that the legislature relies on for bill analysis or information about, various things, like this or like legislation or about legislation.
So the House Research Organization, is it part of the House of Representatives?
Yes, sir.
I object to the leading question. Plus, the question contradicts what the witness just said. But the Exhibit 10 is hearsay. This is not a government document. As you just heard the witness testify, it's paid for by subscription by some, but not all House members who are members of the research organization. It is not a government document. It fits no exception to the hearsay rule. Plus, we know it's full of mistakes from our own experience. But, we've got an issue with regard to relevance and hearsay as to this document.
What's the relevance of the list of representatives in 2010?
Certainly. Well, it's not being introduced for purposes of showing who the representatives are.
What's it being
but
introduced?
the staff members. There are a number of documents that are emails, and they appear to be addressed to individuals who are employees of the legislature, and their names are included in this directory.
So that's the basis.
Yes, as evidence that the emails that are at issue, some of them were addressed to staff members of legislators.
Well, let's hear from this witness about his reliance on this document.
Okay.
Because I'm uncertain as to whether or not it's appropriate.
Okay. So, Mr. Bresnan, why did you provide this document to staff?
Because on the face of it, for example, Exhibit 653 that you asked me about, it is not apparent who Matthew Miller worked for 3+ years ago. This is a publication of the Texas House of Representatives, as it says on the front page. And this is the way that I traced and went back and found out who Matthew Miller worked for. Because when I received the response, which is subject to the cover letter from Representative Orr, which is on page 628, there's nothing to connect that cover letter to this particular email, and that it came from Representative Orr's office. And a legislative staff member is covered under the Lobby Registration Act in terms of direct communication.
So is that person's name in it?
Pardon?
Is that person's name
Yes,
in
sir.
that? What page?
Page 251, right-hand column, second set of entries from the bottom under Orr, Rob. And Matthew Miller is listed as legislative director.
Very good. It'll be admitted.
Okay. Thank you. I would like to offer into evidence Exhibit 106, certified copies of Form 990s from Empower Texans. It's behind tab number 106 in your notebooks.
Counsel, any objection?
One moment, I believe we have an objection based upon relevance. I'm not sure if these are, let me look very quickly. Yes, this is for year 2007.
11.
These are 990s for the years 2007 through 2011. Our objection would be to any 990 other than 2010 and 2011.
Counsel, your response?
I don't have a problem with the exclusion of those other years.
So Exhibit 106 is admitted with the exception of the 990s for years other than 2010 and 2011.
Thank you.
Mr. President, could you turn to tab 106 in the slim notebook? Page 1497. Have you seen these documents before?
I have. 1497 has been excluded, Mr. Chairman.
2010 and 2011.
Let's stick with 2010 and 11.
Right, that's where we are, Mr. Chairman.
Got it. Okay, continue.
So, Mr. President, are you familiar with what a Form 990 is?
Yes, sir.
And what is a Form 990 used for?
It's the basically the federal tax return for certain tax-exempt organizations under the Federal Internal Revenue Code.
You included copies of Form 990s with the complaints. Is that correct?
Yes.
And what was the purpose for including those documents in the complaints?
Well, to provide a reasonable basis to conclude that Mr. Sullivan was paid more than $1,000 in a calendar quarter in the course of his duties.
Can you turn to page 1503, please?
Yes.
What is that page on 1503?
This is a Form 990, Part 7, Section A. Capital A, officers, directors, trustees, key employees, and highest compensated Sorry. You want it louder? You're the first person to ever ask me to talk louder, but I shall. This is a Form 990, Part 7A, Roman numeral 7, Section Capital A, officers, directors, trustees, key employees, and highest compensated employees, and it lists, among other things, the compensation of Mr. Sullivan for the relevant tax year.
And where is the indication of Mr. Sullivan's compensation on that document?
It's under the fourth line where the listing of those officers and directors and staff are listed.
And what is column B used for?
The amount of average hours per week that person spent on the business of the organization.
And where is the amount of compensation reported?
That's in column D and E.
And so column D, what's the amount in column D?
$64,148.
And what's the caption under column D?
reportable compensation.
Chairman, all of these documents speak for themselves. I mean, this witness is not a CPA, not an accountant, he's not an expert in tax reform. So if you're just going to read them to us, that's not relevant testimony. And if he has an expert testimony, he's not been noticed as an expert. He didn't fill out the form. He doesn't have any clue as to whether these are true or correct. The reporting is accurate. I don't think that's an issue. We've admitted him into evidence. We just don't need to be having him read this information to us.
Counsel, I think a more effective question would be, what does this document reveal about Mr. Sullivan's compensation, rather than why did you include it, you know? And so if we could get to the substance of what Mr. Breslin's testimony is, that would help us.
Okay, I understand. So, Mr. Breslin, what does this document show as to what Mr. Sullivan's compensation is?
Same objection.
And I think what he's saying is, what does this document show with regard to what Empower Texas reported was his compensation, right?
That's correct.
Okay. Mr. Breslin, what's the answer to that question?
There are actually two organizations reflected, and the total compensation is $132,000 and some change for the relevant tax year.
Which is the relevant tax year, 10 or 11?
This one's 10, I believe, sir.
Okay.
I think we're still in 10, yes.
Can you turn to page 1525, please?
Okay.
And what is this section of the form used to disclose, to report?
This is the Form 990 for the tax year 2011. Same section of the Form 990, and it discloses annual compensation between the two related organizations of, help me, 90 and 38, about $130,000 a year for the relevant tax year.
Okay. And does this document indicate the amount of compensation received by Mr. Sullivan?
It does, 40 hours a week,
okay,
average.
And what does this document reveal as to how Empower Texans reported Mr. Sullivan's compensation in calendar year 2011?
Once again, the document speaks for itself. We've never, it's not in dispute that Mr. Sullivan is an employee of Empower Texas. And that he gets paid for it.
Overruled. Mr. President?
What's the question? I'm sorry.
Counsel?
What does it say about his compensation? Is that the question?
Well, I mean, my question my question was overruled, but
The objection was
overruled.
I'm sorry, my objection was overruled.
Mr. Nixon's objection was overruled.
That's right. So the
he
question.
can answer your question.
That's correct. So the question is, what does this particular document reveal as to the amount of compensation that Empower Texans reported paying to Mr. Sullivan during 2011?
Empower Texans, $38,842, and the related organization, which I'd have to look back at, but it's $89,729 for a combined total of about $130,000, if my math will withstand scrutiny.
Okay. I pass the witness.
Counsel?
Issue of clarification for the chair. It is our intent to not ask any questions of Mr. President at this time and reserve our questions for our case in chief.
Okay.
However,
You want to take up the tweet thing now?
that would be the only thing I would ask.
Please.
Does Chairman want me, and in doing so, I do not waive my right to call Mr. President back another time.
I am concerned about communications that are outside the record of this proceeding that are relevant to this proceeding, however they may be transmitted over the airwaves.
All right. Mr. President, you were put under the rule and sequestered from the proceedings, is that correct?
I was.
Did you communicate electronically while you were under sequester with any person who was in this room?
I had no knowledge of anybody being in this room that I communicated with. I tweeted, but I had no knowledge of that person being in this room.
Even though the person tweeted about the question I just asked Mr. Keffer?
Check the Twitters first, and you'll see that there's lots of tweeting going on out there. But I did not know that person, and I don't know that person personally, so I did not know that person was in the room.
With whom did you tweet?
Well, I'd have to look back at my iPad to do that if you want to allow me to do that.
I would suggest that we have the ability to show you those tweets in a moment.
That'll be fine. We'll be sure and show all of them then.
Okay, here's one to Emily.
Mr. Chairman,
Home.
may I refer to my own record, my own communication?
I think let's all look at them together. I don't want Mr. President looking at something that we don't know what it is. And I'm certainly entitled.
There's a chair right here.
Well, Mr. President?
Yes.
What I would like you to do is look at Mr. Nixon's evidence.
All right.
And then when we finish looking at his evidence, we can figure out how everybody can look at your evidence. Okay?
All right. Good luck to us.
Do you know who Emily Home is?
I do not.
She writes, Nixon asked Rep. Keffer if his complaint accusing Sullivan of lobbying references a single conversation or phone call. Keffer says no.
Okay.
Did you believe Ms. Horn, H-O-R-N-E, was in the room?
No.
Was she out in the hallway with you?
No. Not to my knowledge. I believe I was at lunch. Do you have the time on that? Yeah, that was during the lunch hour. I'm sitting in the chili parlor by myself.
Okay, that's your response is at 12:30.
And it was a response to her, if I recall correctly.
Right.
Is that correct?
Right. Now, you understand the sequester says not just as anybody in the room, but anybody who's even watching on the internet. You understand this is being broadcast throughout the state of Texas.
It's my understanding, sir, that I'm not to communicate with any other witnesses, any parties, any of the staff, any of the members on the dais, any sort of ex parte communication about my testimony or any of the other witnesses' testimony. It's further my understanding that
you're a lawyer, right?
I am.
Okay,
you asked me my understanding, and I'm trying to answer you.
You just answer my questions. How long have you been practicing law?
I've been a member of the bar since 1988.
The exclusionary rule is Rule 614 of the Texas Rules of Evidence, is it not?
I was familiar with it in law school.
All right. Okay, so your testimony today as to what your restriction is based upon your recollection from law school only and not from any current review of the Rules of Evidence.
That's correct.
All right, well, the Rule of Evidence says that you're not allowed to talk to anybody regarding anything going on in this proceeding at any time, regardless of where they are or who employs them. Not court staff, not just witnesses, nobody, no how, no way, because your testimony could be influenced by outside information. That's what the rule says. You remember that from law school?
No, I don't.
All right. Well, what other tweets do we have here that you responded to? You know who Sarah Rumpf is?
I do not.
All right. So she's tweeting, and you write back. Read Chapter 305, Government Code. Get paid directly, communicate to influence legislature, must register. Fitz Mike, you're arguing this case with people who are watching what's going on, aren't you?
I certainly was responding to the text message where she said that the First Amendment was on trial. I believe that that's the same one.
Documentary evidence proves communication.
I believe that was the prior one.
Oh, here it's agreed shared First Amendment rights. You were arguing this case.
That's a response to her saying we agree, we all have First Amendment right to our opinions, and I agreed with that.
Mr. Bresnan, you were sequestered. You didn't honor that, did you?
I did not communicate with anybody that has anything to do with this trial or in any way could influence this trial. And I certainly had no knowledge that the people were in the room.
Mr. Nixon, is Sarah Rumpf in the room? Is Emily Horn in the room? Okay. Mr. President, I know this this matter is significant to you.
Yes, sir.
And the debate is important. But I would admonish you to pretend like the internet doesn't exist for the next 4.5 hours.
Yes, sir.
You know, let the blogosphere do what it does, but let the commission do what it does.
Yes, sir.
If counsel for the respondent provides us another communication showing that you are communicating about this case while you're under subpoena, I'm going to strike your testimony.
Yes, sir.
All right. Counsel, Mr. President, you are not excused, but we would ask you to step down.
Understood. Thanks.
Mr. Chairman, we would re-urge our motion to strike Mr. President's testimony now. Let's don't wait.
I've made my ruling.
All right. Mr. Chairman, I would request that you take possession of Mr. President's iPad and iPhone until such time that he is no longer under the rule.
I'm not going to do that to a fellow member of the bar. All right. Counsel, your next witness.
I call Robbie Douglas. Good afternoon, Robbie.
Good afternoon.
I would like to offer at this time Exhibit 70. '71. I believe 72 is already admitted per stipulation.
Counsel, why isn't this one agreed to? I mean, these are records at the commission and properly certified.
These are lottery registrations for the years 2001 to 2009. They have no relevance here.
Mr. Juslos, what's the relevance of these documents?
The relevance is that the lobby registrations show that, there are lobby registrations filed by Mr. Sullivan indicating that he was registered as a lobbyist for several years for the Texas Public Policy Foundation. That's just based on what was disclosed in the reports. And that he was registered as a lobbyist for Empower Texans from 2007 to 2009. That's certainly relevant because it indicates that he was previously employed and publicly stated in reports that he was being paid for the purpose of influencing the legislature.
The objection's overruled. Exhibit 70 is admitted.
Now, Exhibit 71, those are lobby activities reports. Mr. Chairman, I can provide you with the certified copies
Same basis.
as well. The same basis.
Counsel, is your objection relevance?
Yes, I mean, we're talking about what activity, what conduct in 2010 and 11 violated the statute. The prior years are not relevant.
Overruled. 71 will be admitted.
And 72 has been admitted by stipulation. That's the statement that there were no lobby registrations or lobby activities reports filed by Mr. Sullivan for any of the calendar years 2010 to 2014.
Any objection to this one?
For 72? No.
Yeah. Okay, 72 is admitted.
Have you withdrawn 73 and 4?
73 and 4. Yes.
Those are
I'm
in
not.
anybody's notebooks?
No,
No, sir.
I have not provided those to anyone. And I have Exhibit 77, certified copies of a campaign expenditure report and attachments filed by Mr. Sullivan on behalf of Empower Texans in May of 2012.
Same issue. Relevance. What relevance does this have to the years 2010 and 11?
Overruled. 77 is admitted.
Could you please state your name for the record?
Robbie Douglas.
And what is your current occupation?
I'm the director at the Ethics Commission for Disclosure Filings.
And how long have you held that position?
Since February of 2014.
Were you employed at the commission before you held your current position?
Yes.
And what was your position prior to your current one?
Analyst.
And how long were you an analyst for the commission?
From September of 2000.
Okay. And what are your job responsibilities from being an analyst as well as your current in your current position?
I was responsible for making sure that all documents relating to campaign finance or lobby or personal financial statements were received in the proper format and made visible to the public within a 24-hour period.
Could you turn to tab 72 in your notebook, please, Robbie? I'm sorry, that would be Exhibit 72. I apologize. 71, excuse me, 71. Are you there, Robbie?
Yes, I am.
Okay. Can you turn to tab G, beginning page 1198? And can you please turn now to page 1205? That's also within tab G. What is the, now are you familiar with this report?
Yes, I am.
And what type of report is this?
This is a lobby activities report.
And what is a lobby activities report used for?
It is to declare expenditures for a lobbyist.
Okay. And what is the name of the registrant indicated on this report?
Michael Sullivan,
And what is the period covered by that report?
August 1st, 2007 to August 31st, 2007.
Does this report disclose any expenditures?
Yes, it does.
And what are those expenditures?
$600, awards and mementos.
Does it indicate who benefited, or does it disclose expenditures by persons benefited as well?
Yes, it does. State representatives,
And what's the amount?
$600.
Can you turn to tab I, please, page 1212? And do you recognize this report?
Yes, I do.
What type of report is it?
It is a lobby activities report.
And what is the period covered by that report?
January 1st, 2009 through December 31st, 2009.
And what is the name of the registrant on that report?
Michael Sullivan.
Does that report disclose any expenditures?
Yes, it does.
And what expenditures does it disclose?
Awards and mementos, $1,830.
Does it disclose any expenditures by person benefited?
Yes, it does.
And what are the amounts that it discloses?
State senators, $120. State representatives, $1,710.
Does it indicate that the registrant was disclosing expenditures for an entity?
Yes, it does.
Is that section 9 of that report?
Yes, it is.
And what's the name of the entity identified?
Empower Texans, Texans for Fiscal Responsibility,
And what's the amount that's listed?
$1,830.
Can you turn to the next page, please? Do you recognize this page?
Yes, I do.
And what exactly is that page used to disclose?
Basically, it's information entered by filer as a memo. It's additional information.
So it's information that somebody filing a report, they can just add?
Yes, sir, it is.
Okay. Does this report disclose information as a memo?
Yes, it does.
And what does that memo state?
It states, no award exceeded $50 per House and Senate member. The House members receiving awards included Wayne Christian, Charles Doc Anderson, Ken Paxton, Jody Laubenberg, Dan Flynn, Randy Weber, Tan Parker, Ken Legler, Charlie Howard, Carl Islett, Jimmy, Don Adcock, Larry Phillips, Kelly Hancock, Tim Kleinschmidt.
Okay, and if I can stop you there.
Okay.
Does it indicate any Senate members?
Yes, it does.
And where is that indicated?
It is indicated further down.
And what does it state?
Jane Nelson, Troy Frazier, Mike Jackson, Dan Patrick.
And is there a sentence beginning above those names?
Yes, there is.
And what is that sentence? In the second to last line.
Second to last line, Rick Hardcastle, Patrick Harless, Mike Hamilton. The Senate members receiving awards included Jane Nelson, Troy Frazier, Mike Jackson, Dan Patrick.
Okay. And just very briefly, can you turn to page 70, please? And can you turn to tab G? very first page, and this is behind Exhibit 70, tab G, page 1117. Do you recognize this document?
Yes, I do.
What is this document?
This is a lobby registration for 2007.
And what is the name of the registrant on that form?
Michael Sullivan.
And on section 6, for registrant's normal business, what does that state?
President, Texans for Fiscal Responsibility.
And can you turn to page 1119? What is that section of the form used to report?
This is employer-client general information.
So what does a person disclose by including information in that section of the form?
Compensation as well as organizational information.
Okay. And what is the name of, is there an employer or client who's listed on that section of the form?
Yes, sir.
And what is the name of the employer or client?
Texans for Fiscal Responsibility.
Can you turn to tab H, please? Page 1123. Is this another lobby registration form?
Yes, sir.
And what is the name of the registrant on this form?
Michael Sullivan.
And what is the registrant's normal business as stated?
President, Texans for Fiscal Responsibility.
And what is the period of time covered by this form? Does it cover a particular calendar year? Is there an indicator at the top of the form that indicates
Yes,
what
sir.
the period of time?
It is through December 31st, 2008.
Okay. And can you turn to page 1125, please? And again, is this a section of the form that's used to disclose a client or employer?
Yes, it does.
And what is the name of the employer or client disclosed on this section?
Empower Texans.
Can you turn to tab I, please, page 1129? Is this another lobby registration form?
Yes, it is.
And what calendar year does it cover?
December 31st, 2009.
You mean that covers the entire calendar year ending on December 31st, 2009?
Yes, that is correct.
Okay. And what's the name of the registrant disclosed on that form?
Michael Sullivan.
And what is the registrant's normal business disclosed on that form?
President, Empower Texans.
And can you turn to page 1131, please? Is there an employer or client identified on this section of the form?
Yes.
And what is the name of that employer or client?
Empower Texans.
I pass the witness.
No questions.
Okay.
Yes.
Counsel, who is your next witness?
The next witness is Jesse Haug.
Okay. Call your next witness.
Is
may this
she
witness be
excused? Yes, she may be excused.
Okay. Thanks, ma'am.
Good afternoon, Jesse.
Good afternoon.
Now, I have exhibits '79 through 104 that have been stipulated to as admissible.
They're admitted.
Okay. So, Jesse, I'd like to refer you to the notebook in front of you, the large notebook. Turning to page 79.
Exhibit 79, correct?
Exhibit 79, yes.
Okay.
Sorry, yeah. Thank you. And I'd like to ask my introductory questions first. So, for the record, please state your name.
Jesse Hauk.
And how do you spell that name, just for the record?
My last name?
Both.
Both. Jessiehaug.
Okay. And what is your current occupation?
I'm a director of computer services with the Texas Ethics Commission. My occupation is probably software engineer.
Okay. So do you oversee the IT division of the Ethics Commission?
Yes.
And how long have you been with the commission?
3 years.
Okay. Now, you printed a number of websites from the empowertexans.com website. Is that correct?
That is correct.
Okay. And can you look at tab Exhibit 81, just behind tab 81? Does that appear to be a true and correct copy of the website indicated at the bottom of that page?
Yes, it does.
Okay. And is there an email address for the indicated on that page above the photograph?
Yes, there is.
Okay. And what is that email address?
mqsullivan@empoweredtexans.com.
Okay. Can you turn to Exhibit 83, please? Is this a true and correct copy of the web page that you printed out? And is that indicated at the bottom of that page? At the bottom of that document?
Yes, it is.
Okay. Can you read that first paragraph, please?
Austin, Texas. Unveiled in Austin today is a new organization, Texans for Fiscal Responsibility, developed to promote government accountability to taxpayers and citizens. The mission of TFR is to create and sustain a system of strong fiscal stewardship within all levels of state government that serves to empower all Texans.
Do you see the box that's to the right of that paragraph?
Yes.
Can you read those two sentences that are in that box?
New organization offers vision, leadership on tax relief, spending reforms. Advocacy efforts focused on promoting sound fiscal policy among lawmakers, taxpayers, It's,
Yeah, I believe it
that's it.
ends there. So on page 1265, and first, excuse me, if you can look at 1264, is there a date on that page?
Yes, there is.
And what is that date?
December 6th, 2006.
Okay. Can you turn to page 1265, please? And I would like you to, if you could you please read the last paragraph on that page?
In addition, TFR will promote a series of budget reforms this legislative session, including reducing the impact of the newly created business tax, urging lawmakers to not exceed the current spending cap, protecting dedicated revenues for their designed purpose, requiring lawmakers to provide greater budget detail, enacting reforms to the current appraisal system, and promoting transparency in spending.
And can you turn to Exhibit 87, please? Beginning at page 1277. Is that a true and correct copy of a website, the website indicated at the bottom of that page?
Yes, it is.
And can you turn to page 1279, please? And the very first sentence at the top of that page, could you read that sentence?
At TFR, discussions with legislators are secondary to our work informing Texans about the activities of their lawmakers.
And can you read the second paragraph?
Our communications with legislators are an extension of our discussions with Texas citizens.
Okay. And can you turn to Exhibit 91, beginning page 1309? And is that a true and correct copy of the website at the bottom of that page?
Yes, it is.
And what is the title of that page? Or, I mean, is there text at the very top of that page?
The text at the very top, which is a HTML title, is Fiscal Index 2001. There's a pipe, Empower Texans.
Is that 2001 or 2011?
Oh, sorry, 2011.
Okay.
My apology.
And is there a date on that article?
December 27th, 2010.
Does it indicate who it's from, who wrote it?
Michael Quinn Sullivan.
Okay. Can you read the first paragraph beginning with the word preparing, please?
Preparing for the start of the legislative session, we last week sent lawmakers a letter outlining our priorities and reminding them how our scorecard, the Fiscal Responsibility Index, works. Of more immediate significance, we noted that House members' first vote could be graded.
And can you turn to page 1310 of that exhibit, please? And the second paragraph, can you read that paragraph?
Would you like me to include all the bullets?
Not yet.
Okay.
No, just the first sentence.
Broadly speaking, here are our issue priorities going into the Senate.
Going into the Senate? Or?
I'm sorry, going into the session.
Okay.
Thank you.
And that document, that website has a number of bullet points beneath, is that correct?
Yes, that is correct.
Okay, and what's the very first bullet point?
Balance the budget without increasing taxes or creating new revenue sources.
Okay, and what is the second bullet point?
oppose the creation of new taxes, granting of additional taxing authority, or creating any new taxing entities.
And what is the third bullet point, please?
Strengthen the constitutional expenditure limit, such as by requiring that the legislature choose the lower of the change in the sum of population plus inflation or the current measure.
And can you turn to look at page 1311, please? And can you read the first paragraph on that page?
For House members, we noted in a December 20th hard copy letter mailed to their capital offices that their first major vote of the 82nd session could well be the first vote on the index, that is, their vote for the House Speaker.
Can you turn to page Exhibit 93, please, beginning page 1317? Does this document, is this a true and correct copy of the website indicated at the bottom of the page?
Yes, it is.
And what is the title of that website?
The title at the top, which is the HTML title, TFR announces priority legislation, then a pipe, Empower Texans.
And what is the date on that article?
February 2, 2011.
Does it indicate who wrote it?
Yes.
And what is that name?
Andrew Kerr.
Okay. Can you read the first paragraph, please?
Yesterday, Texans for Fiscal Responsibility mailed each member of the Texas House highlighting legislation filed for the 82nd session that exemplifies limited government and fiscal responsibility.
And can you read the second paragraph, please?
The priority legislation featured includes bills and joint resolutions that aim to strengthen the constitutional spending limit, protect taxpayers, reform the gross margins tax, advance tax reforms protecting veterans and active duty service members, limit government outreach, and promote integrity in government. Because these pieces of legislation are central examples of public policy designed to enhance freedom and prosperity for all Texans, Texans for Fiscal Responsibility will feature them in our Fiscal Responsibility Index.
And can you turn to Exhibit 96, please? Is that a true and correct copy of the website that's indicated at the bottom of that page?
Yes, it is.
And what is the title of that website?
Again, the HTML title, Fiscal Responsibility Index, 82nd Session, then a pipe, Empower Texans / Texans for Fiscal Response, and it was too long, so it stops there.
Okay. Can you please read the first paragraph beginning the Fiscal Responsibility Index?
The Fiscal Responsibility Index is a measurement of how lawmakers perform on size and role of government issues. We use exemplar votes on core budget and free enterprise issues that demonstrate legislators' governing philosophy.
And can you read the second paragraph?
Lawmakers and their offices are notified in advance of TFR's position on the issues rated and often prior to votes taken on the floor.
Can you read the third paragraph, please?
At the beginning of the 82nd session, we notified lawmakers of our legislative priorities and the priority legislation we encouraged them to support.
Can you turn to Exhibit 100, please? page 1386. Is this document a true and correct copy of the website that's indicated at the bottom of that page?
Yes, it is.
And what is the title of that website?
Again, the HTML title, TFR releases Texas House scorecard, names taxpayer heroes, then a pipe Empower Tex. That was all I could get on that line.
And what is the date of that article?
June 27th, 2007.
Okay. Can you read the first paragraph, please?
Austin, Texas. Texans for Fiscal Responsibility Today released its scorecard of the Texas House. The TFR analysis of votes demonstrates that far too many lawmakers failed to work in the interest of Texas taxpayers by working against common sense protections and responsible spending.
And can you turn to the next page, 1387, please? And can you read the third paragraph on that page?
TFR used an index of 14 votes in the Texas House that provided a clear picture of fiscal responsibility trends.
And can you read the next paragraph, please?
The good news is that there are 15 highly dedicated members of Texas House working to do the right thing for Texas, earning an A on the scorecard, said Sullivan. Unfortunately, that's only 10% of the House. Far too many legislators are spending too much time working to grow government and expand spending while ignoring the needs of Texas families.
And can you read the very first sentence of the next paragraph?
Earning the Texas Taxpayer Hero Award were...
Okay, and does that include a list of names?
Yes, it does.
State representatives?
Yes.
Okay. Can you turn to page 1390, please? Is that a true and correct copy of the website indicated at the bottom of that page?
Yes, it does.
And what is the title of that page?
Okay, the HTML title,
Yes.
2011 Taxpayer Champions, in a pipe, Empowered Texans / Texans for Fiscal Responsibility, and then a pipe, Empow. And the rest was too big to put on there.
Okay.
Too long.
And beneath where it says 2011 Taxpayer Champions, can you read that paragraph?
The top award presented by Texans for Fiscal Responsibility to legislators based on their rating on the most recent Fiscal Responsibility Index.
And can you turn to the next page, please? And is that page a true and correct copy of the website that's indicated at the bottom of that page?
Are we speaking of 1391 or 1392?
I'm sorry, 1392, yes.
Yes, it is.
And what is the title of that page?
Okay, the HTML title, to be clear, 2011 Taxpayer Advocates, pipe Empower Texans / Texans for Fiscal Responsibility, pipe Empow. Then not enough room to print the rest.
And can you read the first paragraph beneath 2011 Taxpayer Advocates?
An award presented by Texans for fiscal responsibility to legislators based on their strong rating on the most recent Fiscal Responsibility Index.
And I'd like you to go to the slim notebook, the exhibit book. It's from exhibits 101 through 112. And if you could turn to exhibit 101, please. Are those documents a true and correct copy of the website that's at the bottom of that page? Or with respect to the very first page?
Yes, it is.
Okay. And what is the title of that website?
Again, the HTML title, Endorsement Documents, Pipe Empower Texans.
And can you read the second full paragraph on that page, please?
In making an endorsement, we consider a candidate's record in public office, their answers to the questionnaire, signing the taxpayer's pledge, and comments from our friends and email list subscribers in the legislative districts.
And beneath that paragraph, were there a couple links embedded on that website where it says Texas House Pledge or Texas Senate Pledge?
Yes, there were.
And did you click on those links?
Yes, I did.
And did you print them out?
Yes, I did.
Are those located here in this exhibit?
Yes, they are.
So on page 1396, that's a copy of the document that you were directed to when you clicked on the link Texas Taxpayer Pledge on that website?
Yes, they are.
Can you read the title of that document?
Texas State Pledge, Taxpayer Protection Pledge.
Okay, and what does that pledge state?
I, blank, pledge to the taxpayers of Senate District blank of the state of Texas and all the people of this state that I will oppose and vote against any and all efforts to increase taxes. Then there are locations to sign.
And is there a paragraph beneath the dates and the witness spaces?
Yes, there is.
Can you read that paragraph, please?
The Taxpayer Protection Pledge is a project of Americans for Tax Reform, ATR. ATR works with taxpayer groups such as Texans for Fiscal Responsibility and activists around the country to ask all candidates and elected officials to make this important commitment to taxpayers. The national list of signers can be accessed at www.atr.org.
And can you turn to the next page, please, number 1397? Is that a copy of the document that you were directed to when you clicked on the Taxpayer Protection Pledge link on the Empower Texans website?
Yes, it was.
Okay. And can you read the language of the pledge?
Taxpayer Protection Pledge. I, blank, pledge to the taxpayers of House District blank of the state of Texas and all the people of this state that I will oppose and vote against any and all efforts to increase taxes. And there are locations for signatures.
Okay. Can you read the paragraph beneath the locations for the signatures?
The Taxpayer Protection Pledge is a project in Texas of Texans for Fiscal Responsibility, asking all candidates and elected officials to make this important commitment to taxpayers. The national list of signers can be accessed at www.atr.org. A list of Texas signers will be available at www.taxpayerpledge.com.
And can you turn to Exhibit 102, please? Is that a true and correct copy of the website that's indicated at the bottom of that page?
And to be sure, this is document 1402.
That is the page number, yes, ma'am.
Thank you. Yes, it is.
And what is the title of that page?
TFR's 2012 Endorsements, Pipe Empower Texans.
And can you read the paragraph that begins Texans for Fiscal Responsibility?
Texans for Fiscal Responsibility is pleased to present our endorsements in the 2012 election season. While we will not necessarily endorse in every race, we endorse the candidates we believe to be the strongest advocates for common sense, conservative principles proven to empower Texans.
And 2 lines beneath that paragraph, can you read the line can you read the paragraph beneath 2011 award recipients? Is that legible to you?
Yes, it is.
Okay.
See a complete list of the legislators who earned the 2011 Taxpayer Champion and Taxpayer Advocate Awards for their voting records in the 82nd legislative session. Generally, we automatically, I can't read that, endorse, I'm sorry, but I can't read it after that, highlighted
Okay,
something.
That's fine. That's all right. I pass the witness.
Hi, Ms. Hogue. I'm Joe Nixon. How are you?
I'm fine, thank you.
Good. Everything you read for the last, I don't know, half hour or so, all off the web page, right?
Yes, they are off the website.
Nothing you read was an email, a letter, correspondence to a legislator or their staff, right?
That is correct.
Okay. One other question. Do you subscribe to a newspaper?
Yes, I do.
Which one?
The Austin American-Statesman.
Is that the only place you get your news?
No.
Where else do you get your news?
I object to relevance.
Broad latitude on cross-examination in Texas?
I thought you were asserting an advertising exception. I don't think or a newspaper exception.
Right.
Go ahead.
You,
It's not broad latitude, it's relevant.
relevant. Do you get your news someplace else?
Pardon?
You go to web pages to get your news?
Sometimes.
I mean, you're the director of IT. You know all about going around the internet, don't you?
I'm experienced with going around the internet, yes.
What are some of the web pages? What are some of the web pages that you go to for news?
Oh, for news?
Yes.
Sometimes Wall Street Journal. Sometimes a Yahoo is interesting, Yahoo News. Sometimes I don't know the source.
Do you just surf around?
Sometimes, yes.
Okay. Do you know anything about Twitter?
A little bit.
Do you have to know somebody to be able to receive their tweets?
You do not have to know someone personally, no.
But I mean, you have to know who it is whose tweet you're receiving, right?
You have to sign up to receive the tweets.
So you have to. So if you're getting a tweet, you have to sign up to receive that person's tweet.
Your account has to be signed up, yes.
Okay, so like if I'm on Twitter and you're on Twitter, you can be tweeting and I'm not getting your tweets unless I sign up to receive your tweets, right?
That is correct.
Okay. So in order to receive tweets, I have to know you enough to sign up for them, right?
You have to sign up for them, yes.
So for me to respond to your tweets, I have to know who you are.
You would have to know my address, yes.
Thank you.
Commissioners, any questions for this witness? Counsel, redirect.
Just to clarify, Ms. Haug, in order to send a tweet on Twitter, you have to create an account on Twitter. Is that right?
I believe that is true.
And each user's name on Twitter has a unique account name. Is that correct?
That would be correct.
So does it typically begin with an at? At so-and-so?
I believe so, yes.
When somebody sends a tweet and they want to direct a message to a particular person, they can do that by using a reference to their username in the text of their tweet. Is that right?
I'm not a Twitter user myself, so I don't know the exact protocol for sending a tweet. I mean, I've read about it, but I don't have a Twitter account, so I'm not 100% sure exactly what the protocol is for sending a tweet to a person that may be subscribed to you.
Okay, but if someone is a user of Twitter, and say their name is at John Doe, and another person was to send out a tweet with the user account name at John Doe, I think you're a terrible person, or I think you're a great person. Somebody can send that tweet and direct it to at John Doe without John Doe ever asking them or having any affiliation with the sender. Is that right?
I do not know the answer to that question.
Okay. I have no further questions.
Nothing further, thank you.
All right. Where do we stand in terms of time, timekeepers?
TE staff is time remaining is a minute, an hour, 32 minutes. And for respondents, time remaining is 2 hours and 45 minutes.
All right. And so we're going to take a 10-minute break. And who's your next witness?
My next witness is Michael Quinn Sullivan.
All right.
Is Ms. Haug excused?
She is.
Thank you.
Thank you, ladies and gentlemen. We're going to take a 10-minute recess.
Quinn Sullivan.
Sir, would you just hang on one second before you guys get started?
You can sit down.
Please. Continue.
Good afternoon, Mr. Sullivan. Could you state your name, please?
Counsel, if I could, I just, the witness has a chance to give an opening statement under
you're right.
571-130C of the Government Code. Mr. Sullivan, would you like to give a statement?
Mr. Chairman, on the advice of counsel, I'm not going to testify today.
All right. Counsel, please.
So, again, could you state your name for the record, please?
My name is Michael Quinn Sullivan.
And what is your current occupation?
On the advice of my counsel, I'm not going to testify today.
So, do you mean that your attorney advised you not to testify today? Is that what you mean?
Objection, attorney-client privilege.
Counsel, help us understand the privileges for which you seek protection.
Well, on that question, it's attorney-client privilege.
And that objection is sustained.
But a person can waive their attorney-client privilege by publicly disclosing that they received advice, the advice that they received from their attorney.
I don't think he's going to waive it. Why don't you go ahead and ask questions?
Okay. You are the president of Empower Texans, is that correct?
On the advice of counsel, I'm not going to testify today.
And you were president of Empower Texans during 2010 and 2011?
On the advice of counsel, I'm not going to be testifying today.
The responsibilities of your employment in 2010 and 2011 for Empower Texans included communicating with members and employees of the Texas legislature, is that right?
On the advice of counsel, I'm not testifying today.
During those 2 years, isn't it true that you routinely sent letters, memos, and emails to members and employees of the Texas legislature?
On the advice of counsel, I'm not testifying today.
Counsel, I'm just unclear on the basis for the witness's assertion of refusing to testify before this commission. So, would you try to flesh that out?
Sure. So, Mr. Sullivan, are you refusing to testify just based on the advice of counsel, or do you have another basis to refuse to testify today?
On the advice of counsel, I'm not going to testify today.
Are you pleading the Fifth Amendment today?
On the advice of counsel, I'm not testifying today.
If it helps the commission in this process, we will inform the commission that the respondent is asserting his rights under the First, Fourth, and 14th Amendments. And
I don't believe those are.
Counsel, I don't believe the respondent will be answering any substantive questions other than what you've heard so far.
So what portion of the First Amendment is he claiming protection of in this proceeding?
I don't believe that we are required to be any more specific than what we have been.
And what portion of the Fourth Amendment is he seeking protection from in this proceeding?
The same, you're going to get the same response from me. I don't have to be any more specific.
Okay. And I presume your assertion of the 14th Amendment is just simply how those two amendments apply to the state action in this proceeding. Is that correct?
Once again, I don't have to be any more specific other than the assertion of the 14th Amendment.
Okay. And so if I understand things correctly, he is not asserting a privilege against self-incrimination under the Fifth Amendment.
We are asserting privileges under the First, Fourth, and 14th Amendments.
Okay. Counsel, what's your response to that assertion of privilege in this hearing?
Well, there is no basis to just refuse to testify based on the First, Fourth, and 14th Amendments. You have to properly state the basis for refusing to testify and what that privilege is. And I mean, whether there's an actual privilege or not is up to the it's up to chair or the fact-finding body to, I should say the presiding officer of the fact-finding body to determine whether there's a proper privilege or not. They can't just invoke it and say First Amendment, Fourth Amendment, without providing any additional details. There are a number of Supreme Court cases that have said generally that just remaining silent in response to questions under oath, remaining silent can be taken as an invocation of the Fifth Amendment. Now, we have done some research, and we haven't found any specific cases that state that just stating on advice of counsel, I'm not testifying, that's the same as invoking the Fifth. But it sounds pretty close to silence to me. There is one Supreme Court case in which the Supreme Court said that just standing mute is an invocation of the Fifth. And in those cases where someone is pleading the Fifth, a fact-finding body in a civil case, provided that they have additional evidence, they can make a negative inference from that refusal to testify. But again, as to whether just, we haven't found any specific cases that specifically address just, stating advice of counsel, refusal to testify. But I do believe that it is an improper invocation of any privilege, and it's not a valid basis for refusing to testify under subpoena.
Mr. Nixon, if you could address a question that I have. This issue came up in the preliminary hearings where Mr. Sullivan invoked all of his constitutional rights. Section 571, 131B of the Texas Government Code addressing formal hearings states that the respondent may not be compelled to give evidence or testimony that violates the respondent's right against self-incrimination under the United States Constitution or the Texas Constitution. You agree with me that that is a Fifth Amendment assertion of privilege, correct?
It's more than the Fifth Amendment, so no.
No, I mean, with regard to that statutory provision, that addresses his Fifth Amendment right to not give testimony that might be incriminating.
Only in part. So the answer to your question is no. There are more. The rights against self-incrimination are broader than just the Fifth Amendment.
Well, and I understand that. I'm talking about this formal hearing procedure.
In the Texas Constitution as well. The Texas Constitution is not. It's. I think it's Article 8 of Article 1, Section 8. Excuse me. In addition, as you know, Chapter 571, 131C requires the Commission to adopt rules regarding discovery, hearing, and related procedures consistent with the chapter. The chapter, of course, is involving, Section B, which you referred to, and the Commission has not yet adopted any of such rules.
That was the rule argument you made that we went to Judge Sparks on, right?
No. We went to Judge Sparks on the overbreadth of the subpoenas, which he ruled were absurd.
Well, I thought there were due process arguments that we went to Judge Sparks on as well.
Yeah. Well, let me tell you, I mean, we're not shy about going back over there if need be, because since Judge Sparks ruled, the Supreme Court has ruled in the case of Susan B. Anthony versus the Ohio Ethics Commission. And in that case, it instructed the district judge to not rely upon the Younger doctrine, as Sparks did, but to proceed to hear the case in the due course, because they felt as if Susan B. Anthony's rights were being infringed upon. And in that case, it was very significant because Susan B. Anthony said, look, even though they've dismissed the complaint against me, I'm subject to the same complaint being filed again because I'm going to engage in the same activity of public comment. And so Justice Scalia wrote and said to the Sam Sparks in that district, hear this case now. So, if that's what you are asking us to go do, I don't have a problem proceeding in that direction. But quite frankly, Mr. Sullivan's not going to testify today to anything substantive other than his name. He's here in honor of the subpoena, but he's going to utilize all of his constitutional rights except the Fifth Amendment at this point. But his rights against self-incrimination go beyond just those enumerated in the Fifth Amendment.
Well, and what I'm trying to understand is how does his First Amendment right to speak freely prevent him from answering questions that we're permitted to subpoena him to appear to answer?
Well, just as Justice Scalia said in Susan B. Anthony, this issued about a week ago, that laws on the books of the Ohio in the Ohio statutes squelch free speech, and those laws hamper the ability of people to speak freely on political issues. People self-regulate, and that Susan B. Anthony doesn't have to state that they are going to violate the law. They have to say that they're worried about being violated by the statute. The statute prohibits them. So we don't have to say that we engage in conduct or don't engage in conduct, and we don't have to say that we don't have to say anything. It is incumbent upon this commission to make its case in and of itself without our help.
But essentially,
So
you're
we have
making
to make you do that.
you're making an argument that the lobby statute is unconstitutional, correct? Is that what that's why you're referencing Susan B. Anthony?
Yeah, that is in part, yes. Remember, the First Amendment gives you the right to speak. It also gives you the right not to speak. The right to be silent.
All right. Well, we're going to take another 10-minute recess and think about this for a minute.
All right, thank you, Mr. Chairman.
All right. We're in recess.
What's that? Privately. That all deliberations regarding this formal hearing are done in public. Absolutely. Thank you.
Hearing SC 3120487 and 3120488. Sometimes the chair needs to consult with his counsel and figure out what to do next. And so this is my ruling with regard to the current objections. Because the only provision that we're prohibited from seeking is information that might be self-incriminating, any objection to other constitutional privileges is overruled. With that said, you may continue to question the witness. Counsel.
Mr. Chairman, I would couple of matters in response.
Sir, I didn't ask for a response. Counsel, you can make a question. If you have some sort of objection, Mr. Nixon, please assert it at the appropriate time.
All right, I object now. I object that the commission went into the back room and deliberated not in public. That is a violation of the Open Meetings Act, and I object that the commission did that. I object that the commission went back and, under your admission, consulted with Mr. Nichols. Mr. Nichols exited the room at the same time you did. Mr. Nichols is not a member of the commission, and Mr. Nichols is engaged by commission vote on a case pending in Travis County, not on this case. And I further object under Section 2001.083 under the Administrative Procedures Act, which is in the Government Code. It says privilege. In a contested case, a state agency shall give effect to the rules of privilege recognized by law. There is no limitation as to which privilege you may assert or may not assert. Mr. Sullivan is asserting all privileges that are recognized by law. To be clear, those are the First, Fourth, 14th Amendment, Article 1 of the Texas Constitution, Section 8, Section 3, Section 9. Most importantly, Mr. Sullivan is freed from unlawful search and seizure. And unless and until there is probable cause, none of which has been asserted yet today, Mr. Sullivan does not have to provide any kind of testimony or information either from his personal knowledge or his property. Mr. Sullivan is going to follow the admonition of counsel and will not be testifying today.
Counsel, do you have a case in Texas that permits a witness not to testify because he asserted the First Amendment privilege?
I do not have a Texas case where that has been.
Do you have a case that cites the Texas rule of evidence on assertion of privilege that permits a witness not to testify because they assert the First Amendment privilege?
If the court is, or the commission is requesting a brief, I'd be happy to provide it a brief.
No, I'm asking if you have case authority on that question.
Look, this is not exactly a new, I mean, we have gone through this now. This is the third time that you have called Mr. Sullivan to come testify. And on each of those separate occasions, I've made the same assertion.
That's not true. In previous instances, you made the Fifth Amendment assertion as well.
No, we have the transcript, and I'd be happy to go back over it with you, and I can go over it with you.
In the previous instances, you said all of his constitutional privileges, including the Fifth Amendment. This time, you said excluding it.
Yes.
That's correct.
In this case, and look, I understand what the commission wants, because there is a mistaken belief by some, as we discussed at the last hearing, that the assertion of a Fifth Amendment privilege allows the commission to draw an inference. Okay, well, I do have case law that instructs the commission and anybody else that wants to be advised that in Texas, the inference that is drawn from a pleading of the Fifth Amendment is no greater, is less than a scintilla of evidence. Basically, it is not even a feather on the scales of justice.
But we talked about that pre-hearing conference. I understand now you are not asserting the Fifth Amendment privilege. Is that correct?
I do not have to at this time.
Right.
Okay.
So what we're talking about is the First Amendment privilege.
Mr. Chairman, I do have a case. Perry versus Schwarzenegger, 597 Federal 3rd, 1147. You have a right under the First Amendment, freedom of association, to not have to testify.
That's a PAC case.
That is, doesn't matter.
We're talking about a lobby case.
Doesn't matter. Doesn't matter. The issue doesn't matter. It's the rule of law that matters.
This is not a freedom of association case. This is a lobby disclosure case.
Right, I understand that.
That's the law. You have a First Amendment right. And we are asserting his First Amendment rights. Freedom of speech, freedom of association, all of them. Freedom to petition the government.
Well, I mean, just so you understand, it's the ruling of the chair that your substantive challenge to the Texas lobby statute, okay, that it is violative of First Amendment rights, is a separate question. What we have before us is a procedural question regarding this formal hearing. And with regard to this formal hearing and the subpoena powers of this agency, we have subpoenaed Mr. Sullivan to testify. And with the exception of the Fifth Amendment privilege, which you are not asserting, those First Amendment privileges are overruled.
Is the commission then ignoring the government code 2001.083?
No, absolutely not.
In a contested case, a state agency shall give effect to the rules of privilege recognized by law.
And that's why I asked you for any authority under the Texas Rules of Evidence for there to be a First Amendment privilege to prevent from testifying.
I just gave you a federal court case that says that under the United States Constitution, there is such a First Amendment.
I'm enforcing the Texas Rules of Evidence in this proceeding.
So the Texas Rules of Evidence supersede the United States Constitution?
No, sir. What I'm talking about is, will you ask me with regard to 2001.083? Now, if you wish to make a Fifth Amendment assertion of privilege, that's a different question. But right now you're not, and those objections are overruled.
I understand. Please understand, Mr. Chairman, in all due respect, the witness will not testify to anything other than...
Well, then the
his
witness
statement.
is going to have to bear the consequences of his actions.
That's fine.
Counsel, please proceed.
Mr. Sullivan, during the years of 2010 and 2011, did you not routinely send letters, memos, and emails to members and employees of the Texas legislature?
On the advice of counsel, I'm not going to be testifying today.
How many emails and letters did you send to legislators and their staff in 2010 and 2011?
On the advice of counsel, I'm not going to be testifying today.
Could you turn to Exhibit 13 in the notebook that's in front of you?
On advice of counsel, I'm not going to be testifying today.
So you're not able to look at a particular exhibit so that I may ask you questions about that exhibit?
On the advice of counsel, I'm not going to be testifying today.
Okay. So behind tab 13, page number 296, there is an email from Michael Quinn Sullivan to Mark Dalton, dated June 15, 2011, with the subject of vote on House Bill 5. Do you recall that email?
On the advice of counsel, I'm not going to be testifying today.
And it is addressed to honorable members of the Texas House, is that right?
On the advice of counsel, I'm not going to be testifying today.
And it states, to begin on the House calendar for today is House Bill 5, allowing Texas to enter the health care compact. Is that correct?
On the advice of counsel, I'm not going to be testifying today.
And the email also states, as you know, we support House Bill 5 and will positively score it on the Fiscal Responsibility Index. Is that right?
On the advice of counsel, I'm not going to be testifying today.
That same email also states, we encourage members of the Texas House to vote for the Healthcare Compact and HB 5. Is that correct?
On the advice of counsel, I'm not going to be testifying today.
So you sent that email, is that correct?
On the advice of counsel, I'm not going to be testifying today.
And you do not deny sending that email, is that correct?
On the advice of counsel, I'm not going to be testifying today.
Isn't it true that that email was sent with the specific purpose of influencing members of the House to vote for House Bill 5?
On the advice of counsel, I'm not going to be testifying today.
And none of those representatives to whom the email were sent asked you to send that email to them, is that correct?
On the advice of counsel, I'm not going to be testifying today.
And that particular email is not an example of news or editorial, is that correct?
On the advice of counsel, I'm not going to be testifying today.
In fact, that's direct advocacy, isn't that correct?
On the advice of counsel, I'm not going to be testifying today.
Did you also contact members and employees of the Texas House in person in 2010 and 2011?
On the advice of counsel, I'm not testifying today.
Didn't your communications to members and employees of the legislature during that period of time urge specific votes for and against legislative bills and amendments?
On the advice of counsel, I'm not going to be testifying today.
Didn't those communications also urge votes for and against candidates for Speaker of the Texas House at the beginning of the 2011 session?
On the advice of counsel, I'm not going to be testifying today.
Isn't it true that you also informed members and employees of the Texas legislature of Empower Texans' legislative priorities?
On the advice of counsel, I'm not going to be testifying today.
And wasn't the purpose of those communications that were sent in 2010 and 2011 to influence members and employees of the legislature to support legislation that was in accordance with Empower Texans' policy goals?
On the advice of counsel, I'm not going to be testifying today.
Isn't it true that those communications were also made on behalf of Empower Texans?
On the advice of counsel, I'm not going to be testifying today.
Isn't it also true that your employer required you, as president, to make those communications?
On the advice of counsel, I'm not going to be testifying today.
You were receiving compensation from Empower Texans during this time period, is that right?
On the advice of counsel, I'm not going to be testifying today.
And didn't your compensation from Empower Texans exceed $1,000 during each calendar quarter of 2010 and 2011?
On the advice of counsel, I'm not going to be testifying today.
And isn't it true that you sent those communications to legislators and their staff who had never asked you to send those communications to them?
On the advice of counsel, I'm not going to be testifying today.
Now, Empower Texans creates and distributes scorecards that assigns grades to legislators, is that right?
On the advice of counsel, I'm not going to be testifying today.
And isn't it correct that you notify legislators of those grades to pressure them into voting in accordance with Empower Texans' policy goals?
On the advice of counsel, I'm not going to be testifying today.
Empower Texans also gives awards to legislators based on their scorecard grades, isn't that right?
On the advice of counsel, I'm not going to be testifying today.
And aren't those awards given to legislators as a sign of support for the votes that they've cast?
On the advice of counsel, I'm not going to be testifying today.
Isn't the purpose of the Texas Champion and Texas Advocate Awards that are given to legislators a sign of, excuse me, let me rephrase. Isn't the purpose of the Texas Taxpayer Champion and Texas Taxpayer Advocate Awards to generate goodwill with legislators on behalf of Empower Texans?
On the advice of counsel, I'm not going to be testifying today.
In fact, in calendar year 2007, you were registered as a lobbyist for Empower Texans, is that right?
On the advice of counsel, I'm not testifying today.
And you also registered as a lobbyist for Empower Texans in 2008 and 2009, is that right?
On the advice of counsel, I'm not testifying today.
And isn't it correct that in 2007 you filed a lobby activities report with the Ethics Commission that disclosed $600 for awards and mementos that were given to state representatives?
On the advice of counsel, I'm not testifying today.
And those awards were the Texas Taxpayer Awards, is that right?
On the advice of counsel, I'm not going to be testifying today.
And in 2009, didn't you also disclose in a lobby activities report $1,830 for awards and mementos given to legislators.
On the advice of counsel, I'm not going to be testifying today.
And isn't it true that at the end of the report, there was a memo that listed all of the representatives and senators who had received the taxpayer awards from Empower Texans?
On the advice of counsel, I'm not going to be testifying today.
So you filed campaign finance reports with the Ethics Commission that were under oath, is that correct?
On the advice of counsel, I'm not going to be testifying today.
And so those reports were required to be true and accurate, is that right?
On the advice of counsel, I'm not going to be testifying today.
So you were swearing in those reports that the expenditures that Empower Texans made for the taxpayer awards in 2007 and 2009 were made to influence legislators, is that right?
On the advice of counsel, I'm not going to be testifying today.
Isn't it true that in previous court filings that you filed in cases against the Commission, against the Texas Ethics Commission, you described Empower Texans as a direct advocacy organization, is that right?
On the advice of counsel, I'm not going to be testifying today.
And a direct advocacy organization is very different from a news organization, isn't that right?
On the advice of counsel, I'm not going to be testifying today.
And you're not a journalist for Empower Texans, is that correct?
On the advice of counsel, I'm not going to be testifying today.
And you were not a journalist for anyone in 2010 or 2011, is that right?
On the advice of counsel, I'm not going to be testifying today.
And is it more accurate that in your role as president of Empower Texans, you are an activist?
On the advice of counsel, I'm not going to be testifying today.
In your communications with legislators on behalf of Empower Texans, the purpose of those communications is generally for influencing them, not for gathering news. Is that correct?
On the advice of counsel, I'm not going to be testifying today.
And is it true that you only started contributing to the website Breitbart Texas within the past year?
On the advice of counsel, I'm not going to be testifying today.
Is it correct that your job responsibilities with Empower Texans includes the review and analysis of legislation?
On the advice of counsel, I'm not going to be testifying today.
And weren't you required to discuss legislation and legislative policies with others, both inside and outside of Empower Texans in 2010 and 2011?
On the advice of counsel, I'm not going to be testifying today.
Weren't you also required to research legislation and discuss with others your strategies and how best to communicate with legislators about Empower Texans' legislative goals in 2010 and 2011?
On the advice of counsel, I'm not going to be testifying today.
In fact, in 2010 and 2011, you spent far more than 5% of your total time working as president of Empower Texans to communicate with and preparing to communicate with legislators to influence them. Is that correct?
On the advice of counsel, I'm not going to be testifying today.
I pass the witness.
No question.
Commissioners? Commissioner Hobby.
Thank you, Mr. Chairman. The record previously has indicated that you did file Mr. Sullivan as a lobbyist in 2007, 2008, and 2009. Is that correct?
On the advice of counsel, I'm not going to be testifying today.
Well, I think the record indicates that that is the fact. What changed? What made you stop?
On the advice of counsel, I'm not going to be testifying today.
Did the law change?
On the advice of counsel, I'm not going to be testifying today.
Did your job responsibilities change?
On the advice of counsel, I'm not going to be testifying today.
Did your contempt for this body change?
So on the advice of counsel, I'm not going to be testifying today.
Various direct communications, I believe, from you to legislators that were clearly subpoenaed and then narrowed in extensive proceedings such that the subpoenas were much less broad than they originally had been. Direct communications between yourself and lobbyists weren't, in fact, produced by you in response to legitimate discovery requests and were produced by third parties. How do you justify that?
On the advice of counsel, I'm not going to be testifying today, sir.
I'm just interested. I'm interested in where the anger comes from, where the venom comes from. You know, you have a constitutional argument that you want to make to the Supreme Court, correct?
Sir, on the advice of counsel, I'm not going to be testifying today.
Anything about this body that hasn't been helpful to you in your larger effort in that regard?
Sir, on the advice of counsel, I'm not going to be testifying today.
So you're a journalist? Is that what you are in your full-time occupation?
On the advice of counsel, I'm not going to be testifying today.
Again, I hate to come back to the tone of it, but the unwillingness to participate in a registration scheme, the unwillingness to participate in an investigation that we're statutorily compelled to perform, the unwillingness to participate in any administrative proceeding, such as this one or the previous hearings. Why?
Sir, on the advice of counsel, I'm not going to be testifying today.
On Monday, you wrote a blast email that said Clancy and his cronies tried to intimidate Texans from exercising their constitutional rights. ... Barack Obama, Joe Strauss, Jim Clancy want to chill your freedom. Do you believe that?
Sir, on the advice of counsel, I'm not going to be testifying today.
Yesterday, you wrote in a blast email the cowardice and incompetence of these wannabe speech regulators and faux prosecutors. To whom were you referring?
Sir, on the advice of counsel, I'm not testifying today.
Who's the wannabe speech enforcer? Is it the civil rights pioneer at the end of the table?
Sir, on the advice of counsel, I'm not testifying today.
Is it the pastor from Bastrop beside her?
Sir, on the advice of counsel, I'm not testifying.
Is it the career public servant to my right?
Sir, on the advice of counsel, I'm not going to be testifying today.
Is it the former elected official to his right?
Sir, on the advice of counsel, I'm not going to be testifying today.
Is it the Bronze Star winner to my left?
Sir, on the advice of counsel, I'm not going to be testifying today.
I don't understand the venom of it. And to say that got to have thick skin and sharp elbows in this town and this is all about fundraising and it should roll off your back. At some point, this Constitutional Commission has to have a sense of integrity, and we've tried very hard to do that. Your boss, a couple of weeks ago, in My West Texas, wrote the following: because Team Strauss controls many appointees to the TEC as well as its funding, Texans for Fiscal Responsibility was not surprised when the Commission announced that the group was guilty of the alleged violation before it began its investigation. To what was he referring?
Sir, on the advice of counsel, I'm not testifying today.
So you don't have any clue what that's about?
Sir, on the advice of counsel, I'm not going to be testifying today.
Thank you.
Commissioner Long?
May I speak?
Please.
Mr. Sullivan, our job at the Texas Ethics Commission is to receive complaints, one of our jobs, and to see that the complaints agree or not agree with Texas statutes. And then we're to adjudicate accordingly. That's our job. One of the jobs. If the statutes are something that you're in disagreement with, I think where you need to go is the Texas legislature and try to change the statutes. We're here to follow the statutes. We've all been appointed here, the whole commission, by the governor, lieutenant governor, or Speaker Strauss, maybe Speaker Craddock a long time ago, but those are the people that appoint us. And one of the reasons we're appointed is we've been politically active, probably. I was county chairman 25 years, served on the State Republican Executive Committee twice. I was the chaplain of the Republican Party for 10 years. Obviously, you know me because my name is on tab 112 that I have signed up on your list to speak against. Let's see, I don't even have a date on it. Tab 112, my name's on it. I don't remember putting it there. Of course, I know, Peggy Venerable, Kelly Shackelford, and Tim Lambert all friends of mine from the past. I'm just saying that we're not in opposition to the principles you may be presenting. Obviously, I'm a Republican, 25 years as chairman. But I think the matter that we're talking about is that we have a job to do. And we've received complaints. We've talked about them today. And we have to adjudicate on that. I think that a lot of the people that are here, as Commissioner Hobby was alluding to, think we're some kind of ogre. And our philosophy is something that's from other world. I probably agree with a lot of your philosophy. I'm not sure I agree with all the tactics. But I just wanted to say that you've probably read these. You've been sitting out here today. And we have been advised by a council that, according to Texas statutes, those who receive compensation or reimbursement or make expenditures to influence legislation are to file a registration with the TEC and pay a registration fee to lobby or be subject to civil penalty. That's what we're here for. We're not here to be mean, disagree with what you do, except you didn't file and you receive remuneration. To me, I'm pretty simple. As he said, I'm a pastor from Bastrop. I started to not speak. I'm not a lawyer. I don't even understand half of this stuff. But sometimes we need to get simple, and the simplicity is we've had a complaint, we've got to adjudicate on it, and it looks like, from what we see, that there were expenditures made when you influenced the legislature. If I'm out of line, my chair will tell me different.
Thank you, Commissioner. Mr. Sullivan, how long have you been involved in grassroots politics?
Sir, on the advice of counsel, I'm not going to be testifying today.
Do you share the frustration of many in the grassroots who work so hard to get people elected, and then when they get to the pink dome, they seem to forget the reason the people sent them there?
Sir, on the advice of counsel, I'm not going to be testifying today.
Do you share the feeling that sometimes the folks that pounded signs and walked blocks and gave them their $15 and $20 donations for a particular set of values feel like when they come to the Capitol, the lobby takes over and they never get a say for how things happen?
Sir, on the advice of counsel, I'm not testifying today.
Do you think it's helpful to have an organization that keeps track of what the legislators are doing?
Sir, on the advice of counsel, I'm not testifying today.
Do you think it's helpful that the people that subscribe to the service know what votes are coming up?
Sir, on the advice of counsel, I'm not going to be testifying today.
Do you think it's helpful that they have the capability of knowing who their elected official is and sending them an email about an important vote that might be coming up?
Sir, on the advice of counsel, I'm not going to be testifying today.
Okay. Do you agree with me that one of the things that Empower Texas does is it educates grassroots people about how to get involved in the political process?
Sir, on the advice of counsel, I'm not going to be testifying today.
Do you agree with me that Empower Texas maintains a very informative website that informs people what's going on in the Capitol?
Sir, on the advice of counsel, I'm not going to be testifying today.
Do you realize that there's no allegation against you that anything that was published on your website is a violation of the Texas lobby registration statute?
Sir, on the advice of counsel, I'm not going to be testifying today.
Do you realize that there's no editorial that you've ever written that forms the basis for an allegation against you in this complaint?
Sir, on the advice of counsel, I'm not going to be testifying today.
Now, I understand that your counsel has argued that the entire process of registering lobbyists is unconstitutional here in Texas. Do you agree with that position?
Sir, on the advice of counsel, I'm not going to be testifying today.
Do you think that Bill Hammond and the Texas Association of Business Guys should no longer have to register their lobbying activity?
Sir, on the advice of counsel, I'm not going to be testifying today.
Do you believe that Steve Moston and the Texas trial lawyers people no longer have to register as lobbyists?
Sir, on the advice of counsel, I'm not going to be testifying today.
How about the Planned Parenthood and those folks? Do they have to register as lobbyists?
Sir, on the advice of counsel, I'm not testifying today.
Okay. Now, do you also know that there's no allegation against you that a scorecard after a vote is conducted is a violation of any lobby registration statute?
Sir, on the advice of counsel, I'm not going to be testifying today.
Do you know that a scorecard posted on your website is not a violation of any lobby registration statute?
Sir, on the advice of counsel, I'm not going to be testifying today.
Do you know that a scorecard that you send to voters in the district is not a lobbying activity that subjects you to registration?
Sir, on the advice of counsel, I'm not going to be testifying today.
Okay. Do you think the people of Texas deserve to know who is paid to lobby the legislature?
Sir, on the advice of counsel, I'm not going to be testifying today.
Do you think the people of Texas deserve to know the agenda for the people who pay to influence legislation?
Sir, on the advice of counsel, I'm not going to be testifying today.
How does Empower Texas decide which matters go on their scorecard?
Sir, on the advice of counsel, I'm not going to be testifying today.
Is it correct that that's a decision of your board?
Sir, on the advice of counsel, I'm not going to be testifying today.
Is it correct that your board consists of just yourself, Mr. Tim Dunn, Lee Dunn, and Luke Dunn?
Sir, on the advice of counsel, I'm not going to be testifying today.
Is it that group, along with the paid staff, that decide what issues are going to be lobbied for or against in a legislative session?
Sir, on the advice of counsel, I'm not going to be testifying today.
Okay. Now, you admit that you've said vote Strauss in direct communications to legislators. Is that right? I'm sorry, to Joe Strauss.
Sir, on the advice of counsel, I'm not going to be testifying today.
Okay. And you admit that you've sent direct communications to members of the House and Senate to vote for or against legislation in the 2011 session.
Sir, on the advice of counsel, I'm not going to be testifying today.
Now, do you think that any paid lobbyist should be able to make those communications to the legislature?
Sir, on the advice of counsel, I'm not going to be testifying today.
Without those ever being disclosed?
Sir, on the advice of counsel, I'm not going to be testifying today.
Do you receive W-2 or 1099 compensation from Empower Texans?
Sir, on the advice of counsel, I'm not going to be testifying today.
Do you get one check or two?
Sir, on the advice of counsel, I'm not going to be testifying today.
Does your check have the same amount each month, or does it vary?
Sir, on the advice of counsel, I'm not going to be testifying today.
Okay. Now, in your organization, you maintain an email, is that right?
Sir, on the advice of counsel, I'm not going to be testifying today.
And you have some emails for things that are subscribed to, is that right?
Sir, on the advice of counsel, I'm not going to be testifying today.
And you also have emails that go directly from you, right?
Sir, on the advice of counsel, I'm not going to be testifying today.
Now, the emails that go out with your name, are those sent from you or someone who's authorized by you?
Sir, on the advice of counsel, I'm not going to be testifying today.
So we can assume that if there's an email or a letter that has Michael Sullivan at the bottom of it, you either sent that email or directed that it be sent.
Sir, on the advice of counsel, I'm not going to be testifying today.
All right. Now, I want to just address some specific things to 2011. Did you directly communicate with members of the Texas House asking them to vote against Joe Strauss?
Sir, I'm the advice of counsel. I'm not going to be testifying today.
Okay. Is it true that the purpose of notifying someone that they're going to get a negative report on a scorecard vote is to influence their vote?
Sir, I'm the advice of counsel. I'm not going to be testifying today.
Is it correct that the reason for putting an item on the scorecard is so that they know which way to vote in that particular matter?
Sir, on the advice of counsel, I'm not going to be testifying today.
Okay. In 2011, did you send a direct communication to Representative Perry regarding House Bill 4 and House Bill 275?
Sir, on the advice of counsel, I'm not going to be testifying today.
In the 2011 session on May 2nd, 2011, did you send a direct communication to Representative Laubenberg regarding House Bill 3640 and 3790?
Sir, on the advice of counsel, I'm not going to be testifying today.
Okay. Now, you're aware that nothing about your lobby registration has anything to do with asking a member to complete a questionnaire. You know that, right?
Sir, on the advice of counsel, I'm not going to be testifying today.
And you know that there's nothing in the lobby allegations against you that have to do with asking someone to take a taxpayer pledge.
Sir, on the advice of counsel, I'm not going to be testifying today.
Okay. Are you aware that you made a direct communication to Representative Cindy Burkett on April 18, 2011 regarding House Bill 5?
Sir, on the advice of counsel, I'm not going to be testifying today.
Did you make a direct communication to Representative Rob Orr on April 28, 2011 regarding Senate Bill 655?
Sir, on the advice of counsel, I'm not going to be testifying today.
Did you make a direct communication to Cindy Burkett on May 3, 2011 regarding House Bill 3790 and House Bill 3640?
Sir, on the advice of counsel, I'm not testifying today.
Okay. On May 10, 2011, did you make a direct communication to Representative Rob Orr supporting House Bill 272?
Sir, on the advice of counsel, I'm not going to be testifying today.
Did you make a similar communication on the same day reminding him about House Bill 3640?
Sir, on the advice of counsel, I'm not testifying today.
Okay. Did you communicate with Representative Cindy Burkett on May 12, 2011 regarding House Bill 2593 and House Bill 2594?
Sir, on the advice of counsel, I'm not testifying today.
Okay. On May 23, 2011, did you make a direct communication to Representative Rob Orr regarding Senate Bill 1581 amendments?
Sir, on the advice of counsel, I'm not testifying today.
And did you communicate with that same representative the next day regarding Senate Bill 8?
Sir, on the advice of counsel, I'm not going to be testifying today.
Is it correct that towards the end of the session you typically make multiple communications a day with members of the legislation regarding how to vote on various bills and amendments that are pending?
Sir, on the advice of counsel, I'm not going to be testifying today.
I also know that you host a meeting on Wednesdays for the Center-Right Coalition. Is that right?
Sir, on the advice of counsel, I'm not going to be testifying today.
Is that a group that's hosted at the Texas Public Policy Foundation?
Sir, on the advice of counsel, I'm not going to be testifying today.
Who pays the expenses for that meeting?
Sir, on the advice of counsel, I'm not going to be testifying today.
The materials that are in the record before us indicate that that meeting is by invitation only. Who decides who is invited to that by you?
Sir, on the advice of counsel, I'm not going to be testifying today.
Isn't it correct that at those meetings there are handouts regarding the bills that have been calendared to come for vote before committees and before the General House?
Sir, on the advice of counsel, I'm not going to be testifying today.
Isn't it also true that there are handouts for that meeting that indicate which position you and your organization support in voting on those bills?
Sir, on the advice of counsel, I'm not testifying today.
Okay. Now, the Commission has sent you a series of subpoenas requesting those documents. Do you have documents regarding the Wednesday morning Center-Right Coalition meeting?
Sir, on the advice of counsel, I'm not testifying today.
Do you keep track of who you have communicated to for or against legislation so that you can follow up with which legislators have supported your agenda and which have not?
Sir, on the advice of counsel, I'm not going to be testifying today.
Do you have a collection of the emails that you sent out when you send them in support or against particular pieces of legislation?
I'm not going to be testifying to on the advice of counsel, sir.
Do you agree that despite the fact that these open records requests show dozens of these communications, in response to the subpoena, your organization has produced not one?
Sir, on the advice of counsel, I'm not going to be testifying today.
Is that because those emails were destroyed by your business?
Sir, on the advice of counsel, I'm not going to be testifying
Have
today.
you destroyed the emails that indicate direct communications between you and members of the Texas House during the 2011 session?
Sir, on the advice of counsel, I'm not going to be testifying today.
Have you destroyed the letters or copies of the letters that you sent to members of the Texas House urging them to vote for or against legislation during the 2011 session?
Sir, on the advice of counsel, I'm not going to be testifying today.
Is it your argument that the lobby statute is unconstitutional as it's applied to you, or as it's applied to everyone who currently registers as a lobbyist in Texas?
Sir, on the advice of counsel, I'm not going to be testifying today.
All right. Commissioners, any further questions?
Mr. Chairman?
Commissioner Ramsey?
Will Mr. Nixon be at the stand again today?
Oh, sure. He's got his whole case to put on.
I would like to ask him some questions.
Well, we'll wait for that time when that time comes. Okay?
Okay.
All right. Counsel, any further questions for this witness?
I have no further questions. No, I have no further questions at this time. However, I would, considering that no proper privilege has been raised with respect to Mr. Sullivan's refusal to testify, I would ask that the Commission enforce the subpoena as served on Mr. Sullivan to require him to testify before the Commission.
Thank you, sir. You may step down. You may call your next witness.
I have no further witnesses.
Okay.
And now I do have a couple more exhibits that I would like to offer before turning over to Mr. Nixon.
How are you going to do that?
Well, I'll describe them to you. One is, it's in your tab as Exhibit 69, and I would like to offer this as not as evidence, but as a guide, as a visual aid for the members of the Commission to review when you are considering the voluminous amount of documents that are included in your notebooks. It is essentially a list of the documents that have been provided by Mr. Bresnan, as well as selected documents provided by Mr. Nixon, by the respondent in response to the subpoenas to produce documents. It's a list that would give you a guide as to where multiple copies of documents are located throughout the exhibit notebook.
So it's just a summary of what's already been admitted in evidence?
Yes, sir.
Mr. Nixon, any objection?
So long as the Commission understands it's not evidence, it's just, it may be a demonstrative aid for your benefit. I have no problem with that.
Okay. We'll admit it for that limited purpose.
The second is, and I have copies. I have not. I got these. These came in at the end of the day on June the 23rd, and they are letters from a Jeff Archer. He's the interim assistant executive director with the Texas Legislative Council, and this I would offer just to help explain some of the email documents that are included with your notebooks. You may note that some of the emails include a name at the very top of the email, and just so that there's no confusion as to what that name indicates, I offer this just as additional information to help the commission understand what that name refers to. It's from again, Jeff Archer with the interim assistant executive director, who explains what that name at the top of the email indicates.
What exhibit is this?
This is Exhibit 113. It has not been provided to you. It's not in your notebook. It's one that we received just on the 23rd, 2 days ago. I do have copies for you if it's permitted.
What, counsel?
This is all hearsay. We would object to it on that basis, and that, Mr. Archer is not qualified to really offer the explanation that he seems to offer in his letter. Howsoever, I mean, if the issue is when it gets back to the fundamental issue is what of the Bresnan documents are going to be admitted. Because if they're not admitted, then this is not necessary. And which of them are, it may offer an explanation as to why there was an email on somebody's computer at a particular time, because when you print it off, it's going to show your name. But that's not how the email was sent. So the email, the document that's in the exhibits, isn't a true and correct copy of whatever was sent, if any, by Mr. Sullivan or Kyle, Texas.
Okay.
So this is an effort to explain that, except the problem is that we don't have the witness here to cross-examine.
Well, that's not necessary under Rule 803.8, public records and reports. Any records, reports, statements, or data compilations in any form of public offices or agencies setting forth the activities of the office or agency or matters observed pursuant to duty imposed by law as to which matters there was a duty to report. Under that rule, records, public records of the activities of an agency, they do not have to be sworn to in order to be admissible. So there is a hearsay exception for that.
All right, counsel, I'm ready to rule. This clearly is of limited value, but I'm going to admit it and ask you to port it forward with that caveat. Okay. All right, commissioners, do we need a short break, or are we ready to continue? We're going to take a short break? All right. Mr. Nixon, we're going to take a 10-minute break, and then we'll be back.
Thank you.
0487 and 3120488. Counsel for the respondent, you may proceed.
Mr. Chairman, I'm looking for a legal pad. As soon as I find it, I will. Okay. Mr. Chairman, Commissioners, at this time, I would like to move for a directed verdict, but I guess we would call it a directed decision. May I make such a motion at this time?
Sure.
All right. Mr. Chairman, a few years ago, I had the privilege of representing Governor Perry in Virginia in federal court, challenging the validity of the Virginia ballot access statute. And I, along with counsel for Gingrich, Santorum, Bachman, one other, had an interesting day like today discussing the constitutional validity of the Virginia ballot access law. When he was making his ruling at the end of the day, Judge Gabney told me, Mr. Nixon, I'm glad I'm a judge, because as a lawyer, I never would want to try a case against you. And Mr. Chairman, I think I would say the same thing to you today. I'm glad you're not counsel for the state, because until you began asking questions, there were no relevant questions asked of any witness as it relates to the lobby law. Remember what I told you, you weren't going to have any evidence of regulatable speech. And you don't. And let's go through it. The issue regarding the speaker's race. There's not a race until you have a candidate. And there's not a candidate until they're nominated. And they cannot be nominated until the legislature is called into session. So what you have an intentionally incomplete petition letter attached to the complaint by both the complainants. You have, in contrast to that, a complete letter, one written and one digital, that really show that these are petitions from citizens of the state, not efforts to lobby, but people saying, I want you to consider voting for somebody more conservative than Speaker Strauss. That's not lobbying. That's a petitioning your government. And there isn't any evidence from any witness that said Mr. Sullivan communicated with them in person. On the issue of scorecarding, I think it's fascinating. Members of the Texas legislature, Mr. Ramsey, get elected in knowing the people are going to be paying attention to what you do. Every vote that's recorded, people pay attention. They're supposed to. Is this commission prepared to say to someone who makes his business paying attention to the legislature, I'm paying attention to you? That constitutes lobbying? Every member ought to know that every vote they take, somebody's going to be watching. Empower Texas, as part of its reporting, identifies issues that are important to them, advises members, and then tells members, these are the votes, you're going to get a good grade or a bad grade. None of this stuff says vote for, vote against. It says we're going to grade you positively or negatively. What grade you get is up to you. And we're going to report your grade to your voters. That's not lobbying. When we have the problem of using a word like influence, Commissioner Long, you said, look, it seems pretty simple to me. Or you're asked to do more than be a simple man today. That's not a good excuse. You got to think today. Today being simple isn't enough. Today you're going to have to be thoughtful. Today you need to be Solomon. You need to be wise. Because today you need to do more than say, I accept the term influence. Anybody could say anything constitutes influence. They come by every day and say hi. They are the nicest, friendliest person. And they make a point of coming by and saying hi every day. Well, have they ever asked you to vote yes or no? No. But they're coming by and saying hi. I know what they want. They want me to vote positively on their legislation. You could say that's influence. Mr. Long, that's why the United States Supreme Court said influence is unconstitutionally vague. Because when we get down to having to deal with restrictions on speech, it takes more than being simple. The law says the First Amendment requires a heightened degree of regulatory clarity, not simplicity, and a close fit between the government's means and its end. The word influence has already been constitutionally ruled vague because people need a bright line. Is there a garden club in Bastrop?
Yes, there is.
The garden club ladies came here and wanted to assert that they have a right to use a certain kind of pesticide to control aphids on their roses. Would you require that they pay each $750 before they spoke to a legislator? That's an important question. And that's the one you're being asked to decide today. It's not simple. If you do anything, and remember, this isn't the only test. If you spend amount of money, even if you're not getting paid for it, but if you spend a certain amount of money a quarter as it relates to influencing legislation, then you have to register too. So, show of hands, who's been to the Empower Texans webpage? Any of you? Okay. Empower Texans webpage, and I think that's significant. That nobody
Are we allowed to take the fifth, Mr. Nixon?
That is your call, not mine.
I have absolutely been to the Empower Texans webpage. It's a great resource.
Good. And you'll note that they report, Mr. Clancy, that as a part of their scorecarding, they inform the public that each member of the legislature was advised on the vote ahead of time. Something that a lot of other places don't do. A lot of other people who do scorecards don't do. But they do. They do, and they report that because it's persuasive to the voters. This vote, this grade isn't given in a vacuum. It is not given without prior knowledge. The legislatures knew that they were being watched on this vote. That's part of their reporting. So that's all you have. That's all you have. And I note that there was not a single witness that testified with regard to anything involving the center-right meetings. Mr. Clancy, you asked some questions as to what went on there. There are people in this room that go to the center-right meetings. Your staff didn't bother to find out who went and didn't call a single person to tell you. There's no evidence. You're not allowed to presume that any kind of influence took place. Mr. Clancy, you referred to a document handed out at the center-right meetings telling legislators how they ought to vote. But Mr. Clancy, is there any evidence before this commission today that a single legislator attended a center-right meeting? Did the commission staff tell you who was there? Do you know? Anyone? You can't presume that legislators were there. You have no evidence of that. So here's where we are. You have no case. The state has no case. Mr. Hobby, you asked questions with regard to anger, hostility, and venom. Those were all argumentative questions. I could have objected to every one. But it's interesting, you didn't ask for any facts. You wanted to know why he was angry. Mr. Hobby, did you ask a single question about an exception to the lobby statute? Did you ask a single question with regard to the Texas Government Code 305.0041?
Is this really what you're doing? You're picking on the questions from your witness who won't answer? Is that really what you're doing?
Now you begin to understand.
No, maybe you begin to understand. You have the full attention of some very fine people up here, and if you continue to accuse decent people of indecent acts when it doesn't seem to be in your interest to do that, I don't understand. I'm entitled to ask that question of your client and of you.
You know, but look where we are today. Look what we saw this morning. From over here, we heard from people who said, I didn't read the complaint. I don't know whether it's accurate. I don't know whether the exhibits are complete. I didn't write it. Somebody else did it. My political consultant suggested that I do it. The lobbyist for the trial lawyers, who claims it's his, hid behind a friend who did the open records request. What you should be asking, all of you, is why this staff didn't investigate these people. You have a basis, you have a right. Your statute allows you to throw out frivolous complaints. You do it all the time. Where was the investigation into the validity of the complaint? It was clear from the outset.
Is this part of a motion to dismiss?
It is.
Is this a closing argument? I've lost track.
It is part of the motion to dismiss. And we're getting there. I still have 2 hours and 27 minutes.
I'm just trying to be clear that I understand that the distraction, but the core issue is.
There's no evidence.
Do you want to make a motion to dismiss? Or
There's no evidence. And what's disturbing of me is that you asked my client where the anger, the hostility, the venom is, but you did not ask those questions of those witnesses who clearly had anger, hostility, and venom against my client. What is the genesis and the basis of filing incomplete documents and complaints you didn't read, research, support, or write? That's what's very important. As part of my motion, I'm going to urge the Commission not only to dismiss the complaints, but to find that they were frivolously done and sanction all of those who participated in them being filed. What is terribly shocking is the lack of investigation into any exception. Everybody said they went to the Empower Texans website. And if you go to it, and you have been to it, you know that they disseminate news and opinion. And our statute says a person who owns, publishes, or employed by a newspaper or any other regularly published periodical, a radio station, a television station, a wire service, or any other bona fide news medium that in the ordinary course of business disseminates news, letters to the editor, editorial, or other comment, that person is not required to register under this chapter.
Mr. Nixon, you agree that you bear the burden of proof on an affirmative defense?
I do agree that I bear the burden of proof on an affirmative defense.
Let's stick to the directed verdict portion of this motion.
Right. That portion is the failure of this commission and the staff of this commission to take a broad look. Instead, and I read it earlier to the commissioners, the statement of the original staff, pay your fine and get on down the road. Those are his exact words. So you can understand between the lack of rules, the lack of process, and the delay of more than 28 months and having a hearing. There's some there are some credibility issues with this environment that are fairly well grounded. When you look at the evidence, and look at what we had today. This big stack that was delivered to me Wednesday at my hotel at 5 in the afternoon. The first time I'd seen the vast majority. The only documents I'd ever seen before were those attached to the petition. Suddenly, I get this. And what are they? Income tax returns, Form 990s that say Mr. Sullivan is employed by a person who owns, publishes, or employed by a newspaper. What else are they? Web pages. This is web pages. A third of this is web pages. Another bunch are documents that don't meet the business exception. They weren't proven up. They weren't authenticated under the rules of evidence. And you've got a massive custody problem. So, and no one has addressed from the state the issues of the unconstitutionality of the statute. It's just not enforceable. Now, Mr. Clancy, you asked a series of questions, and I thought they were good ones. Do you think the state has an opportunity or right to regulate those who earn a living lobby in the legislature? It's irrelevant to the question. It's irrelevant. It doesn't matter what the witness thinks about that at all. And it really doesn't matter what you or I think about that at all. You're charged solely with the duty of enforcing certain statutes that are enforceable. And if they're unenforceable, you cannot enforce them. It's not your problem that the statute is badly written. It's not your problem that we find ourselves today without any rules. But you're in a position to do something about it. There is a way to write a constitutionally valid lobby statute. This one isn't written that way. It is time, Mr. Long, to not be simple, but to understand the reality. If you really want a lobby statute that works, then you have to do the right thing today, and say this statute we recognize is unconstitutional. You have a real problem. You have an exception that the United States Supreme Court says invalidates the rest of your statute. Either Mr. Sullivan fits here or your statute's invalid. That's where you are. It is important to recognize that and to go ask the legislature to deal with it. Someone suggested, and I can't remember who, that Mr. Sullivan should go back and lobby the legislature to change its lobby laws. What? Do you remember who that was? It was you.
Mr. Nixon, I would prefer if you didn't address commissioners directly, and if you feel the need to refer to them by name, if you would use their title as well.
All right. Well, Commissioner Long, I guess that was you. Problem is that's not what we do. Courts.
Anybody can do it.
Well, and we can get to that in a minute, maybe, but courts do a binary function. It's a 1 or a 0. It's either constitutional or not constitutional. That's all you get to do. We don't get to rewrite it today. And I want to remind you, Mr. Sullivan didn't pick this fight. Somebody else did. Somebody else filed And you know why? It's the elephant in the middle of the room. It's because Mr. Sullivan signed the petition along with 7 other 1,000 Texans to say, let's have a different speaker. So the speaker's lieutenants filed a complaint in retribution. That's all this case is about. This commission is being used for a political vendetta, not for a real complaint. They didn't even bother to read it. They didn't even bother to figure out if it was valid. So, here's where you are today. Here's where you are right now. Here's what the evidence shows. Mr. Kepler, incomplete complaint. I didn't read it. Somebody else wrote it. My political consultant, along with a lobbyist for the trial lawyers, did it for me. Ms. Truitt, not only did I not read it, I read notes from I didn't even testify under oath. I read notes from my iPad. And then, by the way, I turned around and did just what this commission thinks is a real bad idea. Filed a complaint and turned around and said, my opponent is under investigation. And then you have Mr. Greenhaw, who says, I don't know if I signed my name. I signed my name one time, and then it went out all these letters that I don't know how many went out, about 30. And that's the end of that. Then you have Mr. Bresnan, who was tweeting during his sequester, and then said, oh yeah, Mr. Greenhaw came over and he did a whole bunch of other stuff with me, and no one ever kept records of any of this, and I put together a list of who all I sent it to later, and I don't have the envelopes that came in. I don't have the envelopes that came in. So you got a real custody problem. So you don't have any evidence. That was their case. So, commissioners, let's end the day right now. Let's end the day right now. I'm urging you to make a decision today, right now, this moment, and I'll give you back my 2 hours that I have left. 2:16. I'll give you back 2:16, and we can end this. And we can send a message and say there's no evidence, and we're not going to be used for political retribution. We're going to follow the law, all of the law, not just the Texas law, but that of the United States Supreme Court, that of the United States Constitution, and that of the Texas Constitution. My motion now, dismiss these complaints, find them to be frivolous, and sanction those who made them.
Counsel?
In 1954, the U.S. Supreme Court issued an opinion of United States versus Harris, and Mr. Bresnan previously quoted from that. This was an opinion that looked at certain provisions of the Federal Regulation of Lobbying Act. And they specifically addressed whether or not that act was constitutional. And I'll read a portion of the law that was at issue. And this was in Section 307 of the Federal Regulation of Lobbying Act. What it required was a person to register. I'll read this. Well, specifically Section Section 308. Any person who shall engage himself for pay or for any consideration for the purpose of attempting to influence the passage or defeat of any legislation by the Congress of the United States shall, before doing anything in furtherance of such object, register with the clerk of the House of Representatives and the Secretary of State and provide additional information. And Section 307 similarly used the language, passage or defeat of any legislation by the Congress of the United States, and to influence directly or indirectly the passage or defeat of any legislation by the Congress of the United States. And what the Supreme Court said, they said, we now turn to the alleged vagueness of the purposes set forth in 307A and B. And they're referring to an earlier case, United States versus Rumley, which involved the interpretation of similar language. We believe this language should be construed to refer only to lobbying in its commonly accepted sense, to direct communication with members of Congress on pending or proposed federal legislation. The legislative history of the Act makes clear that at the very least, Congress sought disclosure of such direct pressures exerted by the lobbyists themselves or through their hirelings or through an artificially stimulated letter campaign. And they had additional language about the history of the Act and what they state, and this is in Section 2 of the opinion. Present-day legislative complexities are such that individual members of Congress cannot be expected to explore the myriad pressures to which they are regularly subjected. Yet full realization of the American ideal of government by elected representatives depends to no small extent on their ability to properly evaluate such pressures. Otherwise, the voice of the people may all too easily be drowned out by the voice of special interest groups seeking favored treatment while masquerading as proponents of the public weal. This is the evil which the Lobbying Act was designed to help prevent. Toward that end, Congress has not sought to prohibit these pressures. It has merely provided for a modicum of information from those who, for hire, attempt to influence legislation or who collect or spend funds for that purpose. It only wants to know who is being hired, who is putting up the money, and how much. It acted in the same spirit and for a similar purpose in passing the Federal Corrupt Practices Act to maintain the integrity of a basic governmental process. They upheld the federal lobby law as it was written, which included the provision influencing. Now, in other circumstances, the U.S. Supreme Court has said that there are problems with the use of the term influence, but that's in the cases of campaign finance disclosure requirements. Even most recently in the case of Citizens United, the U.S. Supreme Court referred to the opinion of U.S. v. Harris and pointed out that lobby disclosure requirements have been upheld as constitutional. And as far as the Texas law is concerned, there is an advisory opinion. It's H-18. It was written or adopted by March 13 of 1973 by John Hill, the Attorney General of Texas. He was looking at the constitutionality of a House Bill 2 that was currently pending in the legislature during the 73 session. And the language in that statute, again, used the same references to influencing legislation as it's written today. And they said, and I'm quoting on paragraph 2 of this opinion, basically, House Bill 2 provides in sections 3 through 5 for registration of those engaged in efforts to influence legislation or administrative action, for activities reports by those required to register, and for a state ethics commission to investigate violations of the Act, render advisory opinions, and to advise other state officers of violation. Although the legislature undoubtedly has the right to so provide for the registration of those engaged in efforts to directly influence legislative or executive action, and to require such registrants to furnish relevant information, the classifications of persons covered and of the information sought must be reasonable so as to not essentially violate the Constitution. And they note that the path to be taken and much of the ground to be avoided was shown by the Supreme Court of the United States in United States versus Harris, construing the federal law. They go on to say that the legislation approved in Harris was construed by the court to cover those who solicit, collect, or receive money or other things of value to directly influence legislation or who engage agents to do so. In our opinion, the regulatory scheme of House Bill 2, requiring registration also of those who spend money or other things of value to directly influence legislative or administrative action, is equally permissible. In selecting monetary parameters for such regulations, the legislature is invested with broad discretion so long as the selection is reasonable. And they further state that at least for purposes of vagueness in a statute is often a fatal vice. And while the courts have sometimes tolerated less precise language in lobby regulatory legislation than they might otherwise do, citing U.S. v. Harris, there are still limits which must be involved. And that opinion goes on to raise some questions about other areas of the law, but those areas were addressed through the legislative process because that was still a bill pending. Ultimately, what the Texas Attorney General's opinion was that there wasn't a problem with the language. There wasn't a problem with the vagueness issue regarding the use of the term influencing legislation in the Texas lobby law. So as far as the objections that this statute is unconstitutional, the United States Supreme Court, the Texas Attorney General, and numerous other courts around the state, around the country, both in federal and state courts, have upheld lobby registration laws. With respect to the definition of legislation itself in the lobby law, I would like to point you to Section 305.004, which is up, or excuse me, 305.002, which is up on that board before you. And it defines legislation as a bill, resolution, amendment, nomination, or other matter pending in either house of the legislature. But it goes on to say, B, any matter that is or may be the subject of action by either house or by a legislative committee, including the introduction, consideration, passage, defeat, approval, or veto of the matter. The definition of legislation is not confined just to what is pending at the time a communication is made. It applies to any matter that may be before the House, either the House or the Senate. That would include the decision of House members of who they're going to elect on the first day of the session as Speaker of the House. If someone is communicating with legislators a month before the session begins, telling them who to support, who to oppose, who to nominate, that's still lobbying because that is still a matter that is subject, it's a matter that may be the subject of action by the House of Representatives. So it doesn't matter for purposes of this case when the individuals whom Empower Texans supported and opposed were nominated. What matters is that there were communications made before the election of the Speaker and that there were actually efforts to influence their votes. Now, regarding scorecards, there's more than just the simple statement that we're grading you and here is your grade. You've seen letters listing Empower Texans' legislative priorities. There are letters advocating for or against Speaker candidates, emails telling members how to vote. Those were all made to influence. It's not just the scorecard that we're talking about. And it also doesn't matter whether or not the individual complainants were aware of all of the documents that are at issue in this case. What matters is that they filed the complaints and they had a legitimate basis for doing so at the time. The Commission accepted jurisdiction over those complaints, and so here we are. We have witnesses who have testified as to where they obtained the documents and what the documents are that were presented to you. They've sworn that they were provided in response to open records requests. They've sworn that they were received from legislative offices and that they were unopened at the time that when Mr. Greenhaw gave them to Mr. Bresnan, they were unopened. And Mr. Bresnan swore that he provided those documents to the Ethics Commission and that they were unaltered. There's plenty of evidence for the Commission to determine that there was a clear chain of custody, that these documents were received from legislators' offices, and that Mr. Sullivan made those communications with the intent to influence. It's the province of this Commission to determine just how credible the witnesses are and how much of their testimony to believe, but there's certainly enough testimony from them, from the both of them, to show to the Commission, to prove by preponderance of the evidence that these were communications made by Mr. Sullivan to members of the legislature. Now, regarding the documents that were provided to Mr. Nixon last Wednesday, they were provided as required by Commission statute, as well as by order of the Commission, that we provide those documents by last Wednesday. That's what we did. And Mr. Nixon had an opportunity to ask the Commission to issue a subpoena to require us to produce those records to him. It even was made available to him at pre-hearing conferences in these proceedings. He never requested that the Commission do so and never filed a motion. And lastly, I would like to read from Section 305.004 of the Government Code, providing an exception, and I will read it in full. A person who, the following persons are not required to register under this chapter. A person who owns, publishes, or is employed by a newspaper or any other regularly published periodical, a radio station, a television station, a wire service, or any other bona fide news medium that in the ordinary course of business disseminates news, letters to the editor, editorial or other comment, or paid advertisements that directly or indirectly oppose or promote legislation or administrative action, comma, if the person does not engage in further or other activities that require registration under this chapter and does not represent another person in connection with influencing legislation or administrative action. It's not the blanket exception that Mr. Nixon is arguing. The legislature included a specific provision that said if you're engaging in other activities that require you to register, then you have to register, which is you're engaging in other activities beyond the dissemination of news on behalf of a bona fide news medium. The number of emails and the letters and the direct communication specifically sent to legislators, not to the general public, not to a mass email list. Those were targeted communications specifically sent to legislators, not news disseminated in the ordinary course of business. It clearly does not fall within that exception. There are plenty of reasons, there's plenty of evidence in the binders that have been given to you to warrant continuation of this hearing and to justify a finding by preponderance of the evidence that Mr. Sullivan was required to register in 2010 and 2011 and that he failed to do so. I ask that Mr. Nixon's motion be dismissed or refused.
Briefly, I want to make 4 points. Mr. Trusloff just admitted to you that the word influence is unconstitutionally vague. He said it. He said, well, I agree. Sometimes it's been held to be vague. You know what that means? It's vague. He also tried to confuse you a little bit by saying it's constitutional to register lobbyists. We've never said it's not. We don't disagree. You may. The state may constitutionally regulate lobbyists. Our argument to you is this statute doesn't do that. Not this one. It has problems, big, serious ones. And it's important. I tell my kids all the time, it's okay to have problems. It's not okay to fail to address them. We can't just ignore the problems of our statute. Now, point number 3. The Supreme Court case of Harris. Harris, the court, essentially rewrote the statute by interpreting it in a way that they said it was constitutional. But they didn't approve the statute on its face. And don't mistake that. Counsel misspoke or is confused. But the court in Harris rewrote the lobby statute that Congress passed regarding itself to make it constitutional because it was otherwise vague. And the strong dissent in that opinion identified the problems in the majority. Now, Mr. Strusloff identified something that I'm just flabbergasted and gave you another reason to stand up and say we got a problem. Legislation is not confined to what's pending before the legislature. How in the world is a citizen of the state of Texas to know what they can say to their representative and when? If at any time any comment can be interpreted as trying to influence even that which is not pending. Do you want that to be the law of this state? That's an unreasonable interpretation. That I wasn't even going to argue with what legislation includes, but when you're told you must consider that which isn't even pending, and there's a huge difference between the Texas statute and the congressional statute. Congressional statute is very narrowed. Does anybody know what the fee is to pay to be a lobbyist in D.C.? It's nothing. You pay no fee. There's no fee to register. And most people don't. It's very narrowly drafted and interpreted and applied. In this state, however, it's a $750 fee to the state of Texas. Now, I'm not going to read this to you, but I'm going to provide everybody one. It's called the Citizen Handbook, How the Legislature Works, and it's printed by the Texas Senate. And it tells everybody what to do. If you go through it, they say, meet candidates and ask them about issues of importance to you. Phone district offices. Meet with legislative staffs. Meet with legislators in their office. Talk about certain bills. Attend hearings and testify. Telephone, write, send telegrams to your legislator. keep the issue before the public with speeches and media coverage, meet or telephone staffs of legislators, check on the progress of bills, invite the legislator to local programs in your area, form a coalition of persons in your area, and support issues of mutual concern. It doesn't say to go register. It doesn't say pay a $750 fee to the state of Texas. So what do you got? You got a bunch of hearsay. You got two people who are upset, and their political consultants told them you ought to file a complaint. One person used it in her campaign. You don't have any hard evidence. You have hearsay. And your staff doesn't even know how to get around the hearsay objection. It's real simple. But they didn't do that. They spent 28 months of sending us crazy interrogatories. The interrogatories were so bad. We tried to answer them, and we sent them tax records and stuff, but they asked for our bank accounts. They asked for the signature cards. They asked for things that this commission doesn't have the authority to investigate. They weren't trying to be reasonable. They instead were trying to make a point. They were being used by the people who filed the complaints to exact a political vendetta. You don't have evidence of a violation of a constitutional statute. I urge you again, dismiss the complaint now, find it to be frivolous, and sanction those who brought it.
Commission declines to grant your motion at this time. You may call your first witness.
Mr. Chairman, I'd like to have a vote of the commission before that ruling is decided by you alone.
Sure. We addressed that.
You addressed it already, or you?
No. We talked about that at one of our prior matters. We need a motion regarding supporting the rule of the chair.
So moved. Second.
Okay. All in favor of supporting the ruling of the chair, say aye.
Aye.
Anyone opposed, say no. The ruling stands. You may call your first witness.
Call Mark Lisheron. We're going to take a moment to connect a
Sure.
projector to the screen.
We object to the calling of Mark Lisheron as a witness.
Give him one of these.
Understand your objection, counsel, and I'm going to let him testify without ruling on your objection at this moment.
Would I be able to voir dire Mr. Lisheron?
Sure. He's taking him on voir dire.
Before I ask him his name?
Yeah.
Okay, if that's the way you want to do it. Mr. Chairman, we have considered, and I want to tell you that I think it's okay if Ms. Truitt is released. I don't anticipate calling her this afternoon.
Counsel?
I have no objection to releasing.
Okay. If you'd let the witness know, Representative Truitt, that she is excused. Counsel.
Good afternoon, Mr. Lisheron.
Good afternoon.
Could you please state your name?
I'm sorry, can you hear me?
Yes, I can hear you. Can you please state your name for the record?
Mark Lisheron.
And what is your occupation?
I'm the deputy editor of watchdog.org.
So watchdog.org, that's your current employer?
Yes.
And what is watchdog.org?
It's an online, national online news organization.
Where does Watchdog.org operate out of? Is it in Texas or?
Our administrative offices are in
Counsel, let's
Alexandria.
focus on his qualifications.
Okay. Okay.
So you don't want me to answer that?
And so what is your current title at Watchdog.org?
Deputy editor.
Okay. So what do you do for Watchdog.org?
As deputy editor, I coordinate a staff. We have bureaus in about 24 states around the country. We also have a national staff. I work with the top editor. I'm second in command. The two of us direct the editorial mission of Watchdog.org.
Do you have any academic degrees?
Yes, I've got 2 degrees.
And what are those?
Journalism and history.
Is that a bachelor's degree? Bachelor of Arts. Bachelor of Arts, okay. And what universities are those from?
The University of Wisconsin-Madison.
Okay. And that's for both?
I'm sorry?
For both,
yes.
Both degrees? Okay. Are those degrees, are they specialized, or is it any specific fields?
No.
I mean, aside from, no specializations, no area of specializations in your
No.
degrees? Okay. What sort of training have you had in the area of news and journalism?
I've spent 34 years in the news business.
Writing as a journalist, or in what capacities?
As a reporter and as an editor.
And for how long were you a reporter?
30 years.
And so, have you been an editor for 4 years, or?
Yes.
Yes. At Watchdog.org, or
yes.
Okay. Is there any sort of a certification, a board certification for journalists or editors?
No.
There's not? Okay.
No.
So who was your employer before you were employed by Watchdog.org?
Immediately before?
Yes. Could you chronologically go back? Who was your immediate employer prior to Watchdog.org?
The Austin American-Statesman.
Okay.
Newspaper.
And how long were you employed at the Austin American-Statesman?
10 years.
And where were you employed before the Austin American-Statesman?
The Milwaukee Journal-Sentinel.
And how long were you employed for the Sentinel?
It was the Milwaukee Journal when I joined it, and then the Milwaukee Journal-Sentinel, and I was there for 14 years.
Okay. Do you teach or lecture in the areas of journalism or the journalistic field?
I have been a guest lecturer for the past 8 years, roughly 8 years, at the University of Texas, both in their schools of journalism and the School of Law. I'm currently teaching a 3-credit journalism course, online course through the University of California, Irvine.
And as guest lecturer, what were the topics that you lectured on?
A variety of media topics. In journalism classes, mostly techniques of reporting, editing, ethical issues involving journalism. On the law school side, how media interacts with the law, and how to. I teach a human rights course, and or guest lecture, and talk about getting human rights issues into the media.
Have you lectured about the field or the practice of media in general, like of what a news organization is?
Yes.
And was that for at the School of Journalism at the University of Texas? Is that what that was?
In all of those capacities that I spoke of.
Okay. Do you belong to any professional societies or organizations?
Yes.
And what are those?
I'm on the board of directors of the Freedom of Information Foundation of Texas.
Are there others?
Not journalism related.
Not related to journalism? Okay. Do you have any publications in the field of journalism?
Beyond...
I'm sorry, I should rephrase it. Publications, I mean like academic journals or professional journals, not news stories or news articles.
Well, if I'm... I'll just say it. For the past 18 years, I've been a senior contributing writer for American Journalism Review, which is journalism periodicals in the field. I've been doing media analysis, both newspapers, new media, analysis and criticism of the media industry.
And has that been for the American Journalist Review?
It's American Journalism Review.
Okay. Have you provided testimony in any court proceedings before?
No.
So you've never testified as an expert witness before?
No.
Have you ever consulted for anyone regarding the field of journalism or news?
No.
Did you conduct any examination of documents in preparing for this case?
No.
So you didn't look at Empower Texans' website?
I've looked at Empower Texans' website many times.
But in preparation for your expert testimony today, did you review?
No more or less than the number of times I've looked at Empower Texans' website, and I would do that normally in my field.
So in preparing for your testimony, what did you review today? Or what did you review in preparation for your testimony today?
I did talk a bit about the media exception and looked at that statute, and I did discuss that with Mr. Sullivan's attorneys.
So you looked at the particular provision of law that Mr. Nixon is stating exempts Mr. Sullivan?
Yes.
What else did you look at?
I can't think of anything else.
So did you look at Mr. Sullivan's publications or his writings or his articles?
Other than what I've seen on Empowered Texans, and Mr. Sullivan also writes editorials and op-ed pieces that appear in other places. Those are the only publications I can speak to.
So on Empower Texans' website, what exactly did you review for purposes of your opinion?
Well, not for my opinion. I regularly go to Empower Texans' website because as one of the, I consider it one of the top conservative news websites. Thing about what's going on with conservative politics in the state of Texas if you don't at least consult Empower Texans.
Did you review any of Empower Texans' organizational documents?
No.
Did you review any of Empower Texans' internal documents? I mean, like meeting minutes or?
No, I don't think I would have been privy to those.
Okay. Did you look at any of the documents that are at issue in this case? Any of the exhibits?
No, I was asked for my opinion as a media expert.
Did you speak to Mr. Sullivan at all about your testimony?
No.
So you didn't ask him about what he does for Empower Texans or what he writes?
In my capacity as a reporter in the past, I've spoken to Mr. Sullivan about what he does with Empower Texans, but beyond journalism questions, no.
And in the past, I mean, what did Mr. Sullivan tell you when you have spoken with him in the past?
Well, beyond him being an advocate and being what I would consider a news gatherer, an advocate, that's pretty much the confines of that discussion.
Okay. Have you prepared any sort of a report based on your testimony today or your anticipated testimony?
No, and I did not want to give up my iPad.
Did you take any notes from in the process of preparing your testimony?
I did not want those confiscated either. I did not take a note.
Oh, you did not take it. Okay.
Sorry, I didn't mean to be flip.
No.
No, not a note.
Okay. Well, I don't have any additional questions, but I would like to object to his providing testimony of if he's going to be providing an expert opinion as to Empower Texans being a news organization, he has to do more than just look at their website. I mean, he hasn't seen the documents in these cases. He doesn't know the specific communications are at issue. I don't think he has enough of a basis to just say that Empower Texans is a news organization when the only thing that he's done is looked at their website.
That goes to the weight of his testimony, not at the admissibility. Your objection's overruled. Counsel?
Mr. Lucheron, thank you very much for your background. Let me fill in a couple of places. The American Journalism Review, is that associated with the university?
The University of Maryland.
Okay. And it's one of the top two or three media analysis and critical journals in America?
Yes.
All right. Have you done any writing that for them that was grant-based?
Yes.
What was it?
We embarked on a series of stories. There were 3 of them, and I was assigned one. The purpose of my story, in fact, the purpose of all 3 stories was to investigate the result of what I call legacy media leaving state houses across the country. And my specific role in the series was to talk about how new media, mostly online or digital media, was beginning to take the place of and supplement the coverage at state houses because we're in a kind of a critical state with newspapers losing staff, television stations pulling out of state houses, and that was was an 8,000-word piece, rather in depth.
An in-depth study of online journalists only reporting about state house news.
Not online journalism only,
right,
but primarily about those success stories in new media.
All right. Let's back up a little bit. You graduated from the University of Wisconsin in Madison, and then what'd you do?
I started, my first job was stringing, which would be freelance work with the Capital Times in Madison, Wisconsin.
What did you do next?
From there, I took my first daily newspaper job at the Tyler Morning Telegraph in Tyler, Texas, in 1980. I was there for 2 years. I won a couple of awards there, so I got stolen away by the prestigious Beaumont Enterprise. I was there until 1984. I wanted to make my way back to closer to the Milwaukee Journal, which was a job that I wanted. I took a job with the Waukesha Freeman, which is just outside of Milwaukee. Did that for 2 years. Started with the Milwaukee Journal in 1986 and was there until the end of 1999 when I went to work for the Austin American-Statesman.
Tell us some of the things you did for the Austin American-Statesman.
I was hired. I was hired to do large magazine style takeouts. When I was hired, by takeout I mean big picture, 2,000, 3,000 word stories that were designed for the front page.
By the way, how did you end up coming from Milwaukee back to Texas?
I got a cold call from one of the editors at the Statesman who had seen some of my magazine work in American Journalism Review, and they were interested in hiring someone who could write magazine-style stories for the paper.
Okay, so let's get back to what you were doing for the Statesman. How long did you do the magazine-style stories?
About 4 years. After that, I was asked by one of our editors, we were reviving our investigative team, and I was asked to anchor a team of 4 investigative reporters. I did that for 3.5 years, I think.
Okay. And then in 2010, you went to work for watchdog.org.
Yes, well, it's actually Texas Watchdog. It was a part of the Watchdog Network. I went to work as their first Austin bureau chief. I was basically covering state government for them for the first time.
Only digital?
Yes.
No print?
No print.
And then you're the deputy editor of all of watchdog.org.
I was a national reporter for a brief time, and then asked to step up to deputy editor.
You mentioned you won some awards while with the Beaumont Journal. Those aren't the only awards you have won, are they?
No, and I'm not going to pretend for anyone in the room that I will remember all of these, but to my best recollection, would you like me to tick them off?
Well, let's just talk about the AP and UPI awards for now.
Okay. I may be underestimating, but I can think of at least 6 Associated Press first place writing awards and at least 2 United Press International awards.
Now, my understanding is while you were with the Austin American-Statesman, you were nominated on 3 different occasions for a Pulitzer Prize awards.
That's true.
All right. Now those aren't. That isn't it. I mean, if you won any other awards.
Yes, I won the Stanley Walker Award, which is presented by the Texas Institute of Letters. It's their top journalism award. And in 2011, I won the Society of Professional Journalists Award. They gave out a First Amendment Award for a series of stories that I did on how the stimulus played out in Texas.
All right. Yeah. You said you've been to the Empower Texans webpage.
Yes, I have.
Listen. Just warming up. I don't know if it's good news or bad news, Mr. Chairman, but I've been told I have 2 hours left. I still have half my time.
Oh, I assure you that's good news.
Okay. Are you able to see the screen?
Yes.
All right. Do you know what that is?
It's the Empower Texans website.
And this is the one you've been going to for years?
Yes.
Okay. What sections do you go to?
Almost always. News, primarily news. Who represents me? Scorecard. And that would be pretty much it. I look mostly for news and commentary.
Do you find news and commentary under news?
Yes.
Let's quickly go to Scorecard. Have you been there before?
Yes.
Scroll down. I want to make note. Have you seen this statement? lawmakers and their offices are notified in advance of TFR position on the issues rated and prior votes taken on the floor.
Yes.
Is that reporting?
Absolutely. It's you're offering information to the public, and I consider it a public service to have to lay out in advance how you're going to grade legislators.
Is this the only scorecard that you go to or have seen?
Well, no. Many advocacy organizations use scorecards, but so do news sites. The Texas Tribune does a scorecard.
Is this the Texas Tribune scorecard?
One of them. They also offer during the legislative session. They offer the public, their reading public, a chance to make their own scorecard, and they do the same thing. They tell you in advance what you'll be graded on, and so both the professionals and the public on Texas Tribune offers scorecards.
Let's go back up to the top. Is there any description of how these votes were tabulated or done here?
No, not well. I mean, not that I can see.
All right. Who else does scorecarding in Texas?
Not a graded scorecard, but the one I'm most familiar with is Texas Monthly.
Let's take a look at that. They do top 10 and
best and worst. Yeah.
Best and worst. Do you consider that a scorecard?
Absolutely, and I believe Paul Burka, who does it, also lays out his criteria for why he voted or why he put one on the best list or one on the worst list.
Let's go to the watchdog.org webpage. Is that your webpage?
Yes.
That looks remarkable like the Empower Texans webpage, doesn't it?
Yes.
Home, states, national news, video, watch blog, same kind of information. But yours is on a more national basis and can do many states, right?
Yes. Primarily news and commentary.
Now, is this new media? Is what you're doing? Is that what we hear as the term new media?
Yeah, new media is, if I can go on.
Yeah,
new media is.
What is new media?
Well, it's kind of a catch-all phrase for media that's sprung up since the advent of the internet. It's and the reasons are myriad for why websites have sprung up. There are. For example, when I did my series on websites helping out at the coverage of the State House, there are literally hundreds of ex-newspaper people who started their own blogs based on original reporting without even taking any pay. I would consider that new media. There's also not unlike and I spent a 6-month stint on the editorial board at the Austin American-Statesman. Many of the new media sites take original reporting, like Mr. Sullivan does, take original reporting and use it as an instrument to advocate. I did exactly the same thing when I would interview legislators for editorials that I wrote, advocating for a position or for a vote on a bill on the editorial board at the Austin American-Statesman.
Well, I note that our exemption here, and you and I had a chance to go over it, but it was written in 1992. That's when it passed. The exemption, the media exemption in the Texas statute passed in 1992. Was the internet something utilized at that time?
No.
Some people talk about old media versus new media. What's your thought on that?
Well, I think one of the reasons why it's easy to embrace new media is that it does so many more things than, and I've spent a career in old media. And I think all of the boundaries have been pushed, and I think people are far more informed with new media than old media. And I might also point out that new media looks a heck of a lot like old media. I liken some of the more informed blogs to like the pamphleteers, like a Tom Paine during the Revolutionary period. Or there were a whole body of left-wing and socialist journalists at the turn of the century, the muckrakers, whose sole purpose for gathering news was to change policy, to change minds, to change legislation. And they were activist journalists. I think it's only recently in our history where you've tried to compartmentalize journalism in a certain way. Well, that's been blown up by the new media.
And so what you're saying is that you're sort of going back to the days when news and advocacy were combined.
Combined sometimes, but not necessarily always. And I think that's why some people wrestle with the issue.
Are you familiar with the term yellow journalism?
Yes.
What does that mean?
Well, yellow or sensational journalism.
Yes.
Around at the same time, roughly as the muckrakers, you had corporate journalists like Hearst, who sold newspapers by making stories and covering events in as sensational a way as possible. Some people would say yellow journalism was irresponsible, but it sold a lot of papers.
Have you been to the Daily Kos website?
Yes.
Kos, K-O-S. Is there any real difference between Empower Texans and the Daily Kos?
Yes, there's a big difference.
What's that?
Sullivan's website is very conservative, and Daily Kos just as advocacy-based, but it's a left-wing website. I mean, if you spend
other than content, one's from the right, one's from the left.
Well, yes, they're both websites that use journalism to advocate.
Otherwise, they're the same.
Yes.
Okay. All right. Now, let's get to the heart of this. Based upon your 34 years of experience as a journalist, in media, as a scholar, as an editor, as an award-winning writer, as an instructor at UC Irvine and at the University of Texas, do you have an opinion on whether or not Empower Texas is a bona fide news medium?
Yes.
What is your opinion?
Empower Texans is a bona fide news medium.
Pass the witness.
Counsel.
I'll wait a moment.
They got very dry.
It's all right. I understand. So, Mr. Lischron, were you paid for your testimony today?
I'm glad you asked. Yes, I was offered a fee, but I've made an arrangement to give that fee as a donation to the Freedom of Information Foundation of Texas, which I mentioned I was a board member.
So it was offered to you, and you had the discretion to decide where it would be donated?
I asked the attorneys who called me in as an expert witness to make a donation to the Freedom of Information Foundation of Texas on my behalf.
Okay. And what was the amount of that donation?
I'm still on the stand, so I think the fee is based on how much time I've been spending here. The fee wasn't settled.
So is it based on an hourly rate of how long your testimony lasts, or?
It was not discussed.
Okay. So it's an unspecified, it would be an unspecified donation?
We didn't talk about it because I wanted it to be a donation and not a payment to me. I assumed that we could talk about the details later.
Okay. So it's going to be decided, in other words, after your testimony today?
The amount.
The amount, correct.
Yes.
Okay. Do you know Mr. Sullivan personally?
I'd say more professionally. We've never socialized. I like Mr. Sullivan, but I can't really say that we're friends.
How long have you been aware of Mr. Sullivan?
Well, I've been in Austin since 2000, and Mr. Sullivan's been on the scene for most, if not all, of that time.
Were you following the Empower Texans website in 2010?
Not following it. Again, going to it. I'm not slavish, but yeah, I follow the issues.
And were you so you were visiting their website in 2010?
I'm not honestly sure when the website went up. I've been going to Empower Texans from the time that the website existed. Yes, but if you ask me when the site went up, I couldn't tell you.
So in 2010, you don't know what their website appeared to be, how their website appeared, what it looked like, what was on it, what its content was? Let me rephrase. In 2010, what was posted on Empower Texans' website?
I don't believe it's significantly different than what's on their website today.
Do you know what sort of information was posted specifically? What sort of articles was posted?
I would assume that it was a mix of news and commentary, pretty much the way it is today. Mr. Sullivan's made no bones about advocating, but there's always been a news component as well as a commentary component.
Were you visiting their website in 2011?
Yes.
How often were you visiting their website in 2010 and 2011?
Specifically, maybe once a week. That'll be my best guess.
And do you know what was posted to their website in 2011?
I'll provide the same answer. I would have said. I would assume. I can't answer about specific stories or specific issues in that year. I'm assuming that it would be a mix of news and commentary.
Okay, but you don't know for sure.
Well, yes, I do know for sure.
Okay.
That it was a mix of news and commentary, but I can't be more specific than that.
What's the difference between news and commentary?
That's a good question. News is fact-based, events, observation. Commentary is the use of that information to make a point.
To make what sort of point? Do you mean like a...
Whatever your point is.
Okay. Like a political point?
Yes.
Advocacy?
Yes.
Lobbying?
I can't speak to a point about lobbying. It's lobbying. I'm not an expert about lobby law or lobbying.
Are you aware of the of the exception that Mr. Nixon has addressed in the exception in the lobby law for someone who's employed by a bona fide news organization?
I believe I testified that Mr. Nixon and I talked about that.
Okay.
About that exception, and we read it over together.
And do you know how long that exception has been in the law?
I believe it's 1992 or 93. I'm not sure. I am not sure.
Okay. Would you be surprised if there was a bill written in 1975 and adopted in 1975 that included the language, the following persons are not required to register under the provisions of this act: persons who own, publish, or are employed by a newspaper or other regularly published periodical, or a radio station, television station, wire service, or other bona fide news medium which in the ordinary course of business disseminates news, letters to the editors, editorial or other comment, or paid advertisements which directly or indirectly oppose or promote legislation, if such persons engage in no further or other activities and represent no other persons in connection with influencing legislation. Would it surprise you if that existed in the law in 1975?
The witnesses' surprise or lack thereof is not relevant.
I'll allow it.
I guess I wouldn't be surprised. I wouldn't be surprised.
Okay. So you said earlier that you were taking a position on a bill when you were with the Austin American Statesman, and you published an editorial. Is that right? Or did I mischaracterize what you said?
Yes.
Okay.
I published. I didn't publish. Our newspaper published, but I was the author of dozens of editorials, and I believe in my testimony what I was, or at least what I was trying to convey, was that in the act of producing those editorials, I would do original reporting, and I would marshal original reporting to make a point. And often it would be to advocate for a policy change. It could be to take a legislator to task for something that I believe they did or didn't do. But the point was, it was the gathering of facts to marshal an argument in the form of a written editorial, and I did that many times.
And were those editorials opposing or supporting legislation?
Yes.
And how were those editorials published?
Published in the. They appeared in the editorial section of our newspaper. Did I answer that correct?
Yes, you did. Well, you answered it. So, did you send copies of that editorial to legislators, or any of those editorials to legislators?
Well, by the time I was on the editorial board, I was able to send links. Very often, I would send. I think it's common if you do an editorial that you're proud of. You would send it to anybody that you wanted to see that editorial, and as far as I was concerned, the wider the distribution of my editorial, the more impact it would have. And yes, legislators got my editorials.
And did you send them to legislators personally, or how were they sent to legislators?
I would usually send them in email form with a link to the editorial.
So you would send it to them as an email, just an email to their House email address, or their House or Senate email address?
Yes, or to staff if I didn't have a personal email address, or I mean a specific to the House or Senate member.
Okay.
37 minutes.
Okay. Just a moment. Mr. Lishron, do you recall an article written for Texas Watchdog, April 4 of 2012, titled "Republican Infighting or Ethics Problem? Conservative Activists Failed to Register as Lobbyists as Required According to Ethics Complaint"?
No, I don't.
Written by you?
Oh, yes.
Okay. Let me pull that up just for 1 moment, please. Okay, I'll let you look at this. Here's it. So do you recall writing this article,
I
Mr.
do.
Lishron?
Yes.
Okay. And it's addressing these complaints that were filed with the commission, is that right?
Yes.
And in this article, you refer to Mr. Sullivan as a conservative activist, is that correct?
Yes.
But you didn't refer to him as a journalist?
No.
Do you recall any discussions that you had with Mr. Sullivan at that time regarding this particular article?
Having seen the story, I recall the conversation about the political motivation.
Did Mr. Sullivan represent to you at that time that he was a journalist or a reporter?
We've never had that discussion.
Okay.
By the way, I don't refer to myself as a journalist either.
How do you refer to yourself?
As an editor.
Okay. I would like to refer you to documents that are in that large notebook that's in front of you, if you could. Big black binder.
Okay.
And if you could please turn to Exhibit 13 in that notebook.
Oh, I'm sorry.
It's the large one. Are you at tab 13?
Yes.
Okay. Could you please turn to page 296? That's behind that tab. And what does that article appear to be? Or, excuse me, what does that that document appear to be?
It appears to be a memo from Michael Quinn Sullivan to honorable members of the Texas House with the subject vote on HB 5.
Okay. And can you read the first two paragraphs in that document?
On the House calendar for today is House Bill 5, allowing Texas to enter the Healthcare Compact. The Healthcare Compact empowers Texas, not Washington, D.C. bureaucrats, with the responsibility and authority to regulate Texas's healthcare. As you know, we support House Bill 5 and will positively score it on the Fiscal Responsibility Index. We encourage members of the Texas House to vote for the Healthcare Compact and HB 5. You can learn more about the compact at http://www.healthcarecompact.org.
Okay. So, Mr. Listron, is that news?
Yes.
In what way is that news?
There's in many ways. You have a bill that's coming up before the House, House Bill 5. We're talking about health care. I would assume that this is of great interest to the public.
Was this email sent to the public?
It was sent to members of the Texas House.
Okay.
I'm assuming based on what it says here.
Okay. So if it was sent to specifically to members of the Texas House, in your opinion, a specific directive that legislators vote in a particular way on a particular bill is news?
You mean the act of asking that? Asking
Well,
for that vote?
I mean the email itself.
Not unless the email was given to a member of the media who could report on that.
But the email itself, is it a news story?
The email itself, no.
Is it a periodical?
I'm not sure I understand the question.
I mean, the email itself, is it a periodical, is it a news story, or is it an editorial?
None of the above.
Okay.
Counsel, you have 30 minutes left.
Can you look at page 297, please? It's the very next page.
Yes.
And what does that document appear to be?
It appears to be similar to the one I just read.
Can you read the first two paragraphs in that document?
As with other fiscal matters, legislation, votes on amendments to Senate Bills 1 and 2 today are subject to scoring on the Fiscal Responsibility Index based on our general principles and the legislative priorities noted at the start of the regular session. There will be a number of very good amendments by your colleagues today that we encourage you to support, reducing tax burdens, increasing transparency, and protecting taxpayers.
Is that document a news story?
The document itself is not a news story.
Is it an editorial?
No.
And why is it not a news story or an editorial?
Because it's delivered to members of the Texas House, and it's not delivered to the public.
So if it were delivered to the public, then it could be a news story or an editorial.
Well, I think I can answer it this way. These positions in these emails, both of the emails that I read, are positions that I've seen on his website about both of these issues. So I believe that he's made those positions public, treating them as a news story, but you're asking me to answer a question about these documents, and I can only tell you that they appear to be emails to me.
But they're different. They're not posted on Empower Texans' website, to your knowledge. At least they don't appear to be published on Empower Texans' website, those particular documents.
Not in that format.
Can you turn to Exhibit 16, please, in your notebook? And I would like you, if you could, please turn to page 420 behind that tab 16. What is that a document? What does that document appear to be?
It says on the top it's a memorandum.
Okay. And is that letterhead from Empower Texans for Fiscal Responsibility at the top? Is that what that appears to be?
It says that, yes.
Okay. And can you read the first two paragraphs in that document?
It is possible that within the next week or so, the Texas House will consider legislation enabling the use of the Economic Stabilization Fund for the current biennium. We oppose taking such an action at this time and will negatively score such an action on the 2011 Fiscal Responsibility Index.
So if that document was sent to members of the Texas legislature and no one else, in your opinion, would that memorandum be a news story?
The memorandum, if it fell into a reporter's hands, it would certainly be a great news story.
No, not the fact that it was sent. I'm talking about the document itself.
I think I see what you're driving at. And are you suggesting that news cannot be conveyed via email? Are you suggesting that news cannot be conveyed via text?
I'm asking a question.
Well, I would suggest that, and because we do this all the time with stories and commentary that we write at watchdog.org, we make use of all social media to get our news and our commentary out into the world. This appears to me to be an extension of what Michael Quinn Sullivan does on his website, and he is directing this memorandum to specific people. That's my interpretation of it.
But in your capacity as you're as editor with deputy editor with Watchdog.org, do you have a practice of sending communications specifically to legislators only, telling them how to vote?
Not specifically legislators only, but legislators, yes.
But you don't send them only to legislators. If you wanted to express your view on legislation, how would you make legislators known? How would you make legislators know about your view?
As a bona fide member of what I consider the new media, we are not in the advocacy business to the extent that Mr. Sullivan is. We both gather news. I would consider both of us journalists, but we deliver our news in a different way than Mr. Sullivan, who, from what I can see, makes no bones about his advocacy.
Is there an adopted code of ethics for journalists?
No. There are organizations that have codes of ethics, Society of Professional Journalists, whatever, but there is no code of ethics for journalists.
Is there any sort of a generally acceptable form that a form of writing, of gathering information, of disseminating news that journalists tend to follow?
I think I pointed out in my testimony that one of the things that's occurred with this explosion of new media, that there are a million different ways to deliver journalism, to create journalism, to disseminate journalism, and any attempt to try to say that there is one rule or one set of rules for how journalism is delivered these days is obsolete.
Do you know if Empower Texans operates with any sort of code of ethics?
I don't know that at all.
Do you know if they've adopted any sort of an editorial policy?
No, I don't know that.
Okay. I have no further questions.
Counsel?
Could somebody scroll that to the bottom of the media exemption? I'm dying to read the rest of it. We were on the actual language earlier. This is the advocacy. Okay. That's the current definition, not the 1975 version. Yes. Okay. Thank you.
Yes. We'll have a chance to talk about the whole thing in my close. Testimony has been very helpful, and thank you. Just a couple of little deals. Under the surprise theory of questioning, would it surprise you to learn that the Federal Election Commission has ruled that Daily Kos is a bona fide member of the media?
No, it wouldn't surprise me at all.
They did it on September 4th, 2007. Are you familiar with the SHIELD law in Texas?
Yes.
What is it?
It's a law that the legislature passed to allow reporters to protect their sources and not be prosecuted for it.
And with whom were you employed when it was passing?
The Austin American-Statesman.
Did the Statesman advocate in favor of the SHIELD law?
Absolutely.
Did the Statesman have reporters with media credentials on the House floor?
Yes.
Were they the only news media that had credentialed employees on the House and Senate floors while the SHIELD law was being debated and discussed that session? Was the Statesman it, or were there others?
No, I would assume that I can be pretty sure that there were representatives from all the major media.
So you're telling me that while an important piece of legislation was being debated in the Texas legislature, members of the media themselves were allowed on the floor of the House and Senate and lobbied in favor of that piece of legislation? While the newspapers were writing editorials in favor of it?
Can you give me the question again?
I don't know that I can do it as well as I did at that time, but I'll try, just for Mr. Ramsey. I was trying to feign some shock and surprise, but let's just go through it. So, while an important piece of legislation was being debated on the House floor, members of the media were on the floor lobbying in favor of that piece of legislation.
They might have been. I can't speculate on what individual reporters were doing on the House floor, but I will say they were on the House floor while that legislation was being debated.
Did the Statesman, or I know it did when I was a member of the legislature, but do you know whether they delivered the copy of the newspaper to everybody every day? Every member every day?
I think at the time that we were, how should I put this? That our resources were being stretched. We might not have done that practice, but there is a news service at the Capitol that gathers up all relevant clips from all of the media, including the Austin American-Statesman, and makes that available not only to reporters, but I believe it's made available to members of the legislature as well.
Sure, it's clipping service.
Clipping service,
and you
yes.
you get a stack every day.
Yes.
And now it probably comes by what? Internet, probably, huh?
I don't know that for sure, but it would seem smart.
Have you ever been to the Quorum Report webpage?
Yes.
What is that? What are they? Quorum Report. What is a Quorum Report?
It's the Quorum Report is a subscription, all digital subscription news service based here in Austin.
The news service. I see that they have a quote of the day. I guess you were here. On the advice of counsel, I'm not going to be testifying today. The quote du jour. I've not seen a quote du jour for yesterday. Is Harvey Kronberg part of the new media?
Absolutely.
So let's focus again. Journalism, a journalist, is that a subset of media?
Yes.
Editor is a subset of media?
Yes.
Okay. The test isn't whether or not you're a journalist. The test is, are you other bona fide news medium that in the ordinary course of business disseminates news, letters to the editor, editorial, or other comment? Clarify one more time, is Empower Texas bona fide news media?
As I'm looking at that definition, Empower Texans, and I'll say this emphatically, is a bona fide news medium.
Thank you. That's it.
Thank you for your testimony here today. Just a very few quick questions. Watchdog.org, what's the business model?
It's we're a 501c3. We're a nonprofit.
Okay, no ads on there.
I've seen ads, but we are not ad based. I don't often get involved with the business side.
So you're more on the writing, reporting,
yes,
you're not on the business
we are
side.
donor based.
Yeah. It was stunning. No, I can't even remember. It was no. He's on the writing side of the house, not the business side. I think that was the point I was making. Quickly, you were here for Mr. Nixon's opening, and he said that if a conglomerate owns any news media, then the rest of the conglomerate is exempt from lobby registration. I understand you're not a lawyer. You said you're not a lobby expert, but that was news to me, and I've been around this stuff for a while. Do you understand that that's true, that any conglomerate that wants to avoid lobby registration can just buy a little media outlet somewhere and they're good to go? Have you ever heard that before?
Because I was hearing it from Mr. Nixon for the first time, I would, before I rendered an expert opinion on it, I would want to examine that.
I'm wanting to ask, have you ever heard that before? Yes or no?
Well, it's not.
Yes or no?
That specific statement, no.
Right. Okay. All right. Now, there's something in the
Mr.
law.
Hobby, I can read to you how the Supreme Court considered that very issue in Citizens United, and in fact use the term conglomerate.
All right.
Well, I'll
question you later. Let's go back to the media exception here, because in the law there's something that says when the exception swallows the rule, there's no more rule. Scroll down. Let's look at the plain language. Again, you're not a lawyer, but the first rule of statutory interpretation is to read it. Start with if. Can you read that to me?
If the person does not engage in further or other activities that require registration administration under this chapter and does not represent another person in connection with influencing legislation or administrative action.
Okay. What does that say to you about the media exception in Texas? Does it say you can do a little bit of media and get that pixie dust effect and it covers everything else you do, or does it say you only have to do media?
I think it's so vague as to be unhelpful.
Okay. Okay. Well done. That's it.
For the record, I did not go over this section of the statute with him. That was true.
But he's a good learner and a good listener. He's been here all day.
All right. Whose turn is it to ask the? I think your turn, Mr. Nixon.
Yeah. If I may, and I just want to address Mr. Hobby's question.
Commissioner Hobby, please.
Commissioner Hobby. Said the exemption results in further separate reason for finding the law invalid, in reference to the media exemption. Again, by its own term, the law exempts some corporations but covers others, even though both have the need or motive to communicate their views. The exemption applies to media corporations owned or controlled by corporations that have diverse and substantial investments and participate in endeavors other than news. So, even assuming the most doubtful proposition that a news organization has the right to speak when others do not, the exemption would allow a conglomerate that owns both a media business and an unrelated business to influence or control the media in order to advance its overall business interest. At the same time, some other corporation with an identical business interest but no media outlet in its ownership structure would be forbidden to speak or inform the public without the same issue. This differential treatment cannot be squared with the First Amendment.
But you agree that this language exempts the conglomerate? Whatever you're talking about, that language somewhere else, that's not that.
That's the.
If you do it, you got to do it all day.
Yeah, and that's the point, is that this is a very, very broad, poorly written exception, except for the fact that if it was narrowly drafted, you don't get around the fact that media doesn't have any special First Amendment privileges. And so it's a tough deal for the commission to be confronted with, but you're damned if you do and damned if you don't. But this is, and I agree with him, and we've had many, many discussions over the last several weeks over what the heck does the bottom part of this statute mean. If you don't do anything else, but wait a minute, it doesn't define what that is. And so you got to come back again to clear First Amendment law and say, if I can't figure it out clearly, then the restriction is invalid. But in this situation, truthfully, it's so broad and so overly poorly drafted that almost everybody is exempt if they own some kind of media outlet. And remember the bottom part, if we scroll to the bottom, that's a binary test. If the person, one, does not engage in other or further activities and does not represent another person. So you have to do two things. This is conjunctive. So you have to be this and this. Well, first of all, even if we could figure out what the first preposition means, if you weren't doing it for somebody, for company B, I'm fine. I'm fine. I have 2 hours.
I'm just saying, it's easy to criticize the legislature. If every board or commission just came to work and said, I criticize the legislature for it, I refuse to do my best to interpret that language, I'm going to go home until I fix it. You must be happening around.
Well, maybe a lot of good things would be happening around state government. I mean, in relation to that, but the point is, this is not a situation situation where you say, I don't like the language, you have been given very clear instruction from our United States Supreme Court. And here's what. Okay, I'm going to pass the witness at this time. I don't have any other questions, but I didn't want to engage you in that conversation.
Any more questions, Council?
No further questions, Mr. Chairman.
We have no further witnesses. We rest.
Very good. Council, we've sort of created a little charge for us as commissioners based on the lobby registration statute. Do you have that? Can you have that? We're going to take a 10-minute break as you all get ready for closing. But I did want you to see the analysis that we received regarding what we think these elements are, so that y'all, if you need to carry the arguments. Will you hand those out to us? All right.
Is there some place in the Texas Register I could go look to see what rule you utilize to charge yourself?
No. You'd have to go to the government code and try to put it in. That's where it all is. But I think for our help in analyzing these issues before us, we wanted to have it all in one place.
Okay. And we did not have an opportunity to participate in the drafting of that charge?
Nor did the commission. All right.
We're in recess, 10 minutes.
Pretty good background, isn't it?
All right, we're back on the record in formal hearing, SC 3120487 and 3120488. Mr. Suslos,
Yes, Mr. Chairman.
are you ready to close?
I am.
Please.
And I'd also like the chair beforehand, Mr. Bresnan is still here. Is he excused?
Yes.
Okay. Thank you. Mr. Chairman and members of the commission, this is a case about transparency in state government. The Texas lobby law requires people to register when they are paid to influence legislators and legislative staff. The elements of a violation of the lobby law are up on that board, and they've also been indicated in the charges that were distributed. And essentially, they are this: if a person communicates directly with a member of the legislature, including a member of the legislature and an employee of the legislature, with the purpose to influence legislation, and they're making that communication as a part of their regular employment, and their employer is paying them over $1,000 in a calendar quarter to make those communications, then that person has to register. It's important to point out again that the definition of legislation as provided by the Texas legislature is the definition that the commission is required to apply, and that's set out in section 305.002 subsection 6. And it is very broadly written to not only include bills, resolutions, amendments, nominations, and other matters that are pending in a House, but it also includes any matter that is or may be the subject of action by either House. And that would include the matter of the election of the Speaker of the House. And to find otherwise, to find that the lobby law only applies to a bill or some matter that is currently pending at that time, would mean that any person could communicate with legislators by giving them a draft of a bill to propose, asking them to push it through the House and make it law. Those communications would be completely exempt because they wouldn't be legislation. And that doesn't make any sense. It's any matter that is or may be the subject of action by either House. And that would include asking someone in December of 2010 to support a particular individual for Speaker of the House, or to not vote for any bills that are going to increase taxes, or asking them to support a bill that's going to increase a tax, let's say the gasoline tax. It doesn't matter whether it's currently been introduced by a member. It doesn't matter whether it's pending on the floor at that time. If it's subject to action, if it may be subject to action by the House, then it is legislation, and that's the definition that we have. Now, the evidence before you it includes testimony from Mr. Bresnan and Mr. Greenhall regarding the documents that are at issue in this case. They've testified that those documents originated from the offices of legislators. And the content of those documents also indicate that they were made not only by Mr. Sullivan, but they were made by Mr. Sullivan on behalf of his employer. And they were part of his employment as president of Empower Texans. The content of the communications themselves is plain enough to show that they were made with the purpose of influencing legislators. He specifically told them how to vote, and in other cases they listed the priorities of Empower Texans. You've seen scorecard notices that were sent out before the votes were issued, and notices stating that legislators were going to be graded. And in those circumstances where the intent is to influence legislators, then even those notices about the scorecards are subject to the lobby law, because it depends on whether they were made with the intent to influence. And the intent behind the scorecards is clear, and it is essentially that here are our legislative priorities. This is what we stand for. We're going to issue a scorecard at the end of the session. You're going to be graded based on how you perform. And in the end, we'll give you an A if you do very well, if you vote in accordance with our goals. Or you're going to get a C, or worse, you're going to get an F. Now, some legislators may not be swayed by that. Some may. It doesn't matter. What matters is whether they were made with the intent to influence them. The Form 990s that are also introduced in evidence, they show Mr. Sullivan's salary during 2010 and 2011. They show that he was paid over $1,000 in each calendar quarter of those years. And so the compensation threshold was clearly exceeded in these cases for both calendar years. Mr. Sullivan met all of the elements under the registration requirement based on compensation and based on lobbying as part of regular employment. And again, the issue is not whether a citizen of this state has the right to petition their government. They clearly do. And the law does not require every person in this state to register just because they happen to send their legislator a letter, or because they call them on the phone, or send them a text message, or send them a tweet. What matters is that the Texas legislature has set out certain boundaries to say, if you are acting within these boundaries, in other words, if you're spending certain amounts of money, or you're receiving certain amounts of money to influence the state legislature or members of the executive branch, then you have to register. And the fee, there is a fee required for a person to register as a lobbyist in this state. It's not always $750. In many cases, it's actually $150. If you are an employee of a 501c3, C4, or C6 organization, and that's the only person who you're lobbying on behalf of, $150 is your fee. That's not a burdensome amount. Now, Mr. Nixon has argued that Mr. Sullivan was exempt from the lobby law because he's a journalist. But there's no evidence that Empower Texans was an actual news organization during this time in question. You have one man's opinion. And Mr. Licheron did not review the documents in this case to coming to his opinion. He had some familiarity with their website in 2010, 2011, but could not specify as to what the actual contents of the website were at that time. And it doesn't matter that Mr. Sullivan happens to write for some other organization, whether it's Breitbart Texas or some other website. It doesn't matter whether he's doing that now. What matters is the activity during 2010 and 2011. Now, Section 305.004A of the Government Code creates an exception, but you're only exempt if you're communicating in the form of news, if your actions are the dissemination of news, letters to the editor, editorial or other comment that are distributed in the ordinary course of business. Now, in 1975, when the legislature adopted House Bill 2, they specifically added the second sentence, the second full provision in 305.0041, the one that says, if the person does not engage in further or other activities that require registration under this chapter and does not represent another person in connection with influencing legislation or administrative action. The fact that the legislature included that provision shows that they recognized that if the exception were as broad as Mr. Nixon claims, then we may as well exempt everyone from the lobby registration requirements. If you're going to have a website that has a section called News, and you're employed by them, it doesn't matter what else you send to the legislature, because you're an employee of a news organization. Clearly, the legislature did not intend for that result in the law. It would be an absurd result, and in effect, the lobby law would, I think there would be a substantial gap created, which the law really does not support. So I would refer you again to the evidence that's before you, the very substantial number of documents, including emails, letters, and memoranda that contain specific directives to vote for and against bills and amendments, as well as vote for and against specific candidates for the speaker election in 2010. And I would also point out that the Attorney General has issued another opinion, and it's actually H583. This was adopted in 1975 in interpretation of the Lobby Control Act. And what they state, this is on page 2, the question was, what is the test for determining whether a salaried individual communicates directly with a member of the legislative or executive branch to influence legislation as a part of his regular employment, as the quoted phrase is used in Section 3B. This is when the law was still in, this was in Article 6252-9C. And I'll point out that the law at the time did not include a compensation threshold. That came later. At this point, there actually was no compensation threshold. And what it says is that the Attorney General responded by stating, "It is our view that a person communicates with a public official or candidate within the scope of his regular employment when the communication is on behalf of and at the express or implied direction of his employer or is ratified by his employer. We do not believe that it is necessary that a specific portion of his salary be allocable to his role of communicating with members of the legislative and executive branches. It is sufficient that he be employed and that he communicate with public officials or candidates to influence legislation as an incident of his employment. Now, this is it's an Attorney General, an opinion from the Texas Attorney General. Again, it's available to provide guidance to the Commission in your application of the law here, and I offer that to you. The standard for the Commission finding a violation in this case is by preponderance of the evidence, which means more likely than not. Is it more likely the case that Mr. Sullivan communicated directly with legislators in 2010 and 2011 for the purpose of influencing legislation on behalf of Empower Texans? And is it more likely than not that he received compensation over $1,000 in a calendar quarter within that time period? And is it also more likely than not that Mr. Sullivan was making those communications as part of his regular employment, or as the Attorney General says, as an incident of his employment, whether at the express or implied direction of his employer or ratified by his employer? I think the evidence in this case is it meets that standard, and that Mr. Sullivan was directly communicating with legislators and their staff in 2010 and 2011 to influence them. He far exceeds the compensation threshold, and that those communications were made as part of his regular employment. Thank you.
You have 5 minutes left for rebuttal. Counsel?
Mr. Chairman, Commissioners, Council, thank you for giving us an opportunity to be heard today. We're grateful for it. We're grateful for the opportunity to be in an open forum. Council used the word transparency, and we're grateful for the opportunity that the evidence regarding these complaints, the witnesses who brought them, how they were collected and made, have now become all transparent for all of Texas to see. Commissioner Ramsey, you were going to ask me a question earlier. Before I get going, I want to give you the opportunity to ask it.
Did you advise your client not to speak, to use the First, Fourth, and 14th Amendment?
Well, that I can't answer, because that requires me to divulge attorney-client privileged information.
So, no one representing Mr. Sullivan would speak to that,
Well,
you know, in that group right there.
That's correct, because we have an opportunity that's zealously guarded in the state to advise our clients without the advice becoming public or subject to cross-examination.
Well, let's get to the heart of the matter. That's a great part of what I said. Why would you be, if we're after facts in this forum, in this setting, why wouldn't you include what facts you have to the process? I mean, we've got no axe to grind, so to speak. I mean, we're not after anybody. We're appointed to uphold the law that was passed by the legislature. And we are here today looking for the answer. But you and your client refuse to help us find the answer. And I'm just curious, because most of the time, all the time, except in those cases, you are pro-transparency. You make eloquent remarks that give me the impression that you're for open government. You're, you know, all those things you're for. And then on the other side of that nickel, you turn around and protect your client by telling him not to help us find the answers. That's my question.
You know, Commissioner Hobby asked the same question in a different way. Why the venom?
Me? No, I don't have any.
I know. No, not you. No, but why, in his opinion? What's the distrust? Is that a fair way to ask your question?
I don't know the answer to that, but let me tell you. This group...
Oh, I'm going to answer your question about why the distrust, if you want to know.
All right.
It goes to the heart of why these complaints were filed. It's a vendetta against somebody who said something that you don't like, and this commission has been used. Those two complainants immediately made their complaints public in contravention of statute and used those public statements to then say that Mr. Sullivan was being investigated. We asked for a speedy trial. We filed an answer and said, we want to have this heard as soon as possible. It was 18 months later before the commission began to do anything. And when it started, it sent us a set of interrogatories asking for our bank accounts. That's not trustworthy behavior. That kind of behavior generates distrust and a desire to be self-protected. When we first came to the original preliminary hearing, I asked that the complainants be subpoenaed. Instead, they were sent letters saying you do not have to show up.
Mr. Nixon, you've answered my question, and I appreciate you answering it. And I just wanted you to think about that question and think about whether you're helping the process or you're hindering it. And that includes the length of time that it's taken to get to this point after these complaints were filed.
Right. Let me go on.
No, you don't have to, not for me.
No, it's very important because the process is now required. We showed up for the preliminary hearing. Your lawyers weren't prepared. They put Michael Sullivan, they were going to have Michael Sullivan come testify. They had no other witnesses and no other documents. None. Not this stack. They didn't have that stack. They just had the complaint. And everybody was surprised and quite frankly angered that Mr. Sullivan wouldn't just come in here and apologize. You, Mr. Ramsey, suggested to us that just pay a $500. Before you heard a bit of evidence, you said pay a $500 fine and we'll just make this go away. At the conclusion of the first preliminary or the second preliminary hearing, where there was not this stack, but just a couple of exhibits attached to the complaints, the chairman says, but when you become the face in front of the person that is saying vote for or against this, now you've crossed the line. And where you're compensated and you commit direct communication, and when you don't meet the exemption, then that's what ends up happening. And so we have a proposed order today that we would ask you to agree to or not agree to by November 1st. When you talk about transparency, the consideration of both sides and all of the facts is not being considered.
That's not true in this case.
Why then were we offered an opportunity to pay a $500 fine before a word was spoken from the witness chair or a document was entered?
Mr. Nixon, I'll answer that. Because that is the law.
Commissioner Ramsey, if you make sure your thing was on. If you have a question for this, this gentleman, you're welcome to ask it.
He's answered my question. Okay. So I'm through.
Mr. Nixon, are we outside the record?
No. members.
Are we outside the record? What exhibit are you referring to with regard to your testimony that you're referring to now?
I'm engaged in argument at this time.
Well, no, you're citing testimony from a transcript. Is that in the record?
I was referring to the transcript that was provided to me of the second preliminary hearing.
And my question to you, sir, is that in the record?
That is not in the record.
Okay.
But in answer
I'd
to
ask you to
Mr.
restrict your remarks to the record before this formal hearing.
And I will quote Mr. Strusloff. This case is about transparency in state government. And you're asking me to restrict my comments. I understand. Now,
Counsel, your sidebar is inappropriate and you know it. That's inappropriate. We have a rule that we're doing here under the Administrative Procedures Act, and you're closing based on evidence that we've had hours and hours to discuss.
close includes the opportunity to argue the law.
Absolutely.
Let's get on to the arguing of the law.
I look forward to it.
Okay. And I would suggest, Mr. Chairman, those kinds of sidebars are inappropriate if you think mine is. So, where are we right now? We have complaints filed as political vendettas and prosecuted as an agent of those who filed the complaint. With a statute that is nearly indecipherable. There's a difference from what you want regulated and what you may constitutionally regulate. And I will cite to you some language from Citizens United that I have not yet read. When government seeks to use its full power, including the criminal law, to command where a person may get his information, his or her information, and what distrusted source he or she may not hear, it uses censorship to control thought. This is unlawful. The First Amendment confirms freedom to think for ourselves. But more importantly, just on April 2nd of this year, the Supreme Court reaffirmed that type of that analysis and that type of thinking and the protection of First Amendment rights for individuals. And I'm going to say something here that I'm going to come back to time and time again. So I want us to all focus on this. Any regulation must instead target what we have called quid pro quo corruption or its appearance. What that means is payment for political favors. That is the only permissible activity of speech that government may regulate. Campaign finance laws or restrictions that pursue other objectives like transparency. We have explained, or fairness, or anything other high, mighty idea, we have explained impermissibly inject government into the debate over who should govern. And those who govern should be the last people to help decide who should govern. Government is the last stop over who should decide. Therefore, when it comes time to regulations of speech and petitioning the government, any regulation involving petitioning the government has a heightened degree of scrutiny. So, let's talk about your burden of proof. You've been told, and the statute reads, that it's by a preponderance of the evidence. But I would assert to you that in this case, that is not the standard. Because this case involves the restriction of First Amendment rights, the standard is strict scrutiny. The standard is that you have to have evidence which is beyond clear and convincing. It has to be very strict and very precise. And you don't have that. You have a chain of custody problem that would get thrown out of any court. And I think that you know that. You have hearsay objections in the documents themselves that make them impermissible. There is a clear way to make a lot of that admitted, but it wasn't utilized by your staff. You're not allowed to cover for them. But what I think, and I'll get to that in a minute, but where we are here is with a strict scrutiny standard. Let's just don't apply that, if that's what you want to do. Well, here's what you're then mandated to do. You're mandated to use a clear and convincing standard, because this is a First Amendment case involving the media. The New York Times versus Sullivan requires that you consider the evidence in this case with a clear and convincing standard. Clear and convincing has not been defined by your chart, but it's well defined in the law. It means the scales of justice are extraordinarily tilted. One touches the bottom and one is on the top. It's clear and convincing, not subject to much dispute. If you want to ignore that and just go on a preponderance of the evidence, what you have is no evidence at all. Now, I know, Mr. Chairman, that you asked a lot of questions designed as a setup to be able to utilize an inference by his failure to answer them. And he didn't use the amendment that you wanted that allowed you to utilize an inference. Therefore, you can draw no inference. But if you ignore that and want to utilize an inference, the inference carries the weight of a feather on the scales of justice. It's less than a scintilla. It's not enough to base any kind of decision. So here we are with no evidence. I am really surprised that counsel for the commission seems to base his entire case on a definition of legislation which he focused on these words: may be the subject of action by either house or a legislative committee. How is anyone to know whether they're allowed to speak on an issue? Something that may come before the House or Senate is defined as legislation? Would any of you like to be subject to a law that broad? Remember, this issue about failing to register doesn't come with a suggested fine of $500. They're criminal sanctions. We talked before about the fact that courts recognize that laws like this result in the gulag or the guillotine. And in Texas, it's the gulag. That's not what free society is about. That's not what free speech is about. That's not what any of the Supreme Court cases have defined and given you direction. This is the first time anybody in the history of the state has challenged in a direct fashion the language of this statute. And it is not enough to say, well, that's just what the legislature wrote. Today, more is demanded of us. Today, we've got to be thoughtful, contemplative. We've got to stand up for what's right. I used the term earlier, and I hope you understand this, Mr. Ramsey, Commissioner Ramsey, that today is a day we stand on a wall between tyranny and freedom. Are we going to be a state where people who say unpopular things are prosecuted for those? There are many, many brave souls who held the butt end of a gun defending the First Amendment. Some here in this room. But holding the butt end of a gun isn't the only way our rights are defended. Sometimes it's by holding the butt end of a pen. We have the right to speak freely, to be free, to challenge government, to challenge authority, to do what I'm doing today on behalf of my client in good faith and apparently unpopular to some of you, to challenge what we know to be wrong. When you have a statute that says you are subject, you must first pay the state a fee of $750, and it matters little if sometimes it's only $150. But you have to pay the state a fee because you might talk to somebody who might consider what you say to be influence on something that might one day be a bill. That's wrong. That is violative of the First Amendment. To require a restriction on speech. Now, you've never heard me say today that lobby activity may not be regulated. It may, just not with this statute. This statute is a poorly drafted statute. People have the right to petition government in the same way they have the right to speak freely. So, when we're here today, we ask ourselves a very important question. Influence. To influence legislation. For whom? Influence is the intent to influence on behalf of the speaker or on behalf of the listener. Can we tell that from the statute? Do we know whose intent to influence legislation? Or are we allowed to prosecute somebody who accidentally influences legislation without intent? You have no evidence that supports anything in that definition. And so the first choice that you should make is to dismiss these complaints, just on a lack of evidence. Transparency in government. I had somebody else fill out the open records request because I didn't want the legislators to know what I was doing. That's very transparent. How about, I never opened any of the mail, so I don't know what's in them. That's real transparent. Or I didn't keep a list, or I didn't have anything to do with it, but oh yeah, he came over and helped me. We assembled everything and made a list. That's real transparent. By the way, don't communicate with anybody about this case while it's going on. Tweet, tweet, tweet. That's real transparent. In order to find Mr. Sullivan liable under the statute, you've got to give credence to that behavior. You've got to say, we like that behavior. That's good for the state of Texas. We can ignore sequestration. We can hide behind our friends. We can avoid transparency. Oh, and the best transparent thing of all, well, I cited under information and belief because I didn't have any personal knowledge of any of it. And I didn't really read it, and by the way, some of the exhibits are incomplete. That's the state's case. Real transparent. The purpose of those complaints was to punish somebody who said something that they didn't like. Vote for another speaker. Even though the speaker's race might or might not have ever occurred, and in this case didn't. So here we go. We have no evidence. Number two, Mr. Sullivan fits into a media exception. I really appreciate Mr. Licheron coming in and telling us, someone with that kind of experience, print media all of his life, has moved over to non-print media, and said, look, bona fide news media is people who deliver news in editorial content in a new way. That's new media. But don't get confused that there's such a thing as old media, because everybody's been doing it the same way for forever. Whether you're a muckraker or a yellow journalist or whether you're Thomas Paine, and you can be an advocate and a journalist and an editorial writer all at the same time, because there aren't any rules. It's free speech, and there's not supposed to be rules. There's not supposed to be guidelines in an organization that you have to be a member of and a test you have to take to pass. You get to say anything you want because you have the right to say it. That's what this is about. And don't think for a second that this is really an exception. Because here's where we are. If you don't have a media exception, statute's invalid on its face. All statutes without a media exception like this are completely invalid. Could you imagine having a lobby statute that required the media to register? Every day when I was a member, I got a copy of the Post, the Chronicle, the Dallas Morning News, the San Antonio Express News, and the Austin American-Statesman for free. And we could log on to Harvey Kronberg's deal later on when that got going and we learned about the internet a little bit for free. They delivered to my office their opinion every day, whether I want to see it or not. And what do all those reporters do? They come in, they ask you questions, they talk to you about stuff. Well, don't you think about this? Don't you think about that? Do you for a second consider that any of these emails are anything other than a new way of reporting and engaging people in conversation for which you can then write about? It's exactly what it is. My kids, you're going to not like to hear this, Mr. Hobby, my kids are never going to subscribe to a newspaper or a magazine. And yet my mom wrote for your family's paper for 7 years. They're never going to subscribe to a paper. That's not where they get their news. That's not where the information director of the state of Texas gets her news. Some from the Statesman. She's all over the internet like everybody else. This is so broadly written that, yeah, I think so many people could fit under that definition that it almost essentially invalidates the rest of the statute in and of itself. Does Michael fit? Absolutely. There's one opinion that when pressed became even more certain. And let's scroll down to the bottom. This phrase, if the person does not engage in further or other activities that require registration, what does that mean? What to the average person does it further? If you can be a member of the media as long as you don't engage in further activity, what does that mean? You're exempt from all lobby registration unless you do something else, but it doesn't define what that other else is. So you had a very frank and honest answer from this witness that said, that doesn't make sense. And he's right. It doesn't make sense. But not only that, it doesn't say or, and it says and does not represent somebody else. So as long as you don't have another lobby client, well, does this mean that Texas, what do you call it, Business Association, Bill Hammond's group, doesn't have to lobby? I don't know what he puts up on the web. I don't know what he does, but it might. That's a problem. And we don't like that. It makes us uncomfortable when we're confronted with reading words that read more than what we want them to read. It makes us uncomfortable. Oh no, this could be a real problem. Well, look, it's okay to have a problem. It's not okay to fail to address it. You got to address your problem. So, so far, right now, the evidence shows two things. One, you don't have any evidence against any regulated activity. And two, it doesn't matter whether you do or you don't, because now Mr. Sullivan's a member of the media. And he has been. He's been always. Oh, was he in 2010, 2011? Yes. Members, commissioners, look at exhibits 83 to 102. Those were the ones that the media consultant from the state testified to. The ethics, the ethics IT lady, Ms. Hogue, said, you know what those are? All of those are web pages from 2010 and 2011. All of those exhibits demonstrate that Empower Texas had a web page that provided news and editorial comment. state's own evidence shows that Mr. Sullivan fit into the media exception. Oh, let's scroll down. Let's scroll back up. The person who owns, publishes, or employs. Oh, guess what? The state, thankfully, provided the 990s, which shows that Mr. Sullivan is an employee of a bona fide news media. Wasn't me. I didn't have to do that. So the state's own evidence demonstrates that Mr. Sullivan is an employee of an entity that is in other bona fide news media. The 990s, exhibits 83 through 102. Now finally, let's talk about whether or not where we are in constitutionality of our entire statute. Forget about the vagueness, forget about the no evidence, forget about the media exception for Mr. Sullivan. If you don't want to find he's a member of the media, here's your problem. Because you've given the media an exception, the fact that you are regulating everybody else is unconstitutional. Because Citizens United, the Supreme Court of the United States, says that the media has no greater rights than the average citizen. So you're in a box with no way out. Now, we had an opportunity to talk to the staff's attorneys, and we told them this. We told them all of this. And we told them more. Don't think for a minute that any email that's addressed to members of the House went only to members of the House. They went to donors. They went to other subscribers.
It's testimony. Nobody said that.
Mr. Hobby, do you not like the facts?
I don't recall any testimony to that fact, so I just want to admonish the other commissioners. That's argument. I heard nothing in the record to indicate what you just tried to put into it.
Right. And it gets back, but you know what? I've told you this before, and I've told you this at prior meetings. This was a big fight about the documents. This is why we went over to federal court. Mr. Sullivan testified, by the way, Mr. Ramsey, Mr. Sullivan testified in front of federal judge Sam Sparks. I called him. I had him testify. He was my first witness. Your commission staff knows all this. And what's shocking, you know it because I've said it to you too, is that all of those emails, anything that got sent to anybody was a blast. If it said, "Dear Cindy," it is individualized and it's a blast to subscribers. And we've gone through and talked about the part of the emails that says, "You want to unsubscribe? Click here."
Where is this record coming from?
Who said that? I said it to you, and I've said it to your staff.
Okay, so let's talk about the evidence that was in the record. Is that in the record?
Yes. Yes.
Is that in the record today?
Yes.
Which witness said that? I want my commission to be clear. Which witness testified about blast emails that you claim were sent?
Did you not know? Did you not hear me say that to you before?
Were you offering testimony today?
This is why I am offering testimony, and here's what it is.
No, counsel, you're offering argument. Was there a witness today who testified to that fact?
I am offering an argument. No, and this was shocking.
You're outside the record. Restrain your argument to the record.
Right.
The evidence that was provided here today.
Mr. Chairman, what is shocking is that commission staff knows facts that it intentionally did not disclose to this commission. It knows facts that it intentionally did not disclose to this commission. It has been discussed in this, before this commission, in prior formal public hearings, as well as in other venues.
Which is
Because-
outside this record.
No, it's not outside this record because the record is the entirety of the record.
No, it's not. Sir, restrict your argument to the evidence that's brought before us today in this formal hearing.
All right. I would like to point out to the commission, particularly in light of that, what's that? Oh, 107, oh, here they are. 107, exhibits 107 and 108, to which we stipulated, are the pleadings in the federal court case that set out those facts. So yes, Commissioner, they are in the record.
The pleadings?
The pleadings. Our
Not the
pleadings.
transcript, the pleadings.
Our pleadings. Verified complaint and application for injunctive relief filed by Empower Texans and Michael Quinn Sullivan. Plaintiff's motion for temporary restraining order in brief in support filed by Empower Texans and Michael Sullivan. There are exhibits 107 and 108 to this hearing. And they set out those facts. So I'm not outside the record.
You're saying that the facts that you recited in a pleading were admitted in evidence in this case?
By your staff.
No, the pleading was.
The pleading was.
Not the fact that's in the pleading.
Well, the fact that those are judicial admissions, and you know that.
By you.
Yes, that's exactly right. I can use evidence submitted by me.
Counsel, you're outside the record.
I appreciate the commissioner's ruling. Which brings me to one last point. Sometimes facts are uncomfortable, sometimes they're stubborn, but they are what they are. But the dissemination of facts in the process of rulings throughout this proceeding from the beginning 28 months ago to today is a problem, is a due process problem. Your ruling a minute ago, you didn't want to recognize what your staff entered into evidence, was what allowed me to make arguments because you weren't comfortable with the arguments. I've made a lot of arguments before this commission that this commission is not comfortable with because it challenges you to be more than just simple. It demands that you be wise. It demands that you do some hard work, demands that you think and you read. This whole situation is a situation, this whole complaint process is a situation that requires more of all of us than maybe some of us are willing to give. But when you look at all the hard facts, when you look at all the hard facts, you realize you don't have any. You got a bad statute and you got a vendetta. It's time to recognize that, dismiss these complaints, do what you need to do with regard to dealing with the unpleasant and inappropriately drafted statute. And then you need to send a message to people who would cause us so much time and trouble and expense and the commission to have to hear the request to please quiet my opponent. Thank you.
Suslos?
I have, is that 5 minutes now? Okay, so I will be brief. Mr. Nixon has asked you to read, and I agree. I ask you to read and focus your attention on the exhibits that are in the books before you, specifically, and most importantly, exhibits 13 to 68. Those are the documents that are most relevant here. Those are the documents that constitute the communications from Mr. Sullivan to legislators and their staff. I do want to point out the comment Mr. Nixon has quoted, "Pay your fine and get on down the road," and I believe on 2 accounts he said that that was from staff. I would like to, for the record, state that that was not a statement that I made.
Is that in the record today?
I'm sorry?
Is that in the record today?
The statement, "Pay your fine and get on down the road," is that what you mean?
Was that in the record
Mr.
today?
Nixon had referred to it a couple of times and attributed it to me.
I let him get
so-
away with it. I'm not
Okay.
going to let you get away with it.
Okay, I just wanted for the record.
Let's talk about today's formal hearing, please.
Okay. As far as the complainants and their motives in filing the complaints, what's relevant here is that they in fact filed them and that the jurisdiction over the complaints was properly accepted. The complaints included a number of documents. They were properly, there was an affidavit that was included with each complaint. The allegations were made on information and belief. The Commission statutes allow a person to file a complaint based on information and belief. They don't need to have personal knowledge of each and every matter that's at issue in the complaint. I would also like to state that with respect to the statutes, the lobby law is not indecipherable. People have been registering with the Commission and our predecessors for decades, and the Texas Attorney General, when they considered House Bill 2 in 1975, they didn't think that the lobby law was indecipherable. They did clarify it. They did make a few suggested changes, but they did not find it indecipherable. And the key language of influencing legislation was reviewed by United States versus Harris again, and the United States Supreme Court did not find that language to be unconstitutionally vague. The standard for considering the evidence in this case, it is not one of strict scrutiny. It may be that a court can apply strict scrutiny when determining whether a statute is constitutional or not. But the issue of whether a statute is constitutional, that decision has to be made. That decision cannot be made by the Commission in this proceeding. The issue is whether there is a preponderance of the evidence that a violation occurred. And to the extent that courts have looked at the Ethics Commission's lobby laws, they have not found them to be infirm on constitutional grounds. The Commission is required to apply the laws as they are written, as well as other state agencies. They're charged with applying the law as they are given to them by the legislature. The definitions of legislation, the standards for the registration requirements are clear. There's nothing in the law indicating that a person, simply by being employed by a news organization, is suddenly exempt under some kind of a blanket from registration requirements. Because an organization, and not to target any organization, but an organization like Exxon, they have a newsletter. And many organizations around the state have newsletters. That does not suddenly mean that anybody who is employed by those organizations is exempt from the lobby law. If they're engaging in additional activities that require them to register, such as specific directed communications to legislators with the intent to influence on behalf of their employers, and they're receiving compensation over the threshold to make those communications, or they're doing it on part of their employment and they're receiving over $1,000 in a quarter in salary, they're required to register. And I ask you to, again, review the evidence that is before you and find by preponderance of the evidence that Mr. Sullivan was required to register in these calendar years and failed to do so. Thank you.
Council, ladies and gentlemen, every Texan, all 26 million of them, has the right to petition, to publicly advocate, and to lobby their government. Every Texan should engage in those behaviors. If they're not paid, they do not need to register. Only some of those who are paid to do that have to register. To be very clear, this hearing and these complaints are not because of matters posted on websites or social media, or communications made to an organization. Merely writing about what is going on in the legislature does not require registration. Merely maintaining a website does not require registration. Merely publishing a rating of how fiscally responsible legislators are does not require registration. Merely writing news and opinions and distributing them in modern press does not require registration. This commission is going to make a decision based on the facts and the law as passed by the legislature. Council, I personally appreciate the constitutional arguments, but I am not aware of any instance where this commission has declared laws passed by the legislature and upheld by the courts as unconstitutional. The law that we're going to apply is from the Government Code, Section 305. I'm sorry, sir, I didn't mean to make you stand. What it says is, any person who receives compensation to communicate directly with one or more members of the legislature, legislative or executive branch, to influence legislation, shall file a written registration, unless an exception applies. Now, as the presiding officer of this hearing, I personally am very troubled by the dozens of letters and emails that were produced pursuant to the open records request, but were not produced responsive to the subpoena. And that means one of two things. Either the subpoena was ignored or the evidence was destroyed. I'm also personally troubled by the assertion of a First Amendment privilege for the refusal to testify. There's 456 district courts in Texas, and every one of them would laugh you out of the courtroom if you made that allegation. Now, simply put, there's nothing wrong with communicating directly with legislators and attempting to influence them on legislative matters. But if you get paid to do that, you have to register. We appreciate the presentations made by both sides today and have listened to the evidence carefully. The Commission will deliberate on what we have heard in the manner provided by law, and we will provide the parties with a final written order promptly. At this time, the Chair will entertain a motion to adjourn. Motion by Commissioner Ramsey, second by Commissioner Aiken. All in favor say aye.
Aye.
This concludes the formal hearing and the taking of evidence.